Παρακαλώ πάρτε θέσεις. Αρχίσουμε σιγά σιγά. Νομίζω το ακαδημαϊκό τέταρτο έχει περάσει. Και έχουμε ένα ιδιαίτερα βαρύ πρόγραμμα σήμερα. Καταρχάς, καλημέρα. Σας ευχαριστούμε πάρα πολύ που είστε εδώ σήμερα μαζί μας για να γιορτάσουμε τα 30 χρόνια λειτουργίας του ΟΠΗ. Χαιρόμαστε ιδιαίτερα που ερχόμαστε αυτή την επιστημονική γιορτή. Θα ξεκινήσουμε κατευθείαν με τους απαραίτητους χαιρετισμούς. Η κυρία Υπουργός δυστυχώς δεν μπόρεσε να είναι μαζί μας, ωστόσο μας έστειλε ένα μαγνητοσκοπημένο μήνυμα, το οποίο θα παρακολουθήσουμε μαζί και στη συνέχεια θα ακολουθήσουν οι υπόλοιπες ομιλίες, σύντομες ομιλίες και χαιρετισμοί. Αν είμαστε έτοιμοι, παρακαλώ, να δείξουμε το μήνυμα. Ευχαριστώ.
Αξιότιμη κυρία Γενική Διευθύντρια του ΓΟΥΙΠΟ, αξιότιμη κυρία Πρόεδρε του Οργανισμού Πνευματικής Ιδιοκτησίας, κυρίες και κύριοι, είναι ιδιαίτερη χαρά και τιμή να απευθύνομαι σε εσάς, χαιρετίζοντας την έναρξη του σημερινού συνεδρίου σας. Ενός συνεδρίου που είναι ιδιαίτερα σημαντικό, όχι μόνο για τη θεματολογία του και τους υψηλόβαθμους διεθνείς προσκεκλημένους και ομιλητές, αλλά κυρίως για το λόγο της διοργάνωσής του, ο οποίος είναι ο εορτασμός των 30 χρόνων λειτουργίας του Οργανισμού Πνευματικής Ιδιοκτησίας. Σε αυτά τα 30 χρόνια λειτουργίας του, ο Οργανισμός Πνευματικής Ιδιοκτησίας, ο ΟΠΗ, έχει προσφέρει πολλά μέσα από πολλαπλούς ρόλους και αρμοδιότητες. Θα σταθώ σε ορισμένα μόνο από αυτά, αναγνωρίζοντας ότι η ιστορική αποτύπωση του συνολικού έργου του οργανισμού υπερβαίνει κατά πολύ τα όρια αυτού του χαιρετισμού. Καταρχάς, ο Οργανισμός Πνευματικής Ιδιοκτησίας έχει συνδράμει στις νομοπαρασκευαστικές εργασίες για τη ρύθμιση πληθώρας θεμάτων πνευματικής ιδιοκτησίας. Η επιστημονική εξειδίκευση και η κατάρτιση των στελεχών του οργανισμού έχει επιτρέψει την εύστοχη και αποτελεσματική επικαιροποίηση των σχετικών διατάξεων, δεδομένου ότι η πνευματική ιδιοκτησία είναι ένα δίκαιο που διαρκώς εξελίσσεται και που συνδέεται στενά με τις τεχνολογικές εξελίξεις και προκλήσεις, οι οποίες πολλές φορές απειλούν την προστασία των δημιουργών και των δικαιούχων των συγγενικών δικαιωμάτων. Παράλληλα, η αποτελεσματική εποπτεία των οργανισμών συλλογικής διαχείρισης των πνευματικών και συγγενικών δικαιωμάτων έχει διασφαλίσει με τη συνδρομή του Οργανισμού Πνευματικής Ιδιοκτησίας την εύρυθμη λειτουργία της αγοράς, η οποία με τη σειρά της επιτρέπει την ανάπτυξη και την προαγωγή της καλλιτεχνικής δημιουργίας. Ιδιαίτερα σημαντικό είναι και το έργο του οργανισμού στη διάχυση της γνώσης για την προστασία της πνευματικής ιδιοκτησίας. Μέσα από την επιμόρφωση και την ενημέρωση, τόσο των επαγγελματιών όσο και των μαθητών, των φοιτητών, των σπουδαστών, εδραιώνεται στη χώρα μας η κουλτούρα σεβασμού της πνευματικής ιδιοκτησίας και των συγγενικών δικαιωμάτων. Τέλος, θα σταθώ στη λειτουργία στους κόλπους του ΟΠΗ της Επιτροπής για τη γνωστοποίηση της διαδικτυακής προσβολής δικαιωμάτων πνευματικής ιδιοκτησίας και συγγενικών δικαιωμάτων. Η Επιτροπή, με την επιβολή του Dynamic Blocking, έχει ενισχύσει αποτελεσματικά την προστασία των πνευματικών και των συγγενικών δικαιωμάτων στο επιγραμμικό περιβάλλον. Η Επιτροπή αυτή, από τη σύστασή της το 2018, μέχρι σήμερα έχει εκδώσει περισσότερες από 300 αποφάσεις και έχει διακόψει την πρόσβαση σε πολλές εκατοντάδες παράνομους ιστότοπους που παραβιάζουν δικαιώματα πνευματικής ιδιοκτησίας. Όλα τα παραπάνω δεν είναι απλώς αριθμοί. Αυτοί οι αριθμοί μετουσιώνουν το έργο και την προσπάθεια συγκεκριμένων προσώπων, των επιστημονικών και των διοικητικών στελεχών του Οργανισμού Πνευματικής Ιδιοκτησίας, των διευθυντών, των προέδρων και των διοικήσεών του, που παρά τις κατασκαιρούς αντιξοότητες βρίσκουν τις διόδους για να διατηρήσουν ενεργό το ρόλο του οργανισμού, αλλά και ζωντανό το δημόσιο διάλογο για θέματα πνευματικής ιδιοκτησίας, ο οποίος αποβαίνει συνολικά προς όφελος της προστασίας της πνευματικής ιδιοκτησίας και των συγγενικών δικαιωμάτων. Δράτω με τις ευκαιρίες αυτής να επιβεβαιώσω για άλλη μια φορά ότι το Υπουργείο Πολιτισμού δίνει ιδιαίτερη βαρύτητα στην προστασία της πνευματικής ιδιοκτησίας. Για το Υπουργείο Πολιτισμού, η πνευματική ιδιοκτησία και η προστασία της έχει κεφαλαιώδη σημασία για την ανάπτυξη της δημιουργικότητας και του σύγχρονου πολιτισμού μας, της σύγχρονης πολιτιστικής δημιουργίας. Στο πλαίσιο αυτό, σχεδιάζουμε την αναδιοργάνωση του ΟΠΗ με σκοπό την ενίσχυσή του σε επίπεδο οργανωτικής δομής, προσωπικού και μέσων, ώστε να μπορεί να ανταποκριθεί το καλύτερο δυνατόν στις σύγχρονες απαιτήσεις και τις προκλήσεις που τίθενται στο παγκόσμιο οικοσύστημα της πνευματικής ιδιοκτησίας. Αναγνωρίζοντας το πολύτιμο έργο που έχει προσφέρει μέχρι σήμερα ο οργανισμός, αλλά και με ισχυρή την πεποίθηση και τη βούληση για την αναδιοργάνωση και την ενίσχυσή του, ως εγγύηση μιας επιτυχούς πορείας στο μέλλον, εύχομαι κάθε επιτυχία στις εργασίες του συνεδρίου σας, προσβλέποντας στα συμπεράσματά σας. Σας ευχαριστώ.
Ευχαριστούμε πολύ την κυρία Μενδώνη για το μήνυμα και επίσης για το μήνυμα που έστειλε όσον αφορά την αναδιοργάνωση του οργανισμού. Προσβλέπουμε σε αυτό. Το λόγο έχει ο Υφυπουργός του Σύγχρονου Πολιτισμού, ο κύριος Fotylas.
Καλημέρα σε όλους και από μένα. Αξιότιμοι προσκεκλημένοι, αγαπητοί συνάδελφοι, και δεν αναφέρομαι στην πολιτική μου ιδιότητα, αναφέρομαι στη νομική μου ιδιότητα. Κυρίες και κύριοι, καταρχάς σας ευχαριστώ θερμά για την πρόσκληση να συμμετάσχω στο συνέδριο του οργανισμού σας με αφορμή τη συμπλήρωση των 30 χρόνων μιας δημιουργικής σίγουρα πορείας. Και μπορεί να με προσκαλέσατε με την ιδιότητα του Υφυπουργού, αλλά όπως είπα και πριν, ο νομικός μου εαυτός έρχεται πάντα μαζί μου. Και το λέω αυτό γιατί ζούμε σε μια εποχή πράγματι που η τεχνολογία μοιάζει να τρέχει με ταχύτητα φωτός και εμείς να τρέχουμε από πίσω κρατώντας σφιχτά τα νομικά μας βιβλία. Και δύο είναι τα στοιχεία. Ότι στο σύγχρονο τεχνολογικό περιβάλλον η διακίνηση και η διάδοση των πνευματικών έργων γίνεται ακαριαία και σε παγκόσμια κλίμακα. Από την άλλη έχει σχεδόν ολοκληρωτικά επικρατήσει το άειλο ως φορέας των πνευματικών έργων. Από αυτά λοιπόν τα δύο στοιχεία κυρίως έχει παγιωθεί προπολού ένα τοπίο στο οποίο από τη μία οργιάζει η πειρατεία και η ανεξέλεγκτη καταχρηστική διακίνηση πνευματικών έργων και από την άλλη κράτη και οργανισμοί αμήνονται ακολουθώντας κατά πόδας τους κάθε λογής λογοκλόπους και καπηλευτές, εξυγχρονίζοντας διαρκώς τις μεθόδους και τα μέσα αντιμετώπισης του φαινομένου. Σχεδόν πάντα είμαστε λίγο πιο πίσω, αλλά νομίζω ότι τουλάχιστον τρέχουμε κι εμείς. Ταυτόχρονα η τεχνητή νοημοσύνη αναδύεται ως μια νέα κυριαρχική δύναμη με απρόβλεπτη επιρροή στον τομέα της δημιουργίας, αλλά δυστυχώς και της καπηλείας. Αντιλαμβανόμαστε λοιπόν όλοι ότι η ανάγκη προάσπισης της πνευματικής ιδιοκτησίας με ένα σύγχρονο τρόπο είναι επιτακτική. Πρόσφατα, πριν από λίγες μέρες, νομοθετήσαμε στη Βουλή ένα νόμο πλέον του κράτους, όπου ψηφίσαμε διατάξεις ύστερα από διαβούλευση με όλους τους εμπλεκόμενους και ενδιαφερόμενους φορείς, τον ΟΠΗ, τους οργανισμούς συλλογικής διαχείρισης, τους παρόχους, τους παραγωγούς, γιατί και αυτοί ενδιαφέρονται για την κατάσταση, και μπορώ να πω πως φέραμε διατάξεις που επιλύουν σε έναν βαθμό ορισμένα από τα ζητήματα της πνευματικής ιδιοκτησίας και εξυγχρονίζουν το νομικό πλαίσιο, συμβάλλοντας ουσιαστικά στην προστασία των δημιουργών. Θα μου επιτρέψετε να αναφέρω έτσι επιγραμματικά διατάξεις οι οποίες έρχονται καταρχάς να βελτιώσουν και να καταστήσουν ένα ήδη νομοθετημένο εργαλείο, όπως είναι αυτό του δυναμικού αποκλεισμού, το blocking, dynamic blocking, να το καταστήσουν ισχυρότερο και ικανό να ανταποκρίνεται στην αμεσότερη και αποτελεσματικότερη αντιμετώπιση του διαρκώς εξελισσόμενου φαινομένου της πειρατείας του διαδικτύου. Ένα εργαλείο με σκοπό να προλάβει, να εξουδετερώσει τις νέες τεχνικές που συνεχώς βρίσκουν όλοι αυτοί οι επιτίδιοι προκειμένου να πλήξουν τα δικαιώματα των δημιουργών, τα συγγενικά, όλα τα δικαιώματα πνευματικής ιδιοκτησίας. Βέβαια νομοθετούμε πάντα με σεβασμό στα δικαιώματα όλων των μερών. Να το κάνουμε ξεκάθαρο αυτό. Και το εργαλείο αυτό του δυναμικού αποκλεισμού, το dynamic blocking, πλέον με την καινούργια νομοθετική διάταξη μπορεί να εφαρμοστεί και θα εφαρμόζεται όχι μόνο σε γεγονότα και αθλητικές εκδηλώσεις που μεταδίδονται ζωντανά, δηλαδή ταυτόχρονα με τη διενέργειά τους, αλλά γενικότερα σε οπτικοακουστικά έργα, ταινίες, σειρές. Επίσης, νομοθετήσαμε διατάξεις την προηγούμενη εβδομάδα, πριν 2 εβδομάδες, που ισχυροποιούν και καθιστούν πιο άμεσες και ευέλικτες όλες τις διαδικασίες, ώστε ο ΟΠΗ να μπορεί να εξετάζει όλες τις γνωστοποιήσεις των ενδεχόμενων παραβιάσεων, χωρίς την υποχρεωτική παρέμβαση που ήταν μέχρι σήμερα του Υπουργείου Πολιτισμού. Έτσι εξασφαλίζεται η ταχύτερη εξέταση των επικαλούμενων παραβιάσεων. Επίσης νομοθετήσαμε διάταξη δια της οποίας ο ΟΠΗ καθίσταται πλέον η μόνη αρμόδια αρχή για τη διενέργεια της έρευνας τυχόν παραβιάσεων και μόνο σε περίπτωση που ο ίδιος ο ΟΠΗ θεωρήσει ότι είναι αναγκαίο θα μπαίνουν στη διαδικασία της έρευνας και άλλα ελεγκτικά όργανα, ανεξάρτητοι λογιστές ή άλλοι οργανισμοί. Και τέλος, νομοθετήσαμε για πρώτη φορά διοικητική παράβαση, όχι μόνο σε όσους πουλούν παράνομο λογισμικό, παράνομες συνδέσεις, παράνομες συνδρομές, αλλά και σε αυτούς που τις αγοράζουν. Διότι μέχρι σήμερα αυτός που αγόραζε μια παράνομη σύνδεση δεν είχε καμία επίπτωση. Κατηγορηθήκαμε, θα έλεγα, από μια μερίδα πολιτικών δυνάμεων, κοινοβουλευτικές δυνάμεις, ότι πάλι εξυπηρετούμε το κεφάλαιο και τιμωρούμε τον κακομοίρη τον Έλληνα που πήγε να πάρει φτηνά μια σύνδεση σε ένα συνδρομητικό κανάλι. Δεν είναι έτσι όμως. Ξέρετε, το ταγκό θέλει 2. Αν δεν υπήρχαν εκείνοι που αγόραζαν αυτά τα προϊόντα, δεν θα είχαν λόγο ύπαρξης και εκείνοι που τα πουλούν. Άρα δεν είναι άμυροι ευθυνών. Να το ξεκαθαρίσουμε. Σήμερα που μιλάμε στην Ελλάδα, πάνω από 900.000 παράνομες συνδέσεις κλέβουν περί τα 150 εκατομμύρια από τους παρόχους και περί τα 35 εκατομμύρια το χρόνο από το κράτος. Και εμείς θα λέμε ότι αυτοί δεν πρέπει και δεν έχουν κανένα μερίδιο ευθύνης. Να είμαστε λοιπόν λίγο σοβαροί. Και βέβαια δεν τελειώνει εδώ η δουλειά. Θα φέρουμε και άλλες διατάξεις και έχουμε δρόμο να διανύσουμε ως την επίτευξη μιας ιδανικής συνθήκης, όσο ιδανική μπορεί να είναι, όπου τα δικαιώματα των δημιουργών θα είναι απόλυτα σεβαστά και προστατευμένα. Το σημερινό συνέδριο είναι μια άριστη ευκαιρία ουσιαστικού προβληματισμού για τα ζητήματα αυτά, με τη συμβολή εξέχοντων πανεπιστημιακών και ειδικών από την Ελλάδα, ειδικών από το εξωτερικό, φορείς, αλλά και από την ίδια την αγορά. Και ασφαλώς είναι μια ευκαιρία και για εμάς να εμπλουτίσουμε τις σκέψεις και την θεματολογία μας, ώστε να μπορούμε να γίνουμε ακόμα πιο παρεμβατικοί, ακόμα πιο αποτελεσματικοί, εν τέλει ακόμα πιο ωφέλιμοι. Αυτή είναι η εντολή άλλωστε του Πρωθυπουργού μας, του Κυριάκου Μητσοτάκη, να προχωρήσουμε με γενναία μεταρρυθμιστικά βήματα, θεσπίζοντας πλαίσιο και κανόνες που προστατεύουν τους δημιουργούς, αλλά και όλους τους πολίτες. Κυρίες και κύριοι, κλείνοντας, το πνευματικό δημιούργημα είναι απαστράπτον και διάφανο και μέσα στην καθαρότητά του, στη διαφάνειά του, κλείνει όλη τη δύναμη του κόσμου και έχει τη δύναμη να αλλάξει τον κόσμο. Το πνευματικό δημιούργημα είναι διάφανο και συχνά είναι άειλο. Είτε γιατί είναι ένα έργο λόγου, μια ιδέα, μια αντίληψη, μια σύλληψη ή ακόμα γιατί συχνά έχει τη φύση πλέον του ψηφιακού, που είναι ένας τρόπος του άειλου. Και επειδή είναι άειλο, είναι ανυπεράσπιστο, γιατί είναι επιδεκτικό υφαρπαγής. Όλοι λοιπόν εμείς, εσείς και εμείς, είμαστε εδώ για να το υπερασπιστούμε. Με όλους τους τρόπους και για όλους τους λόγους. Το Υπουργείο, πάντα υπό την καθοδήγηση της Υπουργός μας, της Λίνας Μενδόνη, θα είναι στο πλάι σας. Έχουμε πολλά να κάνουμε. Άλλωστε, μιλάμε για μια κατάσταση τόσο δυναμική που δεν μπορείς ποτέ να ξεκουραστείς, ούτε να πεις ότι έχεις κάνει εκείνο που πρέπει, γιατί πάντα πρέπει να πας στο παρακάτω βήμα. Και βέβαια, δεν είμαστε μόνο εμείς. Είμαστε μια ευρωπαϊκή οικογένεια και μαζί πρέπει να υπερασπιστούμε τα δικαιώματα των δημιουργών προς όφελος όλων των Ευρωπαίων πολιτών. Σας ευχαριστώ πάρα πολύ.
Σας ευχαριστούμε πολύ, κύριε Υφυπουργέ. Το λόγο τώρα έχει ο πρόεδρος του Οργανισμού Πνευματικής Ιδιοκτησίας, ο κύριος Παναγιώτης Tsiris.
Ευχαριστώ πολύ. Αξιότιμη κύριε Υφυπουργέ, αξιότιμη κυρία Αναπληρώτρια, Γενική Διευθύντρια του ΓΟΑΙΠΟ, κυρίες και κύριοι. Είναι ιδιαίτερη χαρά μου να σας καλωσορίζω σήμερα στο Διεθνές Συνέδριο του Οργανισμού Πνευματικής Ιδιοκτησίας για τον εορτασμό των 30 χρόνων λειτουργίας του. Από το 1994 μέχρι σήμερα, ο ΟΠΗ επιτελεί εξαιρετικά σημαντικό και πλούσιο έργο. Ο ΟΠΗ είναι ο βασικός πυλώνας της προστασίας της πνευματικής ιδιοκτησίας και των συγγενικών δικαιωμάτων στη χώρα μας. Έχει αναπτύξει πλούσιο νομοπαρασκευαστικό έργο, συμμετέχοντας έτσι σημαντικά στη διαμόρφωση της εθνικής μας νομοθεσίας σχετικά με την προστασία της πνευματικής ιδιοκτησίας. Ως η μόνη αρμόδια αρχή για την πνευματική ιδιοκτησία στη χώρα μας, ο ΟΠΗ βρίσκεται σε επαφή με όλες τις ομόλογες αρχές και ανταλλάσσει απόψεις και βέλτιστες πρακτικές για κάθε ζήτημα που αναφύεται, εξασφαλίζοντας έτσι την διασυνοριακή συνεργασία της χώρας μας στον τομέα αυτό. Εκπροσωπεί τη χώρα μας στον Παγκόσμιο Οργανισμό Διανοητικής Ιδιοκτησίας, στις συνεδριάσεις του Ευρωπαϊκού Συμβουλίου, στο Ευρωπαϊκό Γραφείο Διανοητικής Ιδιοκτησίας και σε κάθε φορέα και φόρουμ που αφορά στην πνευματική ιδιοκτησία και το συγγενικό δικαίωμα. Είναι ακόμη κέριος πυλώνας της λειτουργίας και του καθημερινού έργου του ΟΠΗ είναι η εποπτεία του συστήματος συλλογικής διαχείρισης στη χώρα μας, συνεπικουρώντας με τον τρόπο αυτό το Υπουργείο Πολιτισμού. Ο νόμος 4481 του 1997 αναδιαμόρφωσε εκ θεμελίων το πεδίο συλλογικής διαχείρισης δικαιωμάτων στην Ελλάδα. Η θέσπιση του παραπάνω νόμου δεν άλλαξε μόνο τη φυσιογνωμία του εν λόγω τομέα στη χώρα μας, αλλά στην ουσία αναδιαμόρφωσε τον χαρακτήρα και τον ρόλο του οποίου με πληθώρα νέων αρμοδιοτήτων. Το παρόν Διοικητικό Συμβούλιο, του οποίου έχω την τιμή να είμαι πρόεδρος, κλήθηκε να διαχειριστεί εξαιρετικά δύσκολες και νομικά περίπλοκες καταστάσεις, όπως την αδειοδότηση της ΕΔΕΜ, την εποπτεία της ΕΙΕΔ και τη μεταφορά της περιουσίας της τελευταίας. Αποφάσεις του Διοικητικού Συμβουλίου του ΟΠΗ που επικυρώθηκαν με αποφάσεις του Συμβουλίου της Επικρατείας. Τα τελευταία 2,5 χρόνια καταφέραμε να λύσουμε τον χρόνιο γόρδιο δεσμό της οριστικής κατανομής των ποσοστών των εσόδων της ιδιωτικής αναπαραγωγής στους αρμόδιους οργανισμούς. Έτσι, αφού εξαντλήσαμε κάθε περιθώριο και αφού λάβαμε υπόψη ένα τεράστιο όγκο αντιφατικών απόψεων, στοιχείων και δεδομένων, ο οποίος εξέδωσε 3 αποφάσεις επιλύοντας αυτό το ζήτημα στο πλαίσιο των αρμοδιοτήτων του. Και αυτή η κρίση μας επικυρώθηκε από το Συμβούλιο της Επικρατείας. Κεντρικό σημείο στο πολυδιάστατο έργο του ΟΠΗ αποτελεί και η εκπαιδευτική δραστηριότητά του. Ο ΟΠΗ εδραίωσε και εφαρμόζει στην πράξη τόσο το εκπαιδευτικό εργαστήρι του, όσο και το εγκεκριμένο από το Υπουργείο Παιδείας εκπαιδευτικό του πρόγραμμα που απευθύνεται σε όλη την εκπαιδευτική κοινότητα, αλλά και σε μαθητές κάθε ηλικίας, τόσο στην πρωτοβάθμια όσο και στη δευτεροβάθμια εκπαίδευση. Με στοχευμένα προγράμματα, ο ΟΠΗ ήταν και παραμένει πάντα ανοιχτός, παρά τον όγκο και την πληθώρα των αρμοδιοτήτων του, στη διάδοση της κουλτούρας του σεβασμού, στο δικαίωμα και στη χρήση νόμιμου περιεχομένου από νόμιμες πηγές. Έτσι έχει επιτευχθεί μία μοναδική συνύπαρξη με την εκπαιδευτική κοινότητα από άκρου σ' άκρη της Ελλάδας, την οποία στηρίζουμε καθημερινά με όλα αυτά τα προγράμματα και τις εκπαιδευτικές επισκέψεις, αλλά και τη δημιουργία και δωρεάν παροχή εξαιρετικού υλικού για να γνωρίσουν οι νέοι μας την πνευματική ιδιοκτησία και οι δάσκαλοι και οι καθηγητές να μεταλαμπαδεύσουν τη γνώση αυτή σε κάθε νέα γενιά. Εδώ θα πρέπει εντελώς συνοπτικά να επισημάνω το εξέχουσα σημασίας έργο του ΟΠΗ στην καταπολέμηση της διαδικτυακής πειρατείας. Ο ΟΠΗ είχε ήδη προετών συστήσει και διατηρεί ακόμα στη διαρκώς επικαιροποιημένη ιστοσελίδα του Παρατηρητηρίου για την Πειρατεία, συγκεντρώνοντας όλες τις απαραίτητες πληροφορίες. Η σύσταση της Τριμελούς Διοικητικής Επιτροπής για την πάταξη του φαινομένου, της γνωστής σε όλους ΕΔΠ, συνέβαλε από το 2018 αποφασιστικά στην άμεση αντιμετώπιση της πειρατείας, αλλά και στη διαγραφή της χώρας μας από τη λίστα 301 του Επιμελητηρίου των ΗΠΑ, αφού αποστέλουμε κάθε χρόνο εξαιρετικά αναλυτικές και εκτεταμένες συμβολές αναδεικνύοντας το έργο μας. Το 2021, ο Εθνικός Νομοθέτης, με τη συμβολή του ΟΠΗ, προηγήθηκε του ενωσιακού και διεύρυνε την αρμοδιότητα της ΕΔΠ, ώστε να συμπεριλάβει και τα γεγονότα που μεταδίδονται ταυτόχρονα με τη διενέργειά τους, ιδίως τα αθλητικά γεγονότα. Αυτό σήμανε ταυτόχρονα τη διόγκωση του έργου της Επιτροπής σε τρομακτικό βαθμό, αλλά και τη μεγάλη επιτυχία της. Ενδεικτικά θα αναφέρω, όπως ακούσαμε, ότι μόνο το 2024 διεκπεραιώσαμε και εκδώσαμε σχεδόν 300 αποφάσεις, διατάσσοντας τη διακοπή πρόσβασης σε χιλιάδες συνολικά παράνομες διαδικτυακές τοποθεσίες. Παράλληλα, έπειτα από τη σχετική σύσταση της Ευρωπαϊκής Επιτροπής, ο ΟΠΗ συμμετέχει στο δίκτυο των διοικητικών αρχών για την καταπολέμηση της πειρατείας του EUIPO, θα πρέπει να επισημάνω ότι ο ΟΠΗ έχει αναδείξει την Ελλάδα ως ένα κέριο συνομιλητή και στο συγκεκριμένο δίκτυο, με την ΕΔΠ να αποτελεί μοντέλο πρότυπο για άλλα κράτη-μέλη, αλλά και παράδειγμα προς μίμηση. Συμμετέχουμε δυναμικά σε κάθε συνεδρίαση και καθημερινά ανταλλάσσουμε στοιχεία, απόψεις και βέλτιστες πρακτικές, επιτυγχάνοντας τη διασυνοριακή συνεργασία που επιθυμεί τόσο η ελληνική πολιτεία όσο και η Ευρωπαϊκή Ένωση. Τα τελευταία 2,5 χρόνια ο ΟΠΗ έχει αναπτύξει μια δυναμική πολιτική εξωστρέφειας, διευρύνοντας τη συνεργασία μας στην Ελλάδα και το εξωτερικό. Υπογράψαμε μνημόνιο συνεργασίας με τον Παγκόσμιο Οργανισμό Διανοητικής Ιδιοκτησίας στο πλαίσιο της καταπολέμησης της πειρατείας, με τη νομική σχολή του Εθνικού και Καποδιστριακού Πανεπιστημίου Αθηνών, συνδιοργανώνοντας επιστημονικές εκδηλώσεις και ημερίδες. Καρπός του μνημονίου με τη νομική σχολή ήταν και η έκδοση του συλλογικού τόμου με την κατάρθρο ερμηνεία των νέων διατάξεων του νόμου 4181, ερμηνεία των ρυθμίσεων των νόμων 4961 του 22 και 4996 του 22. Μνημόνια συνεργασίας υπογράψαμε επίσης με την Εθνική Σχολή Δικαστών, τον ΟΒΗ, ενώ επίκειται και η υπογραφή μνημονίου με το Πάντειο Πανεπιστήμιο. Ταυτόχρονα διεκπεραιώνουμε και τις λοιπές αρμοδιότητές μας, όπως διερεύνηση καταγγελιών και υποβοήθηση κοινοβουλευτικών ελέγχων, καθώς και την εξαιρετικά σημαντική ηλεκτρονική υπηρεσία χρόνοσήμασης έργων που εφαρμόζουμε για την υποβοήθηση των δημιουργών. Τέλος, ο οποίος βρίσκεται σε καθημερινή επικοινωνία με πολίτες, δημιουργούς, νομικούς και κάθε ενδιαφερόμενο και απαντά σε πληθώρα ερωτημάτων, αναλύοντας το σχετικό νομοθετικό πλαίσιο, επιτυχάνοντας έτσι την άμεση επαφή με το κοινό. Το πολυδιάστατο αυτό έργο του ΟΠΗ δεν θα ήταν δυνατό να επιτευχθεί χωρίς τη συγκινητική συμβολή των λιγοστών υπαλλήλων του και των εξωτερικών συνεργατών του που επέδειξαν πίστη και αφοσίωση στο έργο του. Σημαντική συμβολή στη διαμόρφωση της φυσιογνωμίας του ΟΠΗ είχαν και οι διακεκριμένες προσωπικότητες που διετέλεσαν πρόεδροι και μέλη του Διοικητικού Συμβουλίου αυτού, καθώς και διευθυντές του. Σήμερα γιορτάζουμε τα 30 χρόνια λειτουργίας του ΟΠΗ και τιμούμε όλους όσους συνετέλεσαν στην ευόδοση της αποστολής του. Ο ΟΠΗ αποτελεί τον αμερόληπτο και αντικειμενικό πυλώνα προστασίας της πνευματικής ιδιοκτησίας και των συγγενικών δικαιωμάτων στη χώρα μας, δίνοντας καθημερινά δυναμικό παρόν σε κάθε τομέα του δικαίου, της προστασίας αλλά και της επιβολής. Ευχαριστίες πολλές στην αξιότιμη κυρία Υπουργό για τη συνεργασία μας όλα αυτά τα χρόνια και στον αξιότιμο κύριο Υφυπουργό που είναι σήμερα μαζί μας, αλλά και σε όλα τα στελέχη του Υπουργείου Πολιτισμού για την αγαστή συνεργασία μας. Ακόμη θα ήθελα να ευχαριστήσω την αναπληρώτρια διευθύντρια κυρία Μαρία Δάφνη Παπαδοπούλου για τη διοργάνωση της σημερινής ημερίδας και τους διακεκριμένους ομιλητές που ανταποκρίθηκαν στο κάλεσμά μας και είναι εδώ σήμερα για να μας παρουσιάσουν τις σημαντικότερες πτυχές του δικαίου πνευματικής ιδιοκτησίας και ιδίως τα κέρια ζητήματα που απασχολούν αυτήν την εποχή τόσο την ελληνική όσο και την ευρωπαϊκή και διεθνή κοινότητα. Τέλος, ευχαριστώ όλες και όλους εσάς που είστε σήμερα μαζί μας και συμμετέχετε στον εορτασμό του ΟΠΗ. Ευχαριστώ πολύ.
Σας ευχαριστούμε πολύ. Τώρα πρέπει να κάνω κι εγώ ένα χαιρετισμό. Μια μικρή εξομολόγηση. Δεν έχω ετοιμάσει χαιρετισμό. Χθες το βράδυ έγραψα 2 λόγια. Πρώτον κύριον τα είπε όλα ο κύριος Πρόεδρος τόσο γλαφυρά. Οπότε από εμένα θα ήθελα να πω ένα μεγάλο ευχαριστώ σε όλους όσοι είσαστε εδώ πέρα για να γιορτάσετε μαζί μας τα 30 χρόνια λειτουργίας του ΟΠΗ. Ένα μεγάλο ευχαριστώ στους συναδέλφους του ΟΠΗ που βάζουν πλάτη και μπορούμε να κάνουμε όλα αυτά που κάνουμε, όλες αυτές τις δράσεις και τις πρωτοβουλίες και ό,τι λέμε βάζουν πλάτη και το υλοποιούμε, γιατί χωρίς αυτούς δεν θα μπορούσαμε να τα κάνουμε όλα αυτά. Ένα μεγάλο ευχαριστώ λοιπόν στη Μαρία Συνανίδου. Τώρα συγκινούμε, είμαστε 20 χρόνια μαζί. Στην Εύα τη Μουστάκα, στην Εύα την Κοκκίνου, την Μαρία τη Ράπτη, τον Νίκο το Σταυρόπουλο, τον Γιάννη τον Αναγνωστόπουλο, τη Χρυσούλα τη Σαλάτα, τη Γεωργία την Πραγκαστή και τη Μαρία τη Μαϊμάρογλου, που είμαστε το δυναμικό του ΟΠΗ, που είμαστε λίγοι, αλλά ειλικρινά δουλεύουμε σαν να είμαστε πολύ περισσότεροι, γιατί νομίζω είμαστε μια έτσι δεμένη ομάδα. Ένα ευχαριστώ επίσης στο Διοικητικό Συμβούλιο και στον Πρόεδρο του ΟΠΗ, γιατί μας στηρίζουν σε όλες τις δράσεις και πολλές αφιερώνουν πολύ χρόνο και ενέργεια, πολλές φορές τα δυσεπίλητα θέματα του ΟΠΗ. Και ήθελα να πω 30 χρόνια ΟΠΗ, 30 χρόνια επιτυχίες, βέβαια όχι πάντα, αλλά σίγουρα όταν ξεκίνησα στον οργανισμό, που από τα 30 χρόνια, 20 χρόνια είμαι κομμάτι του ΟΠΗ, μαζί με την Μαρία τη Συνανίδου. Τώρα δεν ξέρω γιατί συγκινούμε. Σίγουρα δεν φανταζόμουν ότι αυτός ο χώρος θα είχε τόση δράση, τόση ένταση, τόσες συγκρούσεις, τόσο πάθη, τόσες επιστημονικές ανησυχίες και προβληματισμούς και τόση βαθιά ικανοποίηση έχω λάβει από αυτόν τον οργανισμό και από την ανασχόληση με την πνευματική ιδιοκτησία. Το σίγουρο είναι ότι δεν βαρεθήκαμε ποτέ. Και ο ΟΠΗ, από ένα μικρός οργανισμός που ξεκίνησε σε ένα μικρό γραφείο στην Ευρυπίδου, με την κυρία Καλλινίκου και 2 υπαλλήλους, η οποία μία εξακολουθεί να βρίσκεται στον ΟΠΗ. Νομίζω ότι αξίζει το χρυσό κλειδί του ΟΠΗ, στην Εύα την Κοκκίνου, 30 χρόνια στον ΟΠΗ. Συγγνώμη, σε δίνω Εύα για την ηλικία, αλλά πρέπει να σημειωθεί σε 30 χρόνια στον οργανισμό. Μεγάλωσε. Βέβαια δεν μεγάλωσε τόσο εντυπωσιακά. Είμαστε πια 11 άτομα με το προσωπικό όλοι και εξωτερικοί συνεργάτες. Σίγουρα όμως μεγάλωσε εντυπωσιακά ο αριθμός των αρμοδιοτήτων του, η δράση μας και αυξήθηκε και η εξωστρέφειά μας. Ο ΟΠΗ, που γεννήθηκε με την βοήθεια της κυρίας Καλλινίκου, μεγάλωσε με τον άγρυπνο βλέμμα του κύριου Πολυζογόπουλου, ανδρώθηκε και με την ενέργεια και την δραστηριότητα της κυρίας Σταματούδη που είναι εδώ και στη συνέχεια ακολούθησε και η θητεία της κυρίας Βαγενά. Ήδη υπόθηκαν πολλά σημαντικά, δεν θα πω για όλη την ιστορική αναδρομή. Νομίζω κάλλιστα θα μπορούσαμε να γράψουμε ένα βιβλίο και νομίζω θα ήμασταν και για σύριαλ στον Οργανισμό Πνευματικής Ιδιοκτησίας, κάλλιστα. Η δομή και το περιεχόμενο του συνεδρίου άλλαξαν πολλές φορές. Και αυτό που τελικά καταλήξαμε να κάνουμε, για να μην κάνουμε μια απλή ιστορική αναδρομή, είναι να επιλέξουμε τομείς στους οποίους είναι οι βασικοί τομείς της αρμοδιότητάς μας και των δραστηριοτήτων μας. Και έτσι θα ξεκινήσουμε με ένα πάνελ που έχει να κάνει τις διεθνείς και τις ενωσιακές εξέλιξεις, στις οποίες όχι μόνο συμμετέχουμε, αλλά παρακολουθούμε, αλλά συμμετέχουμε και ενεργά. σε όλα τα όργανα με τα οποία συμμετέχει ο ΟΠΗ και στον Παγκόσμιο Οργανισμό Διανοητικής Ιδιοκτησίας και στην ομάδα εργασίας του Συμβουλίου στην Ευρωπαϊκή Ένωση, αλλά και στον Ευρωπαϊκό Οργανισμό Διανοητικής Ιδιοκτησίας. Στη συνέχεια, φυσικά, δεν θα μπορούσαμε να αφήσουμε εκτός την τεχνητή νοημοσύνη και την πνευματική ιδιοκτησία. Δεν γίνεται. Όλη πια η συζήτηση περιστρέφεται γύρω από αυτήν, στον οποίο και εκεί προσπαθούμε να παρακολουθούμε στενά τις εξελίξεις και συμβάλλουμε με τις απόψεις μας όπου μας ζητούνται. Επίσης, έχουμε προτείνει να δημιουργηθεί μια ομάδα για την πνευματική ιδιοκτησία και την τεχνητή νοημοσύνη, γιατί θεωρούμε πάρα πολύ σημαντικό οι θέσεις αυτές να μην είναι θέσεις μόνο του ΟΠΗ, αλλά να μπορούν να διαμορφωθούν από όλους τους εμπλεκόμενους, ώστε η θέση της Ελλάδας να είναι μια θέση που είναι στιβαρή και να ξέρουμε ότι έχει διαμορφωθεί μέσα από μια διαβούλευση και μέσα από τις κοινές απόψεις όλων των εμπλεκόμενων φορέων. Στη συνέχεια έχουμε τη συλλογική διαχείριση, η οποία καταλαμβάνει το μεγαλύτερο ίσως όγκο της ενασχόλησής μας και δημιουργεί και τα περισσότερα αγκάθια. Έχουμε γενικά περάσει διάφορα σχετικά με τη συλλογική διαχείριση, αλλά φυσικά δεν μπορούσε να λείπει και φυσικά ένα από τα μεγαλύτερα θέματα που είχαμε αντιμετωπίσει στο παρελθόν είναι το φαινόμενο της ΑΕΠ. Αλλά νομίζω ότι αντιμετωπίστηκε και αυτό. Και τέλος, φυσικά, θα είχαμε το πάνελ για την καταπολέμηση της διαδικτυακής πειρατείας, που όπως υπόθηκε αρκετές φορές έχουμε κάνει πολλά και θεωρώ ότι αποτελούμε ένα παράδειγμα προς μίμηση. Τι έπεται? Ευελπιστούμε στην τροποποίηση του καταστατικού του ΟΠΗ, που θα δώσει τη δυνατότητα να έχουμε περισσότερο δυναμικό, έμψυχο, καλύτερη δομή, για να μπορούμε να κάνουμε καλύτερα τα πράγματα που ήδη κάνουμε στον οργανισμό. Ευελπιστούμε να κάνουμε ένα κέντρο διαμεσολάβησης με τη βοήθεια και με του Παγκόσμιου Οργανισμού Διανοητικής Ιδιοκτησίας, το κέντρο διαμεσολάβησης, ώστε να προσφέρουμε τις υπηρεσίες επίλυσης διαφορών σε θέματα πνευματικής ιδιοκτησίας. Θέλουμε να επεκτείνουμε το εκπαιδευτικό ρόλο του ΟΠΗ και στα πανεπιστήμια και να ενεργοποιήσουμε τα μνημόνια συνεργασίας και με την Εθνική Σχολή Δικαστών, αλλά και με τον Οργανισμό Βιομηχανικής Ιδιοκτησίας. Δεν μακρηγορώ άλλο. Σας ευχαριστώ πάρα πολύ. Έχουμε ένα πολύ σφιχτό πρόγραμμα, οπότε σας ευχαριστώ και εύχομαι να είσαστε καλά και να περάσετε καλά στο συνέδριο. Δεν φεύγω. Θα καλέσω τους ομιλητές του επόμενου πάνελ. I will call now the speakers for the next panel. Mrs. Forben, Mrs. Tsakova, and Mr. Drobnik. Unfortunately, Professor Stathopoulos wasn't able to join us due to some health reasons. So this panel will be chaired. Ευχαριστούμε πολύ. This panel will be chaired by my colleague and the lawyer member of the legal department of Hellenic Opera Organization, Mrs. Sinanidou.
Καλημέρα και από μένα σε όλους. Χρόνια μας πολλά και ευχαριστούμε που είστε όλοι εδώ μαζί μας. Χαίρομαι πολύ που βλέπω όλους σας. Για κάποιους από εσάς χαίρομαι ιδιαίτερα, ακόμη παραπάνω. Περνάω κατευθείαν στο ψητό. Δυστυχώς ο καθηγητής κύριος Σταθόπουλος δεν μπορεί να είναι μαζί μας για λόγους υγείας, οπότε είμαι εγώ στη θέση του, χωροταξικά. Η πρώτη ομιλήτρια, την οποία έχουμε την τιμή να έχουμε μαζί μας, είναι η κυρία Sylvie Forben. Welcome, Sylvie. After classical studies at the Sorbonne, the cycle of Institut d'études politiques of Paris, and the postgraduate diploma in international economics at the Foundation of Political Science of Paris, Sylvie joined the Quai d'Orsay in 1983. During an 18-year diplomatic career, she was posted in Beijing, Rome, and Brussels.
From 1989, she specialized in audiovisual regulation and cultural affairs, serving first at the permanent representation of France to the EU in Brussels, then at the French Embassy in Rome, and later at the head of a pan-European cooperation organization called Evrika Audiovisual.
A Greek name.
A Greek name, indeed. Between 2002 and 2016, she worked at Vivendi Universal, where she served as Senior Vice President of Public and European Affairs. She focused on two main activities of Vivendi, ex-Vivendi Universal Group, telecom and media, where she was involved with her new content services, including new business models and IP-related topics. Sylvie has been WIPO's Deputy Director General for Copyright and Creative Industry since September 2016, and we are very happy to host her here today. Thank you, Sylvie.
Thank you, Maria. I'm going to zoom up a little from the country which used to be at the center of the world some decades ago. I'm not speaking of the 30th anniversary, but the period where Greece was so shining in the world. And I'm going to zoom up a little to give you some words from WIPO, that is to say, with an international perspective. Dear Deputy Minister of Culture, Iason Fotylas, dear Panagiotis Tsiris, President of the Hellenic Copyright Organization, dear Daphne Papadopoulou, Acting Director of HEO, dear friends and colleagues. I'm so happy that the 30th anniversary of the founding of the Hellenic Copyright Organization has given us the opportunity to be here in Athens. Thank you so much for the organizers, especially to dear Daphne, for having chosen this outstanding venue, and to the Director General of the Museum of the Acropolis, Nikos Stampodilis, for offering us this privilege. I'm looking back 30 years ago. If we look back, not only for the anniversary of HCO, but worldwide, discussion at the international level were focused on adopting an essential piece of the international framework, the Internet treaties, the WIPO Copyright Treaty, WCT, and the WIPO Performance and Phonogram Treaty, WPPT, Internet treaties adopted in 1996. Those visionary normative instruments were progressively implemented by a constantly growing number of member states, with 181 contracting party to the Foundational Berne Convention, 118 contracting party to the WCT, and 114 contracting party to the WPPT out of 193 WIPO member states. We may say that the international framework has over time developed to embrace the opportunities and challenges of the digital era. We are facing now a new technological breakthrough with the global spread of generative AI in the creative world. The question that is in everybody's mind is, of course, do we need a new normative endeavor to face this disruptive phenomenon? Question. Recently, I had the opportunity to measure the unprecedented mobilization of jointly member states from around the world, multiple United Nations bodies, and a vast array of private stakeholders relevant in this field, from tech companies to creators and innovators. I participated, in fact, in the Paris AI Action Summit, which took place on February 10th and 11th. One of the main takeaways from this important event is the growing call for global dialogue on AI governance in order to safeguard the role of some fundamental principles. Given my role in WIPO, I brought the message about the importance of some of those cross-cutting principles that might guide our work in the coming months with a focus on the creative sector. First, AI must be human-centric. The copyright system has continuously shown resilience and always adjusted to keep the human creator at the center. Up to now, IP has been able to reaffirm the rights of creators while also supporting technological innovations and new business models. Any adjustment arising from AI must be guided by this principle. Second, trust is essential in both AI systems and governments. AI developers must ensure that they earn the trust of those whose work and innovation form the basis of their models and tools. Third, transparency is central and must be carefully defined and implemented. Regardless of the potential solutions to be considered, it is essential that relevant data and metadata are transparent, traceable, and reliable. For those goals to be achieved, there need to be sufficient technical systems in place to manage the data for all necessary purposes, including attribution, potential opt-outs, as I am in a European-focused word, usage and royalty reporting, as well as payments. As part of our contribution to advance AI governance objectives, I suggested that AI governance efforts will require a balance between top-down principles and bottom-up practical technical input. To this end, at WIPO, we are preparing to launch a new initiative that we have called AIII, AI Infrastructure Interchange, which will be a forum for technical, practical discussions to enable stakeholders to come together to find solutions for navigating the new regulatory, licensing, labeling requirements emerging in the AI space. So, to respond to the initial question, do we need new work in the normative area? I have to say that for the moment, it seems that the most urgent issue to tackle is how we could collectively put in place the components of the infrastructure that will allow the implementation of the three principles I just mentioned: human centricity, trust, and transparency. The omnipresence of the AI debate must not eclipse the continuing need to adapt to the digital environment in order to derive the benefits from this technology and mitigate the inherent risk to the copyright community through proper regulation. We have at WIPO a long-standing project, hopefully near finalization, the Broadcasting Draft Treaty, which would allow member states to launch injunctions with cross-border effects in response to signal piracy. We are conscious that this topic is not at all outdated and do hope that the conditions for a diplomatic conference will soon be met. The discussion that we have had with our Greek colleagues in the last few days reinforced us with the relevance of this project. Some member states, especially in Latin America, have brought some years ago the idea of a debate in our normative committee called the SCCR, Standing Committee on Copyright and Related Rights, on the digital ecosystem with regard music, audiovisual, publishing, press, and other fields. We have many subjects that could be addressed under this topic. And in this regard, there is a growing understanding that tackling these topics at the international level in a more systematic way would be very useful. When we see in Greece and other European countries the sophistication of the mechanism developed in this part of the world that you even mentioned this morning, which are regularly mentioned as well in Geneva, I am convinced that Europe and other developed countries don't need to fear addressing this topic at the international level. In fact, it would be beneficial as well for Europe that other countries would have the same sophisticated tools and means. This brings me to my last point, which is sensitive, and which at the same time could be toxic if we ignore it and fail to address it. The elephant in the room is the continuing belief from some member states, especially from developing countries, that exceptions and limitations due to copyright deserve some more formal support at WIPO level. As you know, we have done a lot of work since 2017 through regional and international meetings, through studies, through toolkits on preservation of material belonging to cultural heritage institutions, and now on access on the content of those institutions, and then, third, after this one, on access to educational and research material. Is it pure coincidence, or is it linked to new stakes related to AI? I hope that I have convinced you that we are facing a real push to address the topic in a more formal manner as well. Again, on this issue, exception and limitation, I think Europe has no need to be on the defensive, but instead can help demonstrate that very well-designed limitation and exceptions with precise context and compensation mechanism can help achieve the objectives already well established in the Berne Convention, with the necessary safeguards from the three-step test. If we can achieve to have something in the nature of objectives and principles, in the format of, for example, a WIPO recommendation, that is to say, soft law, I'm convinced that we could address better a very important topic, TPM, Technological Protection Measures, and RME, Rights Management in Information, in a way that will not be seen by those proponents of a formal work on exception and limitation as an obstacle to the exploitation of exception and limitation, but as an enabler of some very well-managed flexibilities, in addition to their more well-known function, the function of those tools, TPM and RMI. Finally, my last message, as we are here to celebrate a happy birthday to HCO, is that we would gain a lot collectively if we could leverage the potential of copyright while facing new situation with out-of-the-box thinking. If we succeed in this endeavor, we could take the best of the new possibilities offered by the digital era at large for the benefit, as we say in WIPO, of everyone, everywhere, and most of all, for the creators. I thank you.
Thank you, Ms. Forben. We'll pass to our next speaker, Ms. Sabina Tsakova. Welcome. Thank you for being with us. She is the Deputy Head of the Copyright Unit in DG Connect European Commission since January 2025. She previously worked in the Audiovisual Media Services Unit of DG Connect, focusing mostly on the negotiations for European Media Freedom Act. Prior to this, Sabina was a policy and legal officer in the Copyright Unit from 2015 to 2021, and a case handler in DG Competitions Pharma and Health Unit. She holds an LLM in European law from the College of Europe and is admitted to the Paris Bar. Sabina is fluent in Bulgarian, French, and English, and has advanced knowledge of Spanish. Sabina will talk us about EU copyright law, current trends, and outlook for the future. Thank you.
Thank you very much for the introduction, for the invitation. So, dear Deputy Minister, dear President of the HCO, dear Daphne, dear all, I'm very happy to be here today to present you a bit of an overview of our main activities on copyright that have been taking place over the last months, and give you maybe a small outlook for the short-term future at least. I will start with AI and copyright, of course, because you can imagine that this has taken us a lot of our time recently, and I will then mention some developments regarding the implementation of the Digital Single Market Copyright Directive, and also some update on our work on piracy. So starting first with artificial intelligence and copyright, as I said, discussion on AI and copyright, of course, are very, let's say, taking a lot of time, and I know you will be discussing, of course, more in depth later. So I'll try not to, repeat what will be said later, but I still wanted to set the scene a little bit of the copyright framework of what exists in the EU. What we have been working recently are initiatives, first of all, to support the implementation of the TDM opt-out pursuant to Article 4 of the DSM directive. And we have also been collaborating extensively with the AI office regarding their work on the code of practice for GPAI providers, as well as the template for the summary of training data. So on these two issues, first, the implementation of the TDM opt-out. The TDM exceptions, as has been said already today, has been, of course, become increasingly relevant in the context, in the new global context, in the context of AI. And this exception at EU level includes a mechanism that allows right holders to reserve their rights. This exercise of the opt-out, of course, is key for right holders to regain control of the exclusive rights and to license, if so they choose, the use of their works for AI training. And from the side of the Commission, we are really committed to supporting the implementation of this opt-out mechanism. And for this, I wanted to inform you that we will assess the opportunity of introducing a central registry of opt-outs as a complement, of course, to everything that is available and all the emerging also solutions and standards in this area. And we have recently launched a call for tenders for a feasibility study on this registry under the TDM exception. With the study, what we want to seek is to explore a solution that will balance, of course, the interests of right holders and AI developers, ensuring the rights of content creators are respected, at the same time facilitating the growth and innovation of AI technologies. And we expect the launch of this study hopefully before the summer, meaning that results will not be available before the end of the year, at the earliest. The second aspect that I mentioned in the introduction was the AI Act implementation. So as you know, the AI Act, which was adopted last year, includes targeted rules to facilitate the enforcement of EU copyright law. Through two series of measures. One of them is an obligation for AI providers to draw up and make publicly available a sufficiently detailed summary of data used for training their models. And the second part is the obligation to put in place a policy to respect EU copyright law. These rules will be applicable normally 12 months after August 2024. So in a couple of months, essentially. And what is happening currently, the AI office is actively engaged with facilitating the drawing up of the code of practice in consultation with stakeholders. And the process for the drawing up of the code of practice is ongoing. Maybe some of you have seen one of the versions which was published, I think, in December. And there is, I think the next version of the code should be published, I guess, soon. I'm not able to say more at this stage. The AI office is also working on the preparation of a template, which is for the summary of training data that I mentioned. And this template aims to facilitate the exercise of rights by right holders and parties with legitimate interest on that. And for us, of course, it is important that the summary is meaningful. So meaningful for right holders to help them in the exercise of their rights. And at the same time, it shouldn't be, of course, very technically detailed and should, of course, take into account the need to protect trade secrets or confidential business information. Last, what I wanted to mention is, licensing developments, because we have the AI Act, we have the TDM exception with the opt-out. So progress in this practical implementation of the exception, as well as a high transparency on the content used on training of AI models, should help right holders to enforce their rights and to engage in licensing negotiations. We know that there are already some licensing deals that are being concluded between AI providers, for example, and press publishers. I think recently also AI provider from Europe also concluded a partnership with one press agency. But to our knowledge, I think that there are no licensing agreements so far with, for example, collective management organizations. But of course, you will tell me if we don't have the updated state of play on that. And what we are currently reflecting on is whether there would be a need for any potential measures at EU level to foster the development of the licensing market, which should allow AI developers to access quality content at scale and creators to obtain the appropriate remuneration for this, of course. Building on the provisions I mentioned in the beginning, the AI Act, the DSM Directive, we could consider eventually certain specific rules to be introduced to facilitate the conclusions of licensing agreements under fair and reasonable terms. Also, mediation mechanisms could be explored to address possible difficulties, especially when it comes to bargaining power between the different parties. So to sum up on this point, more generally, as I said, we will continue to support the enforcement of the existing set of rules, ensure the implementation, and that they produce a positive impact for right holders across the value chain. And building on these key provisions, we will assess, of course, how to tackle the new challenges that everybody is discussing around the world with AI technologies and the challenges to the copyright framework. So I was maybe a bit long on this topic, but I wanted to present you a good overview because, of course, this is quite topical. The second aspect I wanted to mention is the implementation of the 2019 DSM Directive and possible next steps in this regard. For the moment, we are happy to say that after a very long time, after a very long process of transposition, now all member states have implemented the directive, with the last transposition that was notified to us in August last year. On the directive, I think what is also interesting to keep in mind and follow are developments in the court, because there are a number of interesting preliminary questions on the interpretation of especially the last chapter, let's say, or the last section of the directive. So I think Article 15, 17, and 18. So this is pending in the Court of Justice, but I think we will have probably, or hopefully, some interesting judgments on that. And as to, probably some of you are interested in the next steps on this front from our side. We are currently discussing how to approach the review of the DSM directive, because, as you know, we have an obligation under Article 30 of the directive to undertake a review and report no sooner than June 2026, actually, which is give us some flexibility as to timing. And for the purpose of the review, we are intending to launch a study to examine the application of the main provisions of the directive in the member states, when mainly looking at the effectiveness of the provisions, what impact they have had on the market, on licensing, on the remuneration of creators. And on this basis, we will consider, of course, if there is a need for further improvements of the framework, in particular in light of all the market and technological developments. So finally, a brief word also on piracy. I know you will be discussing in a panel later, so there might be more details given there, but I still wanted to mention, because there is an assessment from the Commission coming up by the end of this year. So the recommendation of piracy on combating piracy of live and sports and other live events was adopted now almost 2 years ago, in May 2023. It was directed at several stakeholders, including member states, which, as we heard earlier, are actively participating also through the dedicated network to exchange best practices on the issue of piracy. This recommendation built on existing legislation, existing remedies in EU law, including Enforcement Directive, InfoSoc, and the DSA. And the idea was to really step up the fight against piracy by recommending certain actions which could help, for example, by treating notices promptly. So when intermediaries receive notices, they should act promptly on the notice. It also encouraged member states to use dynamic injunctions in certain cases. But more generally, it was underlined that cooperation and awareness raising around legal offers as well was very important. So we are now, yes, as I said, 2 years after the recommendation. We are monitoring the effects of the recommendation with the great help of our colleagues in the EU IPO. There are collection exercises, data collection exercises ongoing, and some others will be coming up. So we really encourage strongly all interested stakeholders to participate, because this will give us also good input for our assessment of the recommendation, which is my last point, which is due to come up by November this year, November 2025. So we intend to assess the effects of the recommendation, considering the results of this monitoring exercise. And this assessment should provide us with the relevant information to determine whether there is a need for additional measures at EU level on this topic. And in this context, we will, of course, look at the impact that the DSA has had also on the topic of piracy. So I leave you at that. There are many other few things that we are doing at the Commission, so I'm happy to exchange, of course, also later during any appropriate moment. Thank you.
Thank you, Sabina, for giving us some really interesting information about what is happening, what is being discussed at the European level. And our next speaker is Mr. Dziga Drobnik.
Good.
Thank you. Welcome. Dziga is working as a copyright specialist at the European Observatory on Infringement of Intellectual Property Rights of the European Union Intellectual Property Office, EU IPO, in Alicante, Spain. He's dealing with copyright-related topics online, such as piracy and generative AI. He joined the EU IPO in February 2023. Prior to that, he spent 13 years in Brussels, so now it's better in Alicante, much better, working in the copyright unit in the European Commission. Sorry. But it's like that. As well as in the Audiovisual and Media Policy Unit from 2017 to 2020. He also has experience from the private sector, where he worked in an EU public affairs consultancy and the Slovene National Administration during the presidency of the Council of the EU. He holds master's degrees in geography and history, both University of Ljubljana, Slovenia, European Studies, College of Europe, Poland, and LLM in IP and ICT law, Leuven, Belgium. Welcome. We are happy to listen to you.
Thank you. Thank you very much. Dear Deputy Minister President Daphne, I think she's still around, distinguished guests and panelists, the HCO, happy birthday. 30 years, looking good. Life starts at 30, they say. So thank you very much for the invitation. I will structure my presentation into three parts, briefly introducing the EU IPO, so the European Union Intellectual Property Office, and the Observatory of IP Infringements. Then I'll speak about our strategic priorities in the field of copyright and describe a few relevant initiatives. So about the EU IPO, the agency is responsible for managing EU trademarks design and since recently also geographical indications. And the Observatory on Infringements of Intellectual Property Rights, what we call just Observatory, has been integrated into the EU IPO in 2012, and we have three goals. Three goals: providing facts and evidences to support policy making, national, also the EU level, to create tools and resources to help fight IP infringement, and to raise awareness on IP and the negative sides of counterfeiting and piracy. So, Observatory, we observe what's happening in the field of IP, but we also serve. That's also a word which is in observe, by providing information and tools. We are, in practical terms, we are managing a network of experts and specialist stakeholders from the public sector, private, civil society, and they're organized in working groups and expert groups. And we're also developing tools such as the IP enforcement portal, which is for counterfeiting material, platform that allows the communication between rights holders and enforcement authorities. So what we, under the strategic plan 2030, so the next 5 years, we have copyright has been identified as a strategic priority for us. The reason why maybe because, as you all know, copyright law and policies are still very much national and territorial, but the issues are the cross-border dimension. So the digital transformation has brought this very much into our lives. So it calls for a solution and cooperation at EU level. And it's not only regarding the enforcement part, but there is also an educational awareness composition to it, and outreach. And in the consultation to this strategic work program, the EU IPO has also been suggested by, or invited, let's say, by some stakeholders to act in this area. So building on our experience with intellectual property rights, and our engagement on copyright through the observatory, we had the idea to create the EU IPO Copyright Knowledge Center. It's important here to say that it's about knowledge center. We do not make policy, we support the implementation. This is a very important point I want to make. The center will be kind of the umbrella of our approach in this field. First of all, it will consolidate all the initiatives, copyright initiatives that are currently ongoing, that we're already doing. And there will be a gradual development of new actions around 6 pillars, which again are already existing. Economic data and statistics, as you can see in the back, legal, outreach and awareness, copyright tools and enforcement, where we also have a fight against piracy, and the international perspective. So all of these pillars represent what we're already doing, and the center will be kind of a branding of the focus on copyright, bringing, again, everything together. So not everybody here may be aware what I mean but by the 6 pillars and what we're already doing, so I'll give you a few examples. Under copyright tools, we have the Orphan Works and the Out of Commerce Works portal. These are databases that we're managing. On the outreach side, we have frequently asked questions for consumers and for teachers. We have the Agorateka portal, which is linking to national portals of legal content, so where users can find legally accessible content. In the legal pillar, we have a judges network, we have case law collection that we're collecting. We have enforcement is quite interesting here because we have a cooperation with intermediaries expert group. We have a live event piracy, and I'll speak about it more in the second panel at the end. We've issued also a number of discussion papers on trends, challenges, and good practices when it comes to IP infringement activities. For example, on live event piracy, on apps and app stores and search engines. On economics and statistics pillars, we prepare reports and studies. Our latest one was the online copyright infringement report, which I'll also mention a bit in the other panel. And on international level, we are in conversations and participations in meetings, for example, with a WIPO, WIPO. So part of our work the important part are the networks, such as the National Copyright Administration Network, the dedicated network, as we call it. And here I have to say that the HCO is an important member in it and is participating very actively. So thank you a lot for that. Through these networks, the Copyright Knowledge Center will also work as a forum of where stakeholders will be able to discuss and also prioritize initiatives which the EU-IPO could take as a next step, but also to see which ones are really important, which ones are less. So we'll have a step-by-step approach. There are several objectives that we have in mind. So we'll start with consolidating the tasks that we're already doing and the information sources in a single landing page, the EU-IPO Copyright Hub. And that will be, as you can imagine, the hub. It will bring together all the information. We'll work on the enhancement of the copyright databases, mainly the Out of Commerce Works portal will be further improved. We will also start preparatory work for new services, for example, the Copyright View, which I'll also speak a bit later on. And of course, we'll engage with you, the copyright community, the users and the public sector representatives to prioritize the activities that come next. So, to say it again, all these work streams will be carefully considered and discussed in close collaboration with all interested parties, also including the WIPO and the Commission, so the other panelists, just to make sure that this is clear. So about the specific initiatives, yes, good. The Copyright Hub. The Copyright Hub will be the landing page where we will pull together all the relevant material that we already have. It will provide online information resources, but structured, tailored support for businesses and creators throughout their copyright journey. The aim is to see how copyright can be protected, respected, and valued. It will be done also with or paired with awareness and education material that are adjusted to the specific needs of the audience. So here we're having in mind youngsters, SMEs, individual creators, and for different sectors, because different sectors need different approaches. The flagship initiatives will be the EU-IPO Copyright Interactive Map, which will give access to aggregated data on copyright per member state. What we want to present to you, well, to the user there is the legislation, which are the competent authorities in the member states. Are there any registries available? Deposit system. Collective rights management organizations. Are there any national IP curriculums that could as well fit into there? Are there any IP masters available in the member states? This could all fit into this EU-IPO Copyright Interactive Map. I also mentioned the Copyright View. Yeah. The Copyright View, it will link existing national and EU copyright databases and information from relevant metadata standards. So the aim is to provide a centralized access to information about copyright, authorship, ownership of works. For example, if a work is in public domain, what are the conditions to access? It will also be set up with a view to have a search function, but that still has to be seen, obviously, later on, how this could be done. The main goal will be to improve transparency in copyright attribution and transaction, because these are all linked to the online exploitation of copyright-protected works online. And this project should also support our outreach and education initiatives for creators. For example, we intend to have metadata education, and also provide the relevant resources for users regarding clearance of copyright. So the very first initial step here will be, which is needed, a mapping exercise, gathering information on all the resources which are available in the EU. And I kept it for the last Gen AI on generative artificial intelligence. We are working closely with the European Commission, as Sabina already mentioned, both the copyright and also the artificial intelligence unit. We are conducting at the moment a study on the development of Gen AI from a copyright perspective. But we're looking at not the legal part, we're looking at the technical solutions and practices that are out there. They are being developed to address the copyright challenges raised by Gen AI. So the study will not provide a legal analysis. This is not the aim, but it has a technical focus. But of course, it is within the framework of the legal acts that are there, especially the EU copyright legislation, and also the AI Act. We are focusing here on the input and output side. So from the input side, the opt-out solutions that are there on the market, so the TDM, text and data mining opt-out solutions, for example, roboTXT, the terms and conditions, TDM rep, C2PA, some people this may say something, but also the solutions on the output side to mark content which is created by AI models. So, for example, watermarking. Of course, we cannot avoid economic considerations, but this is not the focus of our study. It will be concluded by the end of this month, and it should be published soon thereafter. And it's also very good timing because, as Sabine already said, they're preparing a central a study for a central work-based TDM opt-out registry, and our study should feed into their work. So let me then conclude just with a timeline. We'll start small steps into this year. One of the first things will be the landing page that you'll be able to see. We'll have the major milestone in 2025 will be the official launch of the EU IPO Copyright Knowledge Center. It's scheduled for November 25. Until then, we have the publication of our study. We'll also have a live event piracy conference on the 30th of April in sunny Alicante. And the new landing page will be set up most likely in September 25, and we'll have the study on the mapping, the mapping for copyright view by the end of this year. Small steps, but going there. Thank you very much.
So thank you, Ziga. Thank you, big thank you to all the speakers. Also, thank you for keeping up the time. Actually, it's planned to have now a coffee break. I don't know if there are any questions. Δεν ξέρω αν υπάρχουν ερωτήσεις για τους ομιλητές, τους οποίους ευχαριστούμε θερμά και για τις εισηγήσεις τους και για το ότι κράτησαν το χρόνο. Διαφορετικά, περνάμε στο πρώτο διάλειμμα, το οποίο θα είναι 1/4 για καφέ και για ό,τι άλλο θέλετε. Τσιγάρο, δεν ξέρω. Καφέ, τσάι, νερό. Η ώρα είναι και 40, οπότε και 55 επανερχόμαστε.
Please take your seat in order to start. Παρακαλώ καθίστε. Σας ευχαριστούμε πάρα πολύ. Το ξέρω ότι είναι λίγο δύσκολο το πρόγραμμα και λίγο τα χρονικά πλαίσια λίγο στενά. Βάλαμε πολλούς για να έχουμε έτσι όλη την εικόνα, οπότε είμαστε λίγο, πιέζουμε στο χρόνο. Συγγνώμη, σας ευχαριστώ πολύ.
Καλημέρα σε όλους σας. Είμαστε λίγο μετά τις 12, αλλά νομίζω δικαιούμαι να λέω ακόμα καλημέρα. The panel will excuse me, I shall start in Greek and say a few words whilst I was a director in the Hellenic Copyright Organization. Θα ήθελα να πω ότι είμαι πολύ συγκινημένη σήμερα, που είμαι ανάμεσα στους ανθρώπους που υπήρξαν σχεδόν η οικογένειά μου για περίπου 12 χρόνια, το 2007 όταν ανέλαβα, ως το 2018. Υπήρξαν μάλιστα στιγμές που έβλεπα περισσότερο εκείνους τους ανθρώπους παρά την οικογένειά μου, θα πρέπει να πω. Ήμουν τυχερή διότι διετέλεσα με κορυφαίους προέδρους που με είχαν στηρίξει στο έργο μου, όπως ήταν ο αείμνηστος κύριος Tsiris, ο Stathopoulos που δυστυχώς δεν μπορεί να είναι σήμερα μαζί μας, ο κύριος Μαργαρίτης, ο κύριος Σαραντινός και άλλοι. Και ήμουν επίσης πάρα πολύ τυχερή, διότι οι υπάλληλοι του οποίοι ήταν πραγματικά υπόδειγμα υπαλλήλων που θα μπορούσε να έχει ένας δημόσιος οργανισμός. Είχα ένα εξαιρετικό νομικό τμήμα, το οποίο με στήριξε σε ό,τι έκανα και όταν παραιτήθηκα πλέον το 2018, ήξερα ότι άφηνα τον οργανισμό σε πολύ καλά χέρια, στα χέρια της Δάφνης, η οποία πραγματικά με έχει κάνει πολύ περήφανη, αλλά και όλα τα παιδιά μέσα στον ΟΠΗ, τα οποία τα αγαπάω πάρα πολύ. Διαδέχτηκα σε αυτή τη θέση τον αγαπημένο μου Κωνσταντίνο Πολυζογόπουλο, τον οποίο πάντα όλοι αγαπούμε πολύ. Και αυτά τα 12 χρόνια είχαν πάρα πολύ ένταση, πάρα πολύ δουλειά. Όπως ανέφερε και η Δάφνη, υπήρχαν στιγμές που και στη δική μου θητεία που πραγματικά κάποτε απογοητευόμασταν, κάποτε αισθανόμασταν πολύ περήφανοι που ήμασταν εκεί. Θέλω ενδεικτικά να αναφέρω κάποια πράγματα που κάναμε τότε, την Επιτροπή για τη Διαδικτυακή Πειρατεία, που την βαφτίσαμε κιόλας με αυτό το ακρονίμιο, το εκπαιδευτικό πρόγραμμα, τίποτα από αυτά δεν έγινε εύκολα, γιατί το εκπαιδευτικό πρόγραμμα, θυμάμαι τότε μας έλεγαν από το Υπουργείο Παιδείας ότι η πνευματική ιδιοκτησία χωρίζει και δεν ενώνει τους ανθρώπους και είχαμε δώσει μεγάλη μάχη για να το περάσουμε και να το βάλουμε στα σχολεία. Ενισχύσαμε τη διαφάνεια και τη λογοδοσία των οργανισμών συλλογικής διαχείρισης και ξεσκεπάσαμε το σκάνδαλο της ΑΕΠ. Ίσως να είναι το δυσκολότερο project που έχω κάνει μέχρι σήμερα. Βελτιώσαμε τον νόμο για τα πνευματικά δικαιώματα, κλείνοντας κενά. Κάναμε το ισχυρότερο που υπάρχει στον κόσμο αυτή τη στιγμή, άρθρο 18, για την ιδιωτική παραγωγή για τους δικαιούχους. Το θεωρώ πρότυπο το άρθρο αυτό. Φτιάξαμε την νομοθεσία, ήταν το πρώτο πράγμα που κάναμε όταν ανέλαβα για τα άτομα με αναπηρίες όρασης. Κάναμε την Προεδρία στην Ευρωπαϊκή Ένωση, διαπραγματευτήκαμε μεταξύ ενώσεων χρηστών και δικαιούχων, ώστε να μπει το νερό στα βλάκια και να αρχίσουν να πληρώνουν πιο εύκολα. Κάναμε τη χρονοσήμανση και πολλά άλλα πράγματα με τα οποία δεν θέλω να σας κουράζω. Θέλω να πω ότι είμαι συγκινημένη επίσης και για το γεγονός ότι κάποιοι φοιτητές μου πέρασαν από τον ΟΠΗ. Έχουμε σήμερα εδώ πέρα την Εύα τη Μουστάκα που είναι στον ΟΠΗ και χαίρομαι πάρα πολύ για εκείνη και με κάνει περήφανη. Έχουμε τη Τζεκούρα την Εύη, τη Ζωή τη Μαυροσκότη, αλλά και παιδιά που αποφοίτησαν από το Διεθνές Πανεπιστήμιο τότε Ελλάδος, όπως η Ανθία Κριτίδου, Αντώνης Ομπάρης, είναι στο νομικό τμήμα της ΙΦΡΟ σήμερα, και πολλά άλλα παιδιά που είναι σήμερα φοιτητές και είναι στο ακροατήριο και πιστεύω και εκείνοι θα έχουν μια εξαιρετική εξέλιξη. Και θέλω να πάρω αυτή την ευκαιρία για να ευχηθώ και στον κύριο Tsiris καλή επιτυχία σε ό,τι κάνει στο έργο του και να ευχηθούμε γενικά ο οποίος να μπορεί να βοηθάει τους δικαιούχους και το Υπουργείο που το έχει πολύ μεγάλη ανάγκη. And now I'm switching to what I am supposed to do. We have a panel of great experts. Some of them I have known for years. We need to speak slowly and close to the mic because we have simultaneous translation and there is streaming going on. And we shall start with Silke von Lewiski. It's Professor Dr. Silke von Lewiski from Max Planck Institute for Innovation and Competition. She's an associate professor at Zagreb University. She's a world-known expert for the European Commission, for WIPO, the German government, and her writings are very well known and have an impact in the area. Thank you, Silke. She will talk to us about the TDM exception, specifically Article 4 of the DSM Directive, and whether this is a legitimate basis for the training of generative AI models. She will discuss options for right holders, such as litigation, negotiation, and conclusion of agreements, and she will also provide examples from Germany.
Thank you so much, Irini, and thank you very much for the Hellenic Copyright Organization for having me invited to this important event, and congratulations to your 30th anniversary. And good luck for the next 30 and more than 30 years, I hope. In my short 15 minutes, I would like to focus in the first part on the question of whether the Article 4 of the DSM Directive on the exception for TDM uses is applicable to the training of generative AI. And in the second part, I will mention some examples from practice in Germany, how to deal with the situation. I put you together here a combination of Article 4.1, which you will very well know, and the definition of the text and data mining in Article 2, so that it actually reads that the member state shall provide an exception for to the reproduction right for the purposes of, I would briefly say, purposes of analyzing, automated analysis of text and data in order to generate information. And the examples are given here, the patterns, trends, and correlations. And also the accompanying recital 8 speaks of an automated computational analysis, which is the purpose of the reproduction, and done with a view to gaining new knowledge and discovering new trends possible. So does this cover the training of Gen AI models? And just to recall, we have different acts of reproduction in the whole process of generative AI. The first one is, of course, the input phase, where works are being copied. They are taken from the internet mostly, but from other sources also, and put into a database, and there one reproduction in any case takes place. So the preparatory act, so to say, for the actual training. At the outside, output end, at the other end, you have the so-called output copies, which may be copies, especially if the works are totally recognizable, if there is a one-to-one copy which may occur, as we have seen, for example, in the case on the lawsuit of New York Times against OpenAI, where the whole articles were reproduced as an output of the generative AI. But I will, in the first part, mainly talk about this question, whether also during the training, so to say, inside the whole process, there will be reproductions which might or might not fall under the TDM exception. And in order to do so, let's say, my view was also, well, always that Article 4 would not, and Article 3 also would not apply to training of generative AI models. But I am glad that last year in Germany we had a publication which confirmed this view also from a technological perspective. Because you may have heard about this study, which is 70 plus pages, and which is the first deep collaboration between a computer scientist and a law professor. I will give you the sources later, and I rely a lot on the computer scientist's results of the study for these technological issues. And he says, well, there is a fundamental difference between classical text and data mining and the training of AI models. Classical text and data mining is, well, in this process, you have, during the training, only certain parameters, so to say, the semantic information is accessed and extracted. And you could argue that this would somehow relate to a non-protected idea or information. For example, you could want to make gender studies of literature in the 1970s and try to find out how often would she be named or he, how often a certain female name appears versus a male name. And then you would have some kind of statistical result, some pattern, and some, well, new knowledge in this case. And that is the classical way of doing text and data mining in order to advance the knowledge with this automated analysis, where you only take out semantic information. Then for the training of AI models, however, you do not only take the semantic information, but also the syntax information, which is, you could say, it compares or corresponds to the expression in a work. And since works are being fed into the databases, the syntax information would be the expression part, so to say, the protected parts of the works. And they explain also that extensive use even must be made of the expression. It's the very purpose of generative AI training. And it is even indispensable to achieve an output which would be useful, such as a text, music, or images. Because, well, for example, if you only put the contents of a dictionary into such a database, you would not really get expression. You could not have good texts. Even from emails, they made a trial to have just email conversations, and the output was really not good for the market, so to say. So if you only would copy semantic information, it would not give the output which you know and which the companies want to exploit. Another difference is that for generative AI models, you have much larger data sets than you need for TDM. So for technical reasons, you could say training of AI models itself does not fall under the definition of text and data mining. But there are also legal reasons. I believe the wording and the purpose, because the purpose of reproduction, as you saw from this combination of Article 4 and 2 at the beginning, is only the analysis. It stops there. It's the analysis with the result of such kind of information which I gave in the example on the gender studies. It is different from generating new products, which would be new texts and images and so on, which would even compete with the human works. So the purpose is very limited in my view, even if some, of course, say information is very broad, but I think you have to see it in the context, in the systematic context of the other examples, patterns, trends, correlations, and also in the context of the historical interpretation. In 2019, when the DSM directive was adopted, there was no knowledge about the potential of generative AI. We have even the rapporteur of this directive, Axel Voss, the member of parliament who was responsible. He also now publishes and states publicly all the time that there were no such discussions. This was not in the mind of the legislator, and so the legislator did not have this in mind and could not have foreseen these consequences. And even if you look into the AI Act of 24, which relates to the TDM exception, I think you could still, and you should still, interpret that only as meaning, well, there's a reminder that where TDM in individual cases may apply, maybe in the pre-stage, not necessarily during the training, then the copyright rules have to be respected. So as a very general statement, because also here the AI Act is not a copyright instrument. It is a safety instrument. It's product safety. It's a different area. Different negotiators were there. And there was no time to go into copyright negotiations and details. So that is also a hint that they did not really envisage to regulate or to clarify the meaning of the earlier DSM directive, especially, and I think that's also a question of democracy, because you have to see that, well, of course, historical interpretation is not the most important one, but if a new phenomenon is so fundamentally different, especially in the consequences for, in this case, the whole cultural sector, then you cannot assume that the legislator wanted to regulate this also. You have to give the democratically elected legislator a chance to discuss these issues once they see that the impact on the whole sector is so that they could not really decide it beforehand without a proper discussion. So this chance should be given to the legislator, and therefore I think all these reasons speak for the result that the TDM exceptions do not apply to the training of generative AI models. Here is the German study. These slides will be put up on the website, I think, so you can then copy it from there. There are 2 articles made by the author, Tim Dornis, of the legal author, which have been published on SSRN in English on most important aspects of the study. Now, what are the consequences? Oops. Okay, let me see how to proceed. It's stuck. I tried to... I can also read without... Thank you, thank you. It's anyway my last...
You can use the clicker.
Yeah. Yeah, no, okay. My last slide. Now, okay, if I and some others say the exception does not apply, then the consequence is that the uses for the training must be licensed. Of course, there are also different views. We will hear this from the panel. So in the end, because there are different views around, the situation is legally uncertain. What do you do in such a situation? Well, both users of AI models and the right holders want to have legal certainty. They want to do business. They want to be sure that what they do, at least most of the users, that what they do is correct. And that's why, in practice, at least in Germany, I want to mention very few examples. Especially the biggest one is probably the litigation started by our music collecting society, GEMA, which is one of the biggest in Europe, I think, and the first one worldwide, which has made a lawsuit on these issues. It has, in November, submitted a claim against OpenAI on the use of lyrics of songs, and in January against Suno AI, that is the AI model by which everybody can produce music files, also against the use of the music in this case. And if you go on the GEMA website, they even uploaded some audio files of some very famous, at least in Germany, very famous songs, not the original ones, but the AI version, which they found as an output of using Suno AI, and they are practically the same. You could hardly distinguish from the original. It's stunning. And so they have really good proofs that these works have been used for the training, and their claims are very broad. They include any kind of reproduction which may occur, and also the communication to the public afterwards of, for example, the songs. So in a way, it is maybe a model claim which has the aim of clarifying all of the important questions which we are facing now. And in the end, the aim is to get licensing deals. GEMA has already put, even online, a licensing model, which is based on two columns. The first one would be a license for AI model services, model provider services, which, in order for them to make a legal training, but also to do reproductions pre-training legally, and also to use the AI tools. So any outcome, that they propose 30% of any revenues of these companies, such as Suno AI, from their, for example, subscriptions with users. The second license they, in addition, propose would be, and that's quite far-reaching and maybe daring, but, well, would be against all those who use the outputs of such AI models, for example, as background music in shopping malls or otherwise. So the users of the output, because they argue that even there the original works are kind of contained, even if they are not recognizable. They are still the basis of the uses which take place of the AI product in the end. again, that is maybe also a strategic claim. It is a very far-reaching one, which probably should show the potential on the market, the value on the market, and that all this is happening on the basis of protected works, and that so far, generally, users, the right holders do not get any money for all this profit-making by big companies. So let's see how this claim will go. It's very interesting. Shorter, if I have still time. Okay. The German CMO on literature, VG Wort, also is now offering a very limited license because literary CMOs do not have so much exclusive rights. But in this small area where they have them, they already have concluded, for example, a license with companies to reproduce works for their own internal use. So, for example, mainly chemical industry companies or others who copy articles for their own internal use. And here they want to broaden this license to cover also AI use inside the companies, but it's only for use inside the companies. They must not give out the output, so it's maybe to facilitate the work of their staff members, something like summaries of articles, which can be done by the generative AI with these articles. This has been set up for some quite time, and the tariff is supposed to be published in May, I believe, so it's very fresh. It's not yet being licensed, but the license will probably be offered in May this year. And very new also, we have a collective agreement between the trade union of actors in Germany and the film producers on how the producers may use generative AI in the film production as regards only actors and actresses. This came into force on the 1st of March, so not long ago, and it will certainly be renegotiated as practice may show new needs. This is somehow following up the idea of the Hollywood actors. You remember the big strike, I think last year or before. So similar issues are dealt with there. And then we can see also development where individual publishers are asking their authors to give the authorization for the publishers to do internal Gen AI work. So when the publishers want to offer their subscribers of online articles and reviews the possibilities to make summaries or similar, to make better research. So that is also happening. So far, that's what happens if the legal situation is not very clear. Thank you very much.
There were very interesting points, which I'm sure we're going to take further during the discussion at the end of this panel. So we proceed with Peter Metzai, professor at the University of Szeged in Hungary. He was also awarded a honorary adjunct professorship at the Faculty of Law of the University of Turku in Finland. He is a chief researcher at Vytautas Magnus University in Lithuania and an invited professor at the Université Jean Moulin Lyon.
Thank you very much. Ladies and gentlemen, Kalimera, if I say it correctly. So that word might indicate to you that this is not the first time being here in Greece, although my pronunciation is quite crap. But this is definitely the first time I speak in Greece on a scholarly event, so congratulations to you to have me here. I'm kidding. I'm so grateful. I'm so grateful to have me here because it's just a wonderful experience to meet Greek colleagues who I met before elsewhere, but now so many at the same place. It's just wonderful. And also congratulations to you to put together this panel in such a logical manner, because as you will see, and all the people here will see at the very end of this panel, we are going step by step further to understand, to decipher what AI and generative AI problems might be out there as regards copyright law. My part here is a pitch on TDM yet, but much more focused on the opt-out provisions. So we have already heard about Article 4 in specific. It was already mentioned that if Article 4 is not applicable to Gen AI, then opt-outs might be absolutely irrelevant. I try to develop this argument, or actually I try to criticize this argument, but develop the question further. But again, my focus here is on the opt-outs themselves. To start with, I have to flag, I mean, I have to solicit for this, but anyway, there's a paper I concluded some time ago. I concluded it at the end of 2023, and that matters in some sense, although it was published quite late in June last year. It took some time for the journal to publish it, where someone is just using the mouse on the screen. Anyway. And that's not me. In this paper, I actually called the opt-out mechanism to be a kind of complex equation. I know lawyers don't necessarily like mathematics. I do. And I like this expression here a lot because the whole TDM exception and the whole opt-out mechanism is really a complicated field with quite a lot of unknown factors, quite a lot of unregulated terms that we have to fill up through practice. I only indicated 3+1, I would say, in my article, which really need deeper understanding and clarification from either legislation or courts at the end. The timing of the expression of the reservation of rights, the location, so where should you do that, the scope of the reservation, and the +1 is the declarer of the reservation, which is also a kind of important thing. And of course, I also noticed that there are still a couple of open questions as regards the overlaps of this rule with other pre-existing rules and the ongoing AI Act at that time, again, ready to be published soon, AI Act. Lots have happened since then. So I just indicated a few keywords over there which prompted me to reconsider my, not arguments, but reconsider whether my fresh article is up to date yet or not. So this is something that prompted me to write another paper, which is going to be published once, soon, we'll see, in a book co-edited by Guido Westkamp and Noam Shemtov, which is about, according to my best knowledge, we still don't know what's the title of the book, but AI. It's, of course, about AI, where I paid closer attention to three major questions. The first one is exactly something reflecting also shortly on the previous presentation, whether generative AI training fits into Article 4 and Article 53 of the AI Act. I will keep this short because you have already heard about that, and I want to speak more about the other two. And the other two questions are the AI Act plus the Code of Practice, which is ever since then gaining the momentum. It's a very important document, and of course we have the one of the masters of this document at the table following me as well, so you have to hear more about that from Alexander Poikert, and also case law. I want to sum up what we see about the case law and the TDM opt-out at the moment. I don't flag it on the screen. I already mentioned the term opt-out several times. I don't like this term. We should prefer right reservation because it's really not an opt-out. It might be called properly an opt-back, but in any case, it's a, let's call it reservation of rights from now on. So what about this question? Is generative AI training fitting into Article 4 and Article 53 of the AI Act? Well, of course, you can find a lot of readings out there that argue contra. I also managed to read Tim Dornis's papers, both the German and the English articles as well. We also had a nice kind of debate on that separately. I respectfully disagree with him, but it doesn't mean that he has no real and valid points together with his colleague from the field of technology. I am not willing to criticize the technological questions at this point because I'm not an IT person. But my focus is much more on the legal dimensions. And I have, let's say, three key arguments at this point. The first one is that, in my humble opinion, the CDSM directive was designed in a broad sense. It was drafted with the idea of AI in mind. Of course, I understand generative AI was not on the market at that time, but I would find it policy-wise a real problem if we would exclude Gen AI as a form as a derivation of artificial intelligence from the scope of this rule, because then you could argue quite easily that anything else comes in the future is also outside of the scope of Article 4, practically meaning Article 4 is meaningless. I don't believe that the rule was set up in such a broad, narrow sense to cover only whatever general AI, but not specific, and in this case, generative AI things. On the other hand, if I just look at the language of the directives, this one and the AI Act, I mean, I see that TDM is kind of equalizes reproduction plus extraction. This is also confirmed both by the CDSM and the AI Act. And then to close the circle, AI Act through Recital 105 and Article 53 expressly refers to the ability to use the reliance on TDM in general purpose AI model developers' life. In this sense, to me, at least in a normative way, generative AI is covered by the existing provisions. But this is just one issue, I would say. Let me refer to one important document that was published quite recently. It was kind of indicated to be published in January, but it was actually, I think, February 2 or 3. This is the ECS's opinion on generative artificial intelligence, which I also had the privilege to contribute to, and there are at least 2 more people at the table who signed that, which is often cited nowadays that we doubt that generative AI is covered by the TDM exception. Actually, this document is not stating that. This document is stating something more important. We argued that the TDM exception is not relevant for ex post uses. So it is unable to cover uses that might follow after the model has been trained. So communication-related activities. I absolutely agree with what we heard before. Outputs are not covered by the TDM exception. This is what exactly the ECS opinion wanted to mean. And maybe there is not that much difference in this sense between the copyright arguments of people. So in other terms, TDM exception is definitely a specific narrow thing, not affecting ex post or follow-up or downstream commerce activities. Now, pay a little bit of attention to AI Act again, and at this point I say I try to keep this short as well, because Alexander Poikert is going to speak more about the Code of Practice, which is a very important document following AI Act Article 53, paragraph 1, C and D points. Based on them, the Code of Practice has to give some guidance on these topics. So paragraph 1C speaks about putting in place a policy document, which is a very important rule, I would say, and also joining my colleagues who have written about that, also the ECS did that. This putting in place has to be extended to cover, to mean drawing up, publishing, keeping it up to date, and effectuating such a policy in real life. That's very important, I would say. The policy document must be meaningful. I also agree with that statement that we heard before, that it should be meaningful in line with the FATL of the EU law. And very importantly, Article 53, paragraph 4 says that there might be 3 alternatives to comply with such an obligation under paragraph 1 and C, from which one of these is only the Code of Practice, and there might be harmonized standards or individual demonstration of compliance as well. In the following slide, I am only focusing on the Code of Practice. I'm not involved in practically any of them, but I have more information on that, so this is why I put it here. But again, you will hear more about that very soon. This document, in its second version, published actually only 3 days after I published my first version of the article, so this is why I also had to update my own article. So it was published in December, I think, 17 or so, and which made me a wonderful Christmas period, which includes 11 measures related to this article, paragraph 1.c, including 16 key performance indicators. My point is that this is a nice development compared to the first version, which includes quite a lot of straightforward and important provisions. I only highlighted a few of them, and I also highlighted with red where people have some critical remarks or opinions regarding the substance of these measures. Some people criticize the language, but again, Alexander might say more about that, that the Code of Practice speaks about reasonable and proportionate efforts to ensure lawful access to training data, although the directive seems to introduce an obligation on that. The document speaks a lot about robots.txt, which is understandable, but I don't believe this is the only right and currently existing technology that we have to pay attention to. And I'm very happy because the second version included more. It speaks about other appropriate technologies that developers have to take care of or focus on. I think this is a very positive and straightforward step. I'm very grateful when I was very grateful when I read this document, because the document expressly said in measure 2.7 that rights reservation might be made at the source or work level, which is great because I think this language was missing from the directive, and this is something I also kind of criticized in my original paper, that we need clarity whether the reservation should be made and at the original site where the document was published, or at other places, including the developers' website through internal mechanisms of reservations. Finally, the document speaks some words about the output stage, which I'm not going to criticize here. I personally like the idea of speaking about overfitting, but I understand that this might be not in the favor of every stakeholders. Overall, I think the second draft of the document took very positive steps forward. We are eagerly waiting for the third version. We'll see when it comes out. Most probably I need to update my own paper again. Thank you. But anyway, I'm looking for that. As regards paragraph Article 53.1d, anyway, general purpose AI developers should also publish a sufficiently detailed summary about the content used for the training of the GPAI model. I think there are quite identical arguments for publishing, what that practically means. It's very interesting to see what a summary will ultimately mean. I assume this is going to be a comprehensive but not complete document. The language of the law is clear. It speaks about contents rather than mere data. It's very important. We have to hear more about the content, the protected subject matter that was used by GPAI model providers. Nevertheless, the most important provision of the part of this provision must probably be the sufficiently detailed prong. So we have to understand what it means, and we are eagerly looking forward to the AI Office's template on that as well. I only flag it, I don't dig into deeper detail because time is passing by quickly. There is also an American proposal from California about the transparency of developing AI models. I don't say this is what we have to follow. I only say that people are started to think on what a summary like that should include. You might need to take a look at that, and I will also eagerly compare the two documents at a later stage. And quickly about case law. In my whatever I know, I'm a limited person, certainly, in this sense. I know about 2 plus maybe one more case at the very moment that might be addressed on a presentation related to TDM. The first one is very well known. This is the German Lion case, which is, well, again, everyone should be a pathfinder, or there should always be a pathfinder. That was the LG Hamburg from Germany, that nevertheless included at least a lot of words about what Article 4, Paragraph 3 opt-outs might be. I don't say this is without problems. I'm not convinced whether the reservation involved in this case was clearly formulated or simply covering a mere scraping prohibition. And the most problematic or open question is, of course, whether the human-readable reservation is also machine-readable or machine-comprehensible. I think there will be quite a lot to speak about that. Also importantly, I flagged that, but I saved this argument for the next slide. In this decision, the Hamburg court said that the reservation shall not necessarily be specifically or consciously addressed to certain user, so it can be general or broad in this sense. At the same time, of course, the decision might have consequences, would put English into the forefront. Minor languages might be disregarded as regards reservation. So maybe even Hungarians should reserve their rights in English to make it machine readable. I'm not sure this is really the right direction here. And the other core decision that we are easily aware of, because it was also reported on Clover Copyright Blog and IPCAT as well, you can find the decision online as well, was a Dutch one where the court concluded that the reservation was not proper because it was not machine readable, because it excluded only specific bots. So as I said, I saved one of my arguments from the previous slide for this slide, because it really looks like the German and the Dutch interpretation of how specific, how directed the reservation should be conflicts. That's very interesting, I would say, something for future discovery in multiple jurisdictions. I didn't put the third case on the screen because I still need to reread it, I think 2 or 3 times more, although this is on my country's language. There's at least a court decision from December last year, which I, for some reason, only accessed last week. I didn't notice it's there. For good reason, it's only mentioning TDM in like a very short paragraph, even 1-2 sentences or so. I need to understand the case much better. But by the way, that court decision seemed to suggest that analytical, automated analytical review of facts for scraping and linking purposes might also be covered by the TDM exception. So this is something we have to pay closer attention at some point. Getting to the very end of my presentation, and instead of giving you a real conclusion, I think there are no real conclusions at this point yet, only open questions. I must agree with Paul Keller, who said that there might be no chance for a one-size-fits-all model in the TDM environment. My expression was complex equation. I still believe there are still a lot of unknown elements of this equation. We'll see how case law develops in that. We'll see how the code of practice will clarify that. So I was very grateful when I also heard it here mentioned publicly, or I also saw that online, that the European Commission is also has published this tender to study the feasibility of a central registry. So there is, again, another higher level of review of what we can do or what we can do better. I keep my eyes on the licensing practices as much as I can, because this is a very fancy topic, I would say. I can also recommend you to look for a blog post from Create people, Amy Thomas and Martin Kretschmer, who compared a couple of these licensing agreements. They speak about unknown elements of these licensing practices. Very interesting. And of course, many people start to speak about other technological questions instead of opting out, or machine learning and the like disgorgement of the information, machine unlearning, as you might say differently. So there are a lot to speak about. And finally, what I was, again, very grateful for your presentation before, because I still struggle to understand what really the Paris AI Summit means for us. You said something very relevant points which are not over there, but I will do research, more research on that. I refer to only one thing which I understood from other talks, President Macron and President von der Leyen, who spoke more about we need to invest more into AI. I don't say this is truly a pro-innovation approach to the question, but I am guessing whether regulation is really going to stay as the main direction. I agree with you, by the way, but we'll see what's going to happen. So we are waiting for Godot, but not from Samuel Beckett, but from GenAI and TDM. Thank you very much.
Thank you very much, Peter, for a very lively presentation. I think you gave us food for thought that we will discuss later on. We'll see also this interaction between a private law instrument and a public law instrument and how these two can sit together. And now we're moving on with Alain Struel. Alain is a professor at the UC Louvain, and he also teaches on the Advanced Masters in IP and IT Law. Ah, okay. You want us to move with Alexander? Okay, no problem. Okay, I had the older program. Okay. So, Alexander, we'll take you now then. As professor of civil, commercial, and information law at Goethe University in Frankfurt am Main. And Alexander Poiker is also co-chair of a working group of the first general-purpose AI Code of Practice under the EU AI Act, where he's responsible for developing and refining drafts dealing with copyright-related rules. and he will talk to us about the copyright-related rules in the EU GPAI Code of Practice. He will give us the overview and the state of play. So, 15 minutes.
Thank you. Thank you very much for this introduction and the invitation here to Athens. I will talk indeed about my current side occupation to draft together with a colleague who has a professorship in Ottawa, Céline Castells-Renard, but who is a trained French copyright lawyer. We have the honor, and sometimes it's also somewhat of a pleasure, to draft the copyright-related rules of this code of practice. So what we are trying to do is to specify what it means to put in place a policy to comply with union copyright law. These are the few words with which we deal. We are not in charge of Article 53(1)(d), which is the obligation to draw up and make publicly available a summary of the content used for training. This provision is also of relevance for the copyright holders because they have apparently serious difficulties to find out whether their works have been used for training. But this summary is taken care of by the AI office itself. The AI office draws up a template for this summary. A first version of this template was circulated, to my knowledge, to the stakeholders already, and the summary is available on the Commission website, but I just wanted to say this is not what I am dealing with. I am drafting, as I said, rules that specify what it means to put in place a copyright policy. I'm doing this also in very close exchange with the AI office and the copyright unit of the Commission. The purpose of this code of practice is not easy to understand. An interesting and important source of information is Article 56 of the AI Act, which says that a code of practice should contribute to the proper application of the AI Act. So it's about specifying what it means to have a copyright policy. On the one hand, this would help the AI office to enforce this provision. On the other hand, it would hopefully also help the providers to know what they have to do in order to be compliant with the Act, and that means to comply with copyright. So you see already there are several layers of compliance. We have produced 2 drafts of this copyright-related rules. This was mentioned. The third draft hasn't been published, and I cannot speak about it. So I will speak about 3 fundamental challenges that Céline Castells-Renard and I face when we try to produce drafts for this code of practice. The first challenge is to understand the proper relationship between copyright law, stricto sensu, and the AI Act and the code, which I would summarize as AI law. So what's the relationship between copyright and the AI law? We have heard this morning the AI Act is about facilitation of enforcement. This was Ms. Sakova. Well, what is that supposed to mean? From the feedback we received from the stakeholders, we see a lot of actually confusion about what we are doing. Some say we are redrafting copyright law, we should do it, we should not do it. I'm also struggling to understand this relationship. So here are my views on this. Copyright law and Article 53(1)(c) certainly have the same aim. It's about protecting rights, protecting the interests of copyright holders, with a view also to other interests. But copyright law and AI law, as was also already mentioned, do this in a very different manner. Copyright law, as you know better perhaps than I do, is a law which operates on a very granular level. I have a right, I tell you, you may use it, you may not use it, the price is X. and to the next one I say, no, you won't be allowed to use it. That's kind of the ideal scenario. And this whole body of law remains completely unaffected of what we are doing, right? Copyright law is around, will remain available, can be enforced, is enforced in the US, that's US law, and in Germany and perhaps in Greece, according to the law as it stands. And we have mentioned this in the recital of the second draft, according to which this code is without prejudice to copyright law, and one might even add that copyright law is not affected in any manner. So right holders, I believe, have already achieved quite something when 53(1)(c) and also D were added to the AI Act, because this is a new layer of protection. It's an additional layer of protection that rights holders now have on top of the copyright law. But this new layer is of a wholly different nature, in my understanding. I would, as a German lawyer, I would say this is kind of public law. Right? It's an obligation which is enforced primarily by the European Commission AI Office. There is a debate ongoing whether there is private enforcement of the AI Act. I have my personal doubts about it, but this is an open question for which we don't have to take a position. So it's a public law enforcement. If you don't have a copyright policy or your copyright policy is insufficient, you face fines, right? It's a fine that you face as a company. And also, this AI law is preventive in nature. You have to have a copyright policy before you engage in reproductions. Okay, so it kicks in much earlier. And it also needs to be proportionate according to the AI Act. Various provisions refer to proportionality. And I would like to exemplify this distinction with regard to two provisions that we propose. One is our understanding of what it means to put in place a copyright policy. Our understanding is that this means that you must not infringe. Either you remain within the boundaries of an exception or limitation, for example, Article 4, but we will get to that in a second, or you have an authorization, or you don't reproduce at all, right? But to have to comply with copyright law in a nutshell means to not infringe. It doesn't mean there is no obligation, as far as I can see, for model providers to enter into a license contract. This is not what copyright sets out, beyond Article 17 perhaps, that you are required to take a license. No, the consequence is you must not use, right? And this is what we are trying to achieve. We are trying to draw up measures that make sure that in the development and placing on the market of models, no infringements occur. Well, it might not be a zero infringement level of compliance, but at least no systematic ignorance towards copyright. This is why we focus on standards for the rights reservations, and why we also specify in the second draft that what we do is without any prejudice to the right of affected rights holders to reserve their rights in any appropriate manner. The rights holders can do it in whatever way they like, and if it's disrespected, they can enforce their rights in civil courts. But we regulate on a more general, let's say, systemic preventive layer where we search for standards. And my reading of the rights holder responses is also that rights holders understand that standards have to be established to keep up with the scale, right? We are talking about millions of rights that you hold and billions of reproductions that the providers engage in. And it's very difficult to do this on a one by one. No, it's impossible to do this on a one-by-one structure. Okay, second problem, and I think that was elegantly explained by the two speakers preceding me, there is a lot of uncertainty when it comes to copyright law. So we have a problem here. We are supposed to draw up a code for the compliance with copyright law when the copyright law is very much unclear. So it is not clear whether Article 4 applies. It is not clear what a machine-readable rights reservation means. It is not clear what appropriate rights reservation means. With all these uncertainties, we have the task to produce a document which says, well, take these measures to comply with, well, what? The rules are not settled. That's just a problem. And one response that we have for the time being adopted is that we say if signatories engage in text and data mining according to the CDSM directive, then they have to do that. And the if means we don't know whether it applies. Good. Then we don't have the standards. There is standardization ongoing. We have referred to the robots.txt because that was the technical standard which was also already adopted by providers. Rights holders often don't like it, but it's apparently the only one which is adopted at grand scale, and we have a full commitment to comply with that one, plus a best effort commitment to comply with other not yet specified standards. And here we have another big uncertainty because all the nice studies that we have heard about have not been published. So how am I supposed to figure out what the right standard is? Okay, third and last problem that we are facing, the AI Act is also very new. It's actually not yet even in force, and there are a lot of questions about its interpretation. And we must not go beyond the AI Act, but we shouldn't also not fall below what it requires. And that is another challenge. Just let me give you two examples. One is the distinction between models and systems. The Article 53(1)(c) applies to model providers, not to system providers. Now, we would like to have a commitment which essentially says a model should not be an infringement machine. You should not place on the union market a model which results in systematic repeated copyright infringements. But the problem is this output is not necessarily controlled by the model provider because it's controlled by the system provider who might be a different company. So the maximum that we could say is the model provider should take some mitigation measures to avoid that the model becomes an infringement machine. And our current proposal is prevent overfitting or memorization. We'll see whether that survives because the counter-argument is, well, that goes beyond what the AI Act says. Okay, 1 minute. And then we come to the Achilles heel of all of our efforts, and that's the territorial scope of application of Article 53(1)(c), which is also hotly debated. As we all know, copyright is territorial in nature. So if you reproduce in the United States of America, you are subject to US law and not union copyright law. However, the famous, at least for me, it's now famous, Recital 106 says any provider that places a model on the union market has to comply with the copyright compliance obligation, and now I quote, regardless of the jurisdiction in which the copyright relevant acts underpinning the training of those general purpose AI models take place. You could read this and that's a recital, it's not the text of the Act, as stating, well, if you place a model on the union market, you have to show the AI office that you had a policy in place during the training which took place in the US that you complied with union copyright law. That would be the product safety or perhaps even supply chain reading of the AI law, but that is somewhat in it has an interesting relationship, perhaps, let's say it like this, to the territoriality principle. And it is argued in the literature that this is an extraterritorial application of union law, which might even run afoul of certain international, well, perhaps, rules. Good, so that's a big one. My time is up. I just want to say the code of practice shall be ready at the latest by the 2nd March, so that's in less than 2 months. So there is intense time pressure in spite of all these uncertainties. And there are various scenarios. So the best one is there is a code and it is signed by a significant number of providers. Even better, the Commission may approve the code and give it general validity that it would then also apply to providers who have not signed up to. But it may also happen that there is no code on May 2nd, and that the AI Act will enter into force in August without a code, and then providers will have to apply with that little sentence, put in place a copyright policy. And maybe then later, the Commission may produce its own common rules as is set out in the AI Act. So in one way or the other, this obligation to put in place a copyright policy will come into force, and we lawyers will have much fun in discussing it further, perhaps also today. Thank you.
I think, Alexander, you made crystal clear how challenging this task is. And now we can safely move on with Alain Stroel, who is a professor at the UC Louvain. He also teaches on the Advanced Masters in IP and IT Law at the University of Alicante. He's a lawyer at the Brussels Bar, and he's now with the firm Pure Stone. He will be speaking to us for a theme that is very favorable to right holders. He will look into how the future system for remunerating creators should look like.
Thank you. Well, there is a long title in the program. I even propose a longer one that you can read, The Risk of AI Slop and AI Model Collapse, and Why We Need Additional Incentives and a Dual Right System to adequately feed the next generation Gen AI models and to remunerate creators. Oof. Well, at least I could stop here. That's the advantage of having such a long title. And I can take the moment to thank the organizers for this excellent organization, for the scenery inside, because it's nice premises, and of course outside. We have the view on the ancient Greek culture, always a pleasure, especially under the sun. But we had it in the Benelux before coming, for once. Okay, that's longer maybe even than the title. I'll try to explain what I want to make as a point today. And it's an advocacy. So I'm very old, so I can still think about the future and be bold. We know the problems that AI has created, and I think the great backlash that started a few years ago. We had the demonstrations. More recently, we had in the UK with the proposal to introduce more or less the same system as the one we have in the EU. There was as well some backlash, and then the government withdrew the proposal. I will start by reminding some shifts in value creation. I don't think it's that important, but we have all experienced, I think, the situation of some creative people who are, I think, partly suffering from the competition with the new tools. And I was struck by a reference, to, for instance, to the trends in demand for online freelancers. And over that period, since ChatGPT was released, there was a an important decrease in posts for online gig workers, especially creative ones, across different job types. Of course, some workers can upskill, reskill, and they will use probably in their practice, so that's a positive side. But I think there will be, and it's happening already, a displacement of creative workers. Should we care? Yes, to a certain point, but I think the history of capitalism or society is about creative destruction, so it has some positive aspect as well. And should we care more than the displacement of other jobs like white collar? Maybe, yeah, because it's about creation and we care about that. But I think we could be more optimistic about integration of those tools in different practice in the future. And there might be some similarities with the way photography was integrated in the 19th century in different practices. But I think it's clear that in the short term, at least, there is a substitutive effect. And of course, a large language model trained on short stories will be able to create competing short stories, as at Newton Rex said. And an AI image model trained on stock image will be able to create competing stock images. So the competitive aspect, the substitutive aspect is there. I think it has some implication in terms of reduction in demand and readiness to pay for human content. So that's a situation, and I think for the law, we have to take that into account, because the law, I think, should care about those who might not that easily transition and who are more vulnerable. I think the issue of vulnerability is an important one in the law. So I think we need corrective measures. It's a matter of redistributive justice, and I'll speak about a remuneration model. But at the same time, I think we have to take seriously the other justification for copyright. Copyright is an incentive system, and I think we need today strong incentives to have more human-generated data in order as well to be able to train the next models and to improve them in the future. So I think we can use the incentive approach that I think is shared probably by the tech sector, and that's what I want to make as a point, because of different risks. The first one, legal uncertainties, has been already stressed. I'll say a word on the AI slop and AI model collapse. On the increasing divergence and uncertainties, we spoke a lot about the situation in the EU, but it's not better in the US. On the contrary, I mean, there are so many cases going on, and we don't know exactly when it will be finished. It could take still a long time. So it's interesting when you look at those cases, most of them in the Northern District of California or Southern District of New York, and there is a recent decision in the Thomson Reuters versus Ross Intelligence, which is interesting in interpreting the fair use exception, because it all turns around the conditions for a fair use. But I think that fair use is maybe not simply, as has been said, the right to hire a lawyer and take one chance in court, because it's really difficult to anticipate the outcome of a case based on the flexibility of the fair use exception. And it's not a bad thing, because I think we need uncertainties in the law. We have them in Europe, they have them in the US. Interestingly as well, those cases have been brought on the basis of unfair competition and unjust enrichment, which have, of course, I mean, those are legal doctrines. In the US, we know them in certain civil law system, unjust enrichment. But you see that there is a moral dimension or a justice dimension. I won't say much about the recent case because that's US law. I'm a bit doubtful about the case because it concerns the Westlaw head notes, which are considered, like based on this example that the court used, are considered as protected. But when you see what the West head note does with the case opinion in a well-known US Supreme Court decision, the Feist case of 91, there is not much originality. But nevertheless, it was considered as protected by copyright, and then the court applies the 4 factors of fair use. And at the end, mainly because of the 4th factor, the effect on the market or on the value of the work, that weighs in favor of Thompson, which wins, but it's a summary judgment, so it's the starting of the discussion in the US. They are both competing in a market, which is the market for data to train. It's interesting that the court sees that market and the competition on that market. I don't have to say much because I share the previous presentation on the doubts about the application of the text and data mining exception. There is a textual argument, generate information is not generate content. Nobody spoke about content at that time. There are arguments based on the travaux préparatoires, and to what stage exactly should the exception apply? That was already discussed. I share the uncertainties brought forward by previous speakers. Another one that was not underlined so far, and it's in red here, there is a condition for the application of both exceptions, it's the legal access to the works, and that creates as well a lot of uncertainty. So what is interesting is the possibility to have a remuneration associated with TDM. We know it's impossible based on some recitals of the directive, because it was considered that there would be only a de minimis harm in that case. But concerning Article 4, it's open. It's not decided in the recitals of the directive. When I asked the question to ChatGPT, he gave the wrong answer, but he's very compassionate, he's emphatic. So he thinks that even for Article 3 exception, they should be, and that the legislator decide that there is an obligation to provide equitable remuneration to the relevant right owner. That's a translation of the response that I got. Very emphatic, but wrong completely on that. So there is uncertainty. It will stay because in the US, the procedure will take as long as for the Google Books case, which was as well a fair use case, a little bit similar. It takes 8 years. So they will have uncertainty. We have it in the US for different reasons already mentioned. Now, I move to maybe something that is new for you, and the term probably is a bit strange, AI slop. It's interesting to see it appeared on Wikipedia as a new entry. And what does it cover, AI slop? Well, it's probably something that we have all experienced, and they give the example of the shrimp Jesus that you might have seen, a shrimp Jesus. That's slop, so it's low quality, it's content which is vague with no real point. Basically, it's a synonym of AI garbage. And I think we will have more and more of this AI slop coming in because people are starting to use that. So that has some consequence probably. For the training of the future systems, because they have to be trained, usually they use online sources, and that might have implications on the quality, of course, of the training. AI model collapse, that's another possibility. It has been documented by some researchers that at some point, if the training is primarily done on synthetic data, on machine-generated data, then there is a risk of reduction in terms of diversity and quality of the data used for the training. So at the end, it can reinforce some initial biases, some inaccuracies, and there is a risk, according to some experts, of the so-called AI model collapse. I just raised that because I think it's a good argument in favor of stronger incentive to have data produced by humans. And that's where I have to come now. What is the system that we should maybe push? At least I'm advocating a dual system that I now present. Recently in the FT, there was an opinion. I think we can share that. The AI copyright wars, especially in the US, need a market solution. But I think we need something more. and that's what I will explain, practical measures and maybe a legislative fix as well. And that's my bold defense of this dual system. It's a dual system to reinforce the incentive for creation by humans. I think in the present context we need that. And that's why we need, on one side, an improved market solution, and on the other side, a new unwaivable right of remuneration, but only for persons, for creators. I briefly present that, and then I stop. First of all, improvement of market solution. That has been mentioned already today by some speaker, Sylvie Forbin, for instance. Because the licensing option is a good one, but I fear that it will be mainly, if not exclusively, in favor of large right owners. At least that's what's happening if you look at the contracts, for instance, signed by OpenAI and other platforms. So it's only the large platforms, the big right owners, like the big press publishers, the content aggregators, which will be able to make those contracts. So we have to improve the whole copyright infrastructure so as to facilitate micro-licensing that involves different parties and maybe directly the creators or some intermediaries like collectives in the meantime. But that's a huge work, of course. It's not a legal one. We need practical measures in order to standardize. And not only to standardize, I think, the opt-out expressions. We should go further and do both. The standardization of the opt-outs maybe, but as well of metadata to allow micro-licensing that could better favor the creators. But that's probably not enough. I'm in favor of adding a new unwaivable remuneration that exists already in different countries, and we have it in Belgium, it exists in Spain, in certain cases in Germany. So that's a residual remuneration right that should be parallel to the exclusive right. That's very important because we are used to remuneration rights that replace exclusive right, like for levies, private copying. I think that's a new model of right, and it's important to have that in mind. It should be reserved for physical persons, maybe under certain conditions, some terms of registration. It should be an unwaivable right that could be valid towards AI developers. It could be exercised through collective, and that could be mandatory. And it would be triggered by the conclusion of licensing deals with other right owners, or there could be other triggers. And I think for that we need a legislative fix. We need some boldness maybe as well from legislator to tackle the issue. And I think at EU level we could have just a building blocks for this right of remuneration that could then be maybe adjusted in different national systems. That's of course to discuss. And there could be a linkage between the two, because I think that the fully market-based solution, if it takes into account the interest of the creators themselves, then it's probably the best solution. If they could manage all the metadata and organize the micro-licensing directly and get something, that's the optimal. But probably it will be very difficult. So the residual remuneration right could be considered as a conditional or contingent solution in the absence of an efficient and fair market solution. That's how I would link it. So there might be a possibility of phasing out of this remuneration right if the market conditions change. That would be, this linkage would be an incentive, of course, to improve the market mechanism as well. So that's why I push for this linkage. A quote to finish. Artificial intelligence, said Kate Crawford, is a registry of power. We have to take that into account. Thank you very much.
Very much. I guess this will be a remuneration for everyone, also for non-EU citizens, I guess. So we're moving on to our last but not least speaker, Marina Markelou. She's an assistant professor at the Faculty of Law of the University of Groningen, and she will be speaking to us about the obligations of open source developers under the EU AI Act. I'm not seeing
εδώ.
Until we fix the issue here, we can take questions, if you wish, to the speakers that have already presented their papers. Are there any questions? If yes, please raise your hands and then tell us who you are. I see a hand down there. Could you please stand up so that we can see you? Yeah. Hi. Is there a mic that we can take to the person asking the question? There's no mic? Okay, it's coming.
I'm Luca Cazzelli. I'm head of the CMO EDEM for music rights. I'm not a lawyer, I'm an economist. And I wanted to put a question for you because I've missed it in the discussion. In all markets, there is a structure of the market. And in this market that we're talking about are creators who are single and many, many creators. There are big companies, which are AI providers, and there are some institutions. Now, my question is similar as a subsidiarity argument in the EU. Who takes the responsibility for identifying the work coming out of the machine? Who should do the licensing? Who does the negotiations, and at what level? And what do you think would be the bargaining power of individual creators in their negotiations with large providers? Now, we heard in the morning in this very interesting first presentation about the human-centric and the principles. Shouldn't the protection of rights holders themselves be a principle so that CMOs like ourselves can actually deliver what we're supposed to deliver? And so I would like to very much hear your views as to where should the licensing and who should do the licensing. Should it be at the individual's level? Should it be at the CMO level? Should it be at the EU level? And who has the bargaining power to do these negotiations? Thank you very much.
Thank you for your question. I don't know whether we have any volunteers to answer. Okay, Silke, go ahead.
Okay, I can try. Thank you for your question. Who should do the licensing? Well, very simply, those who have the rights. So it is the exclusive rights of reproduction mainly, also for the output, then later the communication to the public. And this depends on the branch of the market. As I said, in the music field, the GEMA could rely on the exclusive rights because its members, as a CMO, have mandated the CMO to manage these rights. But our literary CMO does not have to a big extent these rights just for internal use in companies, because these rights in the literary field are usually with the publishers. So the authors have transferred them to the publishers, and then it's up to the publishers to address the OpenAI, for example, and that's what we see in New York Times against OpenAI, and in the US a lot, and maybe in the future also here. So yes, of course, for individual authors, it's I don't see a real chance because it's much too costly to have such a litigation, except maybe for micro-licensing if it will happen automatically. If this will be a technical system which would be able to be installed, but we don't have it, at least yet. So I think it's collective in nature. Even the trade union, which I mentioned from Germany, it's collectively all the actors together who did a deal with their film producers. There are certain uses where, in order to have enough bargaining power, we have to get together, and even smaller CMOs, I don't know whether they should, for this purpose, get together on the European level and address the big providers. But maybe now one first has to wait on the outcome of the GEMA case, and then it would be useful after that, if it would be a positive one for right owners, to maybe get together as on the European level as CMOs. But that's future.
Thank you, Silke. I think it is still uncharted waters in many respects, which means that for the time being, in my view, nothing has changed with regard to the normal licensing of rights. However, one issue which is very important for CMOs is whether they should accept to license rights for works that are AI generated. And this is an issue there. Are these works protected? Can they be represented by CMOs? This is a very interesting issue, perhaps we could discuss later. Is there any other question we can take? Oh, are we ready, Marina? We're ready? Okay, then we'll keep the rest of the questions later.
All right. So thank you. Καλησπέρα. Έχω τον άχαρο και πραγματικά δύσκολο ρόλο να σας διακόπτω από το φαγητό και να είμαι και η πέμπτη. Ελπίζω να σας κρατήσω το ενδιαφέρον, γιατί θα μιλήσουμε για ένα θέμα το οποίο λίγο ξεφεύγει από τα τετριμένα. Έχει να κάνει με τις υποχρεώσεις ενός developer όταν μιλάμε για open source AI. Και τώρα θα κάνω switch στα αγγλικά προς σεβασμό στους συναδέλφους και πανελίστες. Λοιπόν, thank you very much. So, ex-Google CEO warns Eric Schmidt recently in the AI summit in Paris, stated that Western countries need to focus on building open source AI models or risk losing out to China in the global race to develop the cutting-edge technology. The warning comes after Chinese startup DeepSeek shocked the world last month with the launch of R1, its powerful reasoning open large language model. So, if we don't do something about that, China will become the open source leader and the rest of the world will become closed sourced, Schmidt told the Financial Times. Open source AI models are in widespread use, enabling developers around the world to build custom AI solutions and host them where they choose. And this is happening faster than one might think or realize. In a survey that took place in 2024 and reached out more than 2,000 people coming from the community, software development, in the US, Brazil, India, and Germany, regarding the use, the experience, and expectations around generative AI in software development, nearly everyone said they had experimented with open source AI models at some point. And it is true that for AI, society needs at least the same essential freedoms of open source to enable AI developers, deployers, and end users to enjoy those same benefits: autonomy, transparency, frictionless reuse, and collaborative improvement. Open source AI not only enables research and development on more capable AI models, but also progresses on other issues, such as explainability, or biases, safety, or efficiency. The EU policymakers were concerned about the impact of AI Act on open source. And they were rightfully concerned because during the negotiations, they saw the emerging of AI models like Bloom, Stable Diffusion, and AI systems like Llama 2 or GPT-Neo that claimed that they were open, but they were not open actually as such, as recognized by the OC community. For instance, Llama 2 made its model weights available, but nothing else was open. for Euractiv reported that one point of debate until the final hours was how the EU should address open source AI models that developers make freely available to the public. And they did introduce some exceptional rules for open source AI models and systems. But did they succeed on their mission? Or did the complexity of these new rules make it harder to bring open source AI in the EU? In other words, let's imagine an open source developer navigating this new landscape. Will she feel comfortable and reassured that everything is clear now after the new legislative piece? Does she know what are her obligations if she wants to release her model in the EU market? I'm not so sure. So today we're going to give an overview of the obligations of open source AI developers by trying to see the law, and specifically EU AI Act, through the eyes of an open source AI developer. So the first step is understanding the context. Setting a uniform legal framework for the development, the placing on the market, the putting into service, and the use of AI systems in the Union is a very ambitious task. And at the same time, taking into consideration the open source AI community, whose activity is on the rise, with academic initiatives, startups, and other players leading the way in open innovation, is even more challenging. And accordingly to the practice, there is a spectrum of openness, and can include anything from making the training and evaluation datasets to shape an AI model publicly accessible, to release the code under the open source software licenses, to making a mode's parameter settings publicly available, to providing documentations like model cards and datasheets. In light of this complexity, the AI Act cares for scientific research and development activities on AI systems and models only when they are placed into the market or they are put into service. In other words, if you are an open source AI developer and you develop a system or a model exclusively for research purposes, you are not affected by the regulation. In practice, though, this is very difficult to be determined, as very often there are strong and inherent collaborations between research public institutions and private players that end up having a commercial interest. Think about PyTorch, the most dominant AI development framework right now. It was initially developed for internal use by Meta, but was released publicly in 2017. While PyTorch operates as a research foundation under the umbrella of Linux Foundation, it continues to be financially supported by Meta. The employees that it has, its former Meta employees, also allows Meta to shape the work practices of researchers so that new AI models could be easily integrated and commercialized. Moreover, as an open source AI developer, you should keep in mind that irrespectively of where you operate, or no matter where you develop your AI model or system, if you release it within the European Union, or if people in the Union are going to get affected, so you fell within the scope of AI regulation. Article 2, paragraph 1A, C, V, and F explains it in details. Secondly, depending on the role that you might have along the value chain, that is whether you are a provider, a downstream provider, a deployer, and depending on the produced outcomes you are going to develop, so AI system, general purpose AI system, general purpose AI model, and so on, you have to see and what are your obligations, because the obligations are clearly changing. In the light of above, if you are an open source developer of an AI system and you release it under a free and open source license, what does it actually mean? We will see that. You are not affected by the AI Act unless this AI system released is a high-risk AI system, or this AI system is a prohibited AI practice, or this AI system is related to the detection and labeling of artificially generated or manipulated content under Article 50. And then, in the above cases, we have the application of Articles 25, paragraph 4, and other obligations as well. And then, if you're going to be a developer or of an open source general purpose AI model, and you release it under a free and open source license, and you are not presenting a systemic risk, then you are exempted at last from the transparency-related obligations of Article 53, 1A and B. That is to draw up and update technical documentation of the model, etc., etc. But you are still obliged to fulfill your copyright-related obligations as they have been stated in Article 53, 1C and D, that is to produce a sufficiently detailed summary and to put in place a policy compliant to the European copyright law. We have heard so far many interesting things. I'm going just to mention one slight thing. With regards to the policy, we have really taken into consideration the fragmentation of implementation of the TDM exception in 27 countries, the fact that we don't even have a Union Copyright Act, and taking also into consideration the fact, as Professor Peckert already told us, that an open source general purpose provider could not control the chain when the model is going to be released because he's not controlling or she's not controlling the integration of the model within the downstream, AI systems. So this is a very, very, very challenging task that we are asking from developers. And there are still open technical questions about the standards, and especially now in machine-readable formats, we have the robots.txt files for websites, and we have tools like Spawning API, that they are effectively a good start. If you're an open source systemic GPAI model provider, and you meet the conditions as defined in Article 51, like you are having a systemic risk, so then you have to comply with all 4 obligations of Article 53. But the $1 million question here is the following. What does it mean to be an open source AI developer under the EU AI Act? You are an open source developer, so you actually know what does it mean, right? No. Why? Because you have to understand what does open source AI means under the EU AI Act and not under the OSI community that you are participating. And this really is a big, big problem. So we have so far the EU AI Act, Articles 53, paragraph 2 and 54, paragraph 6, and they are stating that we have an open source AI when we have publicly available parameters, weights, documentation on model architecture and model usage, and we have a license. This model is going to be released under a license that allows access, usage, modification, distribution of the model. And we have at the same time some recitals, and I remind you that the recitals are not legal binding, that they are used to explain the dispositions and the provisions, and they are not binding as such. And there we have some essential characteristics of open source AI components. So we need not to have any kind of monetization. We need to enforce the obligation of attribution of the original provider, and we have to implement a share-alike obligation of the initial licensing terms of distribution. And we have a kind of definition of open source AI under Recital 102, according to which software and data, including models released under a free and open source license, allows them to be openly shared and where users can freely access, use, modify, redistribute them or modified versions thereof. Three key points. We don't have any kind of reference of AI training data sets there, so we only have the reference on data. And we are wondering whether we are going to let the community self-regulate or not. And we don't have any kind of consideration with regards to the new emerging responsible AI license. That is another wave that is coming up now, and it concerns AI license that touch upon the misuse, against the misuse of license and against the harmful content that might be produced within, this process. So just to wrap up and some takeaways for you. So we are talking about transparency, but transparency for whom actually? Because it is much less obvious how the information that companies disclose will translate into action and whether it will yield substantially greater accountability, as only a small number of actors will have insight of these disclosures. And we don't want to create a situation where open source GPA models will be less transparent and less well documented than the proprietary ones, because then we're going to create an instrumentalization of the law. And why, of course, we did not want to include the data training requirement, it's a practical discussion because no open resources are sufficient enough for training large foundation models. And their modes of modifying AI systems do not depend on the openness of the data. And this is a valid argumentation. With regards to the terminology also, we have many challenges really to face with. We have OZI, like the community, the open source initiative community, that they're using the term foundation model. And we have AI Act, that it uses the general purpose AI models. Then we have other legislative pieces that they are using high impact models to define the models with systemic risk. The already complex landscape is being even more complicated when we don't have a commonly acceptable agreement on basic definitions. It undermines the effort of effectively regulating, it provokes legal uncertainty and mistrust. We need to agree in an established definitional standard in the context of open source AI, like the one that we have already in the context of open source software. But we need to let the community work towards this direction, and we need to establish a robust transparency requirements in the EU for all GPA models. We need to do and to be clear on what is open and what is not open, how much open it is, and we need to understand what AI system and certainly what AI systems do not accomplish. Full openness is not always the solution. Meaningful openness might be the solution. Thank you very much.
Thank you very much, Marina, for this excellent presentation. I think now we're in a position to take more questions before lunch. So, who wants to ask something? Go ahead. Bernd, do you want to stand so that everyone can see you? Thank you. Yeah, we can hear you. Can we fix the mic, please?
Okay, maybe now.
Okay, it does work now.
I fixed it. Okay, my name is Bernd Jugenholz. I have a question for Alexander Peukert. Thank you for your presentation. I know you're now seen as the ultimate authority on the AI Act copyright interface. So I have a question to you. I was happy to hear a little bit about one of the problems that has been puzzling me when reading the AI Act, Article 53, that you underscore that there is a difference between an obligation to put in place a policy to comply and an obligation to comply, if I'm summarizing what you were saying, and that you saw the focus of the AI Code of Practice that you are deeply involved in basically clarifying that. Could you say a few more words about how you see that difference? If you look at the text of Article 53, it doesn't say AI providers must comply, but they have to have this policy to comply. Where exactly is the difference? intuitively, I would say there is a difference, otherwise other language would be used. But I'm just curious about your opinion.
Well, nobody wants me to kind of start again with my presentation, but so my understanding is that we draw up a kind of template for the internal policy, which would then be implemented to avoid copyright infringements. And that is already, if you spell it out like this, it kicks in much earlier. It is of a much more general nature. You have to have procedures. You have to have, procedures mostly, measures you have to take. And at the end of the day, the legally interesting question is also at which point do you violate the law, So you infringe a copyright as soon as you cross, a tiny bit the border, the limit of a limitation. With regard to one single right, that's enough. But would that be enough to establish a violation of 53(1)(c)? No. 53(1)(c), in my view, but that will be decided by the AI office and the Court of Justice in perhaps years to come, is when there is no copyright policy, if you have to have one. That's a very interesting question. And if you have one, it is insufficient. That could be a case. And even you could violate if you have one and it is sufficient, but you don't implement it. Could be another case. But even the latter one, which is most closely to a copyright kind of infringement case, you would perhaps imagine a case where you have where you start a crawling and you you don't implement a certain opt-out standard, right? And that could be said to violate 53(1)(c). However, if you could imagine such a case that you have implemented a rights reservation standard, you honor that, but for some technical reason, you still crawl and scrape a content and use it. That would be a copyright infringement, possibly, but it's probably not, potentially not an infringement of the AI Act.
So, thank you for that clarification. So would you expect, you've been working closely with the AI office in drafting the code, that the enforcement or the supervisory and compliance role that the AI office has vis-a-vis the AI Act will concentrate more on looking at the actual policy than looking at the entire world of copyright compliance?
I don't know. I don't know. You would have to ask Commission representatives, and that depends also on the resources that they have. But sure, I mean, if you have few resources, no, I should stop here.
Go on. Okay, thank you.
Thank you, Bernd and Alexander. I would like to take this opportunity to ask Silke something. You talked about this Gamma model, and you said that it has mainly two limbs. One is licensing model provider services for training, and the other is licensing users of the output. And my question is, how Gamma would license users for the output if this output is considered to be an infringing output, if it believes that model service providers should first take licenses in order for this output to be legal? I mean, are they going to license illegal output? How does that work?
Well, I'm not Gamma,
so
I don't really know that. No, I think this is,
Isn't that a bit problematic in its conception?
Yeah, I didn't see the writ. I mean, there's a submission used. So the output use is a use of the original works, even if you don't recognize them word by word.
Yeah. It's a bit unfair asking you, I know, because you're not Gamma, but it was interesting to learn about it. Are there any more questions? no more questions, so let me not stand. We have 1 hour for the lunch? Yes. Okay, so it's 3 o'clock, we resume. Thank you all very much.
Ναι, αλλά...
Είναι πολύ σκοτεινά εδώ.
Ναι, δεν μπορείτε λίγο να τα πάτε λίγο πιο ψηλά, λίγο...
Όταν θα έρθει η ώρα, ο ηχολήπτης
βλέπει. Το βλέπει εκείνη τη στιγμή και το ανοίγει, γιατί μου είπανε να το πατήσω γι' αυτό.
Είναι οκ. Μπορούμε να ξεκινήσουμε. Αυτό, όταν ο ηχολήπτης δει να πιάνει το μικρόφωνο αυτό, θα το...
No.
One, yes, okay. So, ladies and gentlemen, let me welcome you in this session too. Let me express my joy and how honored I feel by this invitation in both of my capacities as the Professor of Copyright Law in Law Faculty of University of Athens and as the Dean of this faculty. So we shall proceed in this session with our distinguished guest speakers. And please let me declare in advance that Professor Koumandos, whom the successor I'm supposed to be, had a particularity, was stuck with the clock. So I'll try to ask you for your aid in order to justify that I'm his true successor. So I shall pass the floor to two fair ladies, distinguished ladies, Professor Papadopoulou and Dr. Sophie Grete von Rosen. They are already vastly known. Ms. Papadopoulou is Professor of Intellectual Property Rights and the head of the IP Law Group in Stockholm University, member of the Research Council of the Law Faculty of Stockholm University, chair of the IFIM, that's Institute for Intellectual Property Rights and Market Rights, and the editor-in-chief and founder of Stockholm University Property Law Review. What actually is even more interesting is that Mrs. Papadopoulou is also author of several books and articles in the field of intellectual property as well as in regulatory rights. Ms. von Rosen is already a member, supervisory officer in the Swedish Property Office. She is, of course, the Swedish representative of the Nordic Supervisory Network on Collective Management of Copyright, a lawyer of Swedish Artists Association, and also a player of classical music or jazz. She has performed some Christmas concerts. Is this also true? So it's a multifaceted personality. I pass you the floor. You have 20 minutes, both of you. And of course, we are keen to know the Swedish particularity. We usually speak of the ECL, extended licensing, collective licensing, as the Nordic model, but which is actually the Swedish model or the Swedish subcategory of this model.
Very happy to hear. Thank you.
Yes.
Καλησπέρα. Thank you very much. Just testing the mic. I don't need it. It's rather interesting being here in not only my home country, but also the city I was born and raised, representing Sweden. But okay, I will do my best. Okay, first of all, it is a huge honor to be here. Thank you very much for the invitation. Being here at the Hellenic Copyright Organization, an organization with a long-standing role in fostering copyright practices and development, and actually one serving as an inspiration and support for the work in Sweden. We usually talk about the Swedish model in Greece, but when it comes to copyright management issues, we talk about the Greek model in Sweden, which is rather nice. We are still far away from having the same kind of well-built-up structures like yours, barely celebrating 8 years since the implementation of the Collective Rights Management Directive. Should I? And maybe you are wondering why we're standing here together. We are not representatives of the same organizations. I'm a professor of private law, and Sophie here is working at the IP office, supervising CMOs, collective management organizations. So why are we interested in the same things? Well, some years ago, I started engaging in an interdisciplinary project looking into, among other things, women in the film industry. And from that, I entered the field of contracts in the film industry. And while I was doing this work, it involved a lot of field work, empirical studies. I realized that you cannot talk about contracting in the film industry if you don't talk about collective management of rights. And this is where my interest came about. And Sophie?
As Francesca said, I'm trying to be close to the mic. Hope this is fine. Yes, I am since 2021. I'm a member of the Swedish Supervisory Board. And that's a truth with modification that I only have a background in law. I always feel a bit like a lawyer in disguise. Really deep inside, I've always been interested in policy making and implementation. And so starting at the Swedish Intellectual Property Office, I got involved with overseeing the way we have organized our organization. And again, you don't know this, Daphne, but I looked at you 5 years ago, 4 years ago, 3 years ago. We've had you as an inspiration, so it's really, really great to be here. Yeah, we got in contact because of your project with film contracts and the organizations within this field. And we thought that our point of departure today would be how is this development of the Swedish collective rights management structure? Again, this is a structure that has developed in a little bit of a regulatory void. We've had no specific regulation on collective rights management. So has that impacted initiatives such as the CRM directive, but even the DSM directive on governance and control?
So we propose to share our thoughts today by first providing you an brief overview of the Swedish collective rights management market, mainly because it looks in a different way than, for instance, here in Greece. Make a presentation of a study, the study I'm working with, and some conclusions I could draw from that study on contracts within the Swedish film sector, and reflect on the potential role of organizations managing rights collectively. We will also discuss some thoughts on the challenges of governance and control in these organizations, and we will finally briefly reflect on the concept of accountability.
Can you hear me? Can you hear me? I think I might use this because I find it hard to stand still when I talk. So, collective management in Sweden. Do you hear me well at the back as well? Yes. This is actually a quote from our Ministry of Justice. First came the organizations, then the agreements, and after that the regulation. This quote comes from actually a meeting where I had the question, how have you regulated to make it work? And that question took some time to reflect on because we've had no regulation. When the organizations came into being, this is more than 100 years ago, I would say 150 years ago, the trade unions started being strong in Sweden. They came first. Then came the agreements, lots of negotiations within the labor market field, within the housing market field, within the insurance field. And first after that had been around for about, well, I would say 50 years, then the collective rights management agreements came. And fast forward until 2017, again, this surprised me as well. We had no regulation at all. We had other frameworks through which we regulated organizations, but not collective rights management legislation. So Swedish labor market norm. Do you know what this is? You know what this is?
Saltsjöbaden.
Yeah, this is a very, very famous picture. I think everybody, my generation, knows this because I'm born in the 70s. 1938, there were huge conflicts in Sweden, and we had this famous agreement being signed at a beautiful hotel called Saltsjöbaden, where the representatives of the industry met with trade unions. And this kind of norm that was cemented there has been a norm that's been affecting, I would say, so many parts of our society, of course, as well, copyright. The norm, or the Swedish model as it's been referred to, kind of pushes for negotiation rather than legislation, which I think it was interesting to this morning's discussions. How do we regulate things? Good practice, for example. How do we regulate things that we don't really know what they are? Well, our way of regulating has been, again, through negotiations. We do much more soft law instruments than hard law instruments. Another kind of quirky bit of it is that a minimal government interference. The government sets the cadre, the case, and then we leave it to the parties to negotiate the details. And another part which is interesting and which is important not to forget as well, just when it comes to discussions on governance, is the collaborative structures and the mutual dependencies, the interlinked situation between different actors on the market that this way of regulating has resulted in. They want us to stay on this picture. I'll try.
Stuck. I think we pressed at
Stuck.
the same time.
Here?
Yeah.
Here we go.
Yes.
So the effect on the organizational and regulatory landscape within collective rights management for this has been that, again, there's been no specific CMO regulation, but there's been other ways of kind of dealing with this growing structure. One being that the Swedish government has actually endowed quite a lot of functions on CMOs. And it's an interesting way of governing. I do remember once when I was in part of a negotiation and one institution, I won't say which one, they didn't want to comply with what the government did. And my then superior sat down and said, okay, fine, shall we discuss the 153 million euros of funds you're getting this year? After that comment, they wanted to discuss our requirements. So it's a kind of different way of steering. It's not without complexity, I think. Now I'm speaking from a supervisory point of view, because, of course, if you endow public functions on, in this case, CMOs, there's an interest from the government to make sure that they can do the work well. And my kind of speculation is that this is one reason why we've accepted quite generous administrative deductions. I remember when Irini and I met a few years ago, you asked me, well, can they do 100% deductions? And I said, of course they can. We have organizations doing 100% deductions. Can they do stable, flat rate deductions of 25 years that are never being revised? Yes, of course they can. If they deal with what they're supposed to deal with in a correct way, we are quite generous. We don't go into details in the levels of deductions. Again, I'm jumping the point said, that kind of system has led to very stable and very knowledgeable institutions. And they are, I would say, they take on functions that would be equivalent to some of the functions that you do at this organization. They are, in a way, the Swedish Copyright Office. The government calls on them for expertise to a far larger extent than, for example, they call on me. And I think you have been part of this procedure, so do you want to share some of your experiences there?
Yeah, no. So I was recently a member of an expert committee looking into changes in the Copyright Act concerning limitations. And it was quite interesting to see that out of the 10 experts that participated, a vast majority came from the CMOs and guilds, of course, as well. And it's also, if you look into how these organizations operate, it is obvious that every time the Swedish government or the Ministry of Justice has to kind of revise or think about revising the Copyright Act due to a new directive or new technological challenges, they call upon these organizations. So they have the role of the expert advisor to the government and to the ministry, which is as such quite an interesting thing because, of course, part of the issues discussed in the expert committees affect in one way or another the functioning of these organizations. So sometimes I felt during these discussions that I was wondering whether there is kind of an interest in self-preservation as well, or enhancing their role and status, maybe much more than actually enhancing the role and status of rights holders, which, yeah, for me it was quite interesting to see in practice.
Yeah. And So, effect of this labour market norm on the implementation of the CRM directive. I really very much like the CRM directive. I started working within this field when it was being implemented. And it is interesting now, remembering the comments that were being made when the directive was going to be implemented. We heard that it was just a thing from the south of Europe. It wasn't necessary in Sweden. Everything worked so well. So this was a regulation that we could let's just ignore it. We couldn't really ignore it. There were discussions about not having a supervisory authority, but unfortunately, we had to have a national competent authority. And this all works well. That was quite funny because generally things work well in terms of that there are stable structures. Okay. Some people have come into prison though, so I wouldn't say it always works well. But again, the absence of detailed regulation that you can see in our way of dealing with collective rights management. Again, we mentioned deductions, but same with tariffs. I know that when we have met Daphne in the supervisory networks, we never have anything to contribute with when it comes to tariffs because we don't set tariffs. We don't know what the tariffs are. We don't, they're none of our business. We set a framework for how tariffs are to be decided. Let's move on quickly here.
Okay, so thanks to the CRM directive, we now have a basic understanding of how these organizations look like in Sweden. And what we have 28 organizations engaged in the activity of collective rights management. 9 of these organizations are collective management organizations, 2 of which are larger, so-called umbrella or meta organizations. It's Bonus and Copyswede. The remaining 19 are classified as other organizations, which according to our provisions on extended collective licenses are entitled to enter into collective agreements. And this is where we find the guilds and the trade unions. Okay, and as mentioned in our introduction, I have been part of an interdisciplinary project looking into women in the film industry, and under the framework of this project, I conducted extensive interviews with different film directors and film workers, and I collected a great number of contracts from 1915 to today. As a spin-off of the project, I decided to investigate how contracts in the film industry are negotiated, concluded, and finally enforced. And I did that under the light of a relational contract theory. And in order to apply this theory, you have to look into all the different layers and different relations in the specific industry you are working with. And an important aspect when looking into these contracts, I was actually diving into the relations of various actors and above all the different roles of the various actors on the market. And the study developed into a way where it was impossible for me not to look into the role of these organizations, looking into the role, the relations of the organizations with their members and the relations of the organization with each other. And since we're talking about the film industry, I looked in particular into the Swedish Union for Performing Arts and Film.
Do you want to say who that is?
You know?
Ingmar Bergman, right?
Yes. The Swedish Union for Performing Arts and Film, this is a very prominent trade union and professional organization in Sweden, established in 1894. It represents a diverse group of professionals, including actors, technicians, administrators, film directors, film editors. There is a very high level of membership. Members are organized in different branches depending on what they're actually working with. And the organization has, of course, undergone several significant developments during time. It has taken on board different functions from organizing elderly people's homes to collective management of copyright. And with the introduction of collective licensing schemes, the organization was given the potential mandate to collectively manage rights. The union has played a very important role, one has to say, advocating for the rights and interests of Sweden's creative professionals, ensuring better working conditions and engaging in activities supporting cultural heritage. And this expertise that we talked about, the expertise that the Swedish government calls upon, it's used both for the advocacy work, but also consulting on the members. So members in this organization have the possibility to get a lot of help when drafting their individual agreements. So one might wonder, why is this a challenge? Why do we perceive this as a potential issue? And here we will recount the story of the film editors. And film editors have been members of this union for over 50 years. But until quite recently, they were not considered to be authors. They were not considered to be copyright holders. Actually, this issue was raised both with regard to distribution of income from collective licensing schemes, but also with regards to the distribution of private copy levy. And from the perspective of the film editors, the question was a general issue, not only being part of the authors to receive remuneration, but also being recognized as authors, as copyright holders. And this decision that came 2022 cemented somehow a historical scar, a feeling of being treated in an unjust way and being marginalized. So, of course, this has also influenced the drafting of the individual contracts, and this is what I find quite interesting. Up until 2022, if you look into the individual contracts of film editors, they are not dealing with copyright issues because there was a lack of identity as an author from the part of the film editors as a working group, as a group of film workers, and because also the expertise they received from the union informed them that they are not authors and they should not have any clause related to copyright in the contracts. After 2022, you see a complete difference there, a change. You find in individual contracts copyright provisions.
And I can say that they were not part of the group saying that everything worked really well. They were actually the first group that called me when I started my work at the supervisory office.
Yeah. And I think this situation shows that there is a potential lack of transparency and confusion over who truly controls access to collective rights benefits, who is to decide whether a group of workers is an author or not, and on what criteria. This case can also be used to illustrate the multiple roles of these organizations in Sweden. They are consultants to the Swedish government, they are collective management organizations, they are private consultants to the authors. More than anything, it illustrates the difficulty of individual rights holders to navigate within a very complicated landscape.
I was a bit nervous putting this picture up because this is a real picture. This is when I tried to explain to my controller unit how funds were flowing through the organizations. It was meant to be a half-an-hour meeting. It ended up being a 2-hour meeting. And I hope you can't read the details about the money. But anyway, it kind of shows how this self-regulation and limited state intervention... I am a fan of the organizations in a way. You know, it's a really well-set structure. However, it's not that easy to navigate. Like the film editors, it took me quite a lot of time. It took you some time. We kind of argued about this issue. Were the decisions made by the right person in the right organizations? They were. But sometimes the same person sits on 3 organizations, so you don't really know who you talk to. If you have a really fierce debate, then you have someone else calling you. So again, the gradual evolution and hybrid organizations that we find here, it is efficient. It does mean that it works well, but it is a challenge to transparency. So a few minutes left. Reflections on government control. We'll talk really, really quickly here. Governance challenges rather than government control. We talked about closed loops. Basically, you make a decision is being made, and there are systems which on the face of it seems like they would increase accountability and transparency. But when you scratch the surface, Sweden is a small country as well. You know, everything seems to be interlinked. And I think this is an important issue that we are working with, talking of good practice with the organizations, because if you don't have trust in the system, then you have a big issue. So we put some questions here. For example, how do we ensure that these new right holder groups, the film editors in your case, that they feel represented and that they have this meaningful voice? They did feel excluded. They are included now, but the case is far from finished. We still have the whole distribution question to talk about. I like concepts such as institutional legacy and path dependence. I learned those concepts fairly recently, that you kind of get stuck in doing things the way it's always been done. And again, we've had this system in existence for 150 years. It's not that easy to change. Move on. So when it comes to government control, I thought when I started my position that I would be top-down controlling organizations, and I've learned in the past few years that it's much more difficult. It's much more navigation done than just telling people what to do. Again, because we can talk about the deductions. I try to change the deductions within one organization. That's still not possible because the deduction, the mechanism through which deductions are made, it's the same as our Ministry of Culture allows the organizations when they are given the organization a mandate to distribute state aid. So if I put a requirement on one part of the organization, then I also need to speak to the Ministry of Culture, asking them to change the way they allow deductions for the distribution of aid. So everything is kind of interlinked. And then this concept of collaborative governance. I remember when I first read an article about collaborative governance, I thought, they're talking about us. They're talking about me. This is what we're doing. And maybe we could end on that note a little bit, because that concept is not just a concept which is valid, I think, for collective rights management. We talked about the AI Act this morning. We talk about any market that you regulate that is not that clear. Any market that's kind of dynamic and moving, you have to think in other terms than just top-down control. And yeah, I needed to reassess my view as an authority.
We might conclude by saying that Sweden's approach to collective rights management showcases the strength and challenges of a self-regulated system rooted in collaborative governance. And while this model has really fostered stability, expertise, and high representation, it also kind of raises concerns about transparency, closed decision-making structures, and a lot of institutional resistance to change. And addressing these challenges requires a flexible regulatory approach that balances efficiency with accountability, ensuring that all rights holders, both established ones and emerging ones, have a meaningful voice. So as governance frameworks continue to evolve, striking this balance will be the key to sustaining an equitable and adaptable system. Thank you very much.
Thank you. We keep time. Did we keep the time?
Almost stuck with the book. Okay. Thank you. Thank you very much. No, I'm not strict. I didn't exercise my strictness. Not with you. No. Indeed, a highly interesting presentation. What actually was a methodological challenge for me is the implementation of this relational theory, contract theory, upon the film contracts. Perhaps we may speak later on this. Now, I'll pass the floor to Professor Hugenholtz, who has asked me not to speak for a long time for him. Indeed, it is something bothly difficult and easy. In order to make the long way short, I might say to you that, of course, Professor Hugenholtz is Professor of Intellectual Property at the University of Amsterdam. He's at the same time judge at the Court of Appeals of The Hague, former director of Institute of Information Law, and founder of European Copyright Society, and so many. The easiness of the presentation might be simply that Professor Hugenholtz is Professor Hugenholtz.
Thank you for that kind introduction. Kalispera. Is it late enough for Kalispera? Yes. Yeah? Or is it just yassas at this point? Okay.
In Greece, the night is always young.
Okay. Χρόνια πολλά στην όπη. But I'm not going to sing. Happy birthday. Thank you. No? Oh, it's all AI. No, for the rest, this is actually an AI-free presentation, guaranteed. So you can relax. Thank you, Daphne, for inviting me to Athens, to this wonderful conference, and to this wonderful weather. What an opportunity. I'm unfortunately going to pay my visit with a presentation on a very unsexy topic, which is international application of copyright and neighboring rights. I mean, just saying that is already enough to put you to sleep. On the other hand, there are two fairly recent decisions by the European Court that actually might merit a more serious look at this topic, one of which you're already quite familiar with, I presume, the Raap case, which was decided 5 years ago, and which caused, through a bombshell in the world of neighboring rights, particularly the remuneration rights for performers, got really upset by that case. More recently, we now have another case, very much in the same line, in the field of copyright, the Quantum decision, which was decided in October of this year. In both cases, completely undermine the way we have been dealing with international application within the EU. And this has ramifications for copyright and neighboring rights everywhere, particularly in collective rights management. So that's the topic. Now, the next slide. Okay, here's the boring part. International application of copyright and related rights. What are we talking about? Before these two decisions, this field was dominated in Europe, as it still is in the rest of the world, by the two main conventions in our field, both providing for national treatment, the rule that foreign creators, authors, or artists are protected as local, regardless of any protection in their country of origin. That's the ground rule, national treatment. We see it in the Berne Convention. We also see it in the Rome Convention, the WPPT. However, there are important exceptions in these international conventions. The Rome Convention and the WPPT, for example, allow a state to make a reservation in respect of the right to a single equitable remuneration, the remuneration right for performing artists and phonogram producers, which has to be stated expressly. The Berne Convention allows for a trio of exceptions to national treatment. One is for works of applied art, one is for terms of protection, one is for the artist resale royalty. Why do we have these exceptions to national treatment? Because these are all subjects where there is no international comity, no international harmonization. There are huge differences in the way copyright treats works of applied art across the world, or in the way neighboring rights are protected across the world. Member states have happily made use of these exceptions to the national treatment rule, have actually invoked and applied reciprocity in all these fields against right holders from other non-EU states. And that was also because there are no general EU rules of application barring that application, except in the field of term protection, artist resale right, and databases, where the EU lawmaker had actually provided for specific rules allowing reciprocity to occur. That is the pre-Raap, pre-quantum state of the international law as it applied in Europe. Now comes Raap, and Raap was decided almost 4.5 years ago, actually, so it's not really a recent case. Raap is an originally Irish case concerning the equitable remuneration right, the SER. I will spare you the details. We don't have time, and you probably know the details. The core question here was, can Irish law prevent American artists from getting paid under this remuneration right? In other words, can Ireland apply reciprocity vis-a-vis the United States, where such a right does not exist in the same way as we have it in Europe? And this question could have come from anywhere in Europe because, well, not anywhere, but most European countries, like Ireland, actually did not protect artists from the United States under these reciprocity provisions. Why? Because the United States does not protect European artists and does not give them a remuneration right over there. Reciprocity. However, the European Court did away with all that. According to the European Court, and I'm summarizing a quite complex decision in only 3 bullet points here, inferred from the state of European Union law that such reciprocity cannot be invoked by the member states individually. And the primary argument here was, and I think that is typical for the way the European Court is reasoning today, the rental and lending right which provides this right doesn't say so. It says there must be a right to remuneration. It does not limit this expressly to EU performers or phonogram producers, so it must also apply to American artists. A simplicity that does not really attract me, but I'm not the court. The court additionally considered that the right should be interpreted in light of the WPPT, the International Convention to which the European Union has acceded, making that treaty part of the EU legal order, pointing out that national treatment is the default rule and that any deviation from that rule therefore must be done by, it must be executed by or implemented by the European Union rather than the national member states. In other words, Ireland was not allowed to apply reciprocity, not allowed to exclude US performers. It's only for the European legislator to do so. That's RAP. And RAP caused, as I already mentioned, quite a stir in the field of neighboring rights. In fact, a bombshell, as I already mentioned. Artists, CMOs, everybody involved immediately argued for some form of intervention by the European legislator, and the European Commission rapidly commissioned a study to look at the economic consequences of this decision. This study came out in 2023, showing that at least half of the member states prior to RAP applied reciprocity, and that as a consequence of the decision, income from this equitable remuneration right now needs to be shared with a much larger right holder base, including right holders from the US and other countries which formerly were prevented from benefiting from that right under reciprocity. The study estimated the annual losses that the European Union would suffer in respect of the United States. In other words, the amount of money flowing from the EU to the United States as a consequence of this decision between 35 and 66 million euros. Annually, other stakeholders actually estimated much higher losses, even exceeding 100 million a year. Paradoxically, of course, the CMOs were in sort of an ambiguous position here because although the decision clearly led to lower income per European artist, the overall revenue of the CMOs increased because they were now also collecting for American artists. In the Netherlands, and this is just an example of the impact this decision has had, the per artist income was reduced to such a point that SENA, the Dutch CMO charged with collecting this money, had to increase its fee by 26%. So quite a substantive loss for Europe vis-à-vis the United States. This is the study I mentioned. There was also a consultation initiated by the Commission, which led to all kinds of comments. Many people expected a follow-on, but nothing happened. It's a bit of a lame report that you can consult online. That's RAP. Now, quantum. Quantum is about these chairs. And I'm sure many of you have this chair at home, or perhaps your student child has several at home. They're extremely popular. Most likely, what your student has bought is a fake. They are available everywhere at low price, but they're actually very famous chairs designed by the Eames couple, American designers. This brings me to quantum. The quantum case is about Quantum, which is a large budget furniture retailer operating in the Netherlands and in Belgium, and they're selling these chairs. Good imitations of the original Eames design, the copyrights of which are now owned by Vitra. And according to Vitra, this is copyright infringement. According to Quantum, this is completely allowed because these are chairs that originate in the United States and under Article 2.7 of the Berne Convention, therefore are subject to the rule of reciprocity. In the United States, there's no copyright protection for the design of a useful article, like a chair, no copyright in the US, therefore no copyright in Europe. I'm summarizing a more complex rule to make it simple. Is that rule allowed under EU law? That's the question that the Quantum Court, the Dutch Supreme Court, asked to the European Court. And the answer, after this rather elaborate introduction, you can guess if you didn't even know the case. No, of course, that is not allowed under EU law, because under EU law, like with the RAP decision, there is no express provision in EU law allowing a court to differentiate between works that have their origin in Europe and works that have their origin in the United States. The scope of application of the Information Society Directive, which is the most horizontal of our copyright directives, is not limited to EU works, applies to everyone. And since the court had previously established that works of applied art are actually normal works for the purpose of copyright, 1 + 1 is 2, therefore rules of reciprocity cannot contravene this European protection regime from which everyone in the world can benefit. In other words, member states, in this case the Netherlands, may not apply Article 2.7 reciprocity, although the Berne Convention expressly says that they may do so. National member states may not do that on their own. Only the European legislator would be competent to do so. Here we see the same language reappearing as we already saw in RAP. That's quantum. And again, the consequences are quite substantial. Maybe in economic terms, not as big as the consequences of the RAP ruling, where you can easily calculate that hundreds of millions of European euros are flowing to the US, where they should have stayed with us. Sorry for sounding a bit protectionist, but thanks to the current political climate, I can now say these things. The consequences for collective rights management, for copyright generally, of the quantum case are similar and possibly even further reaching than RAP. Because what the court is really saying here is a very simple decision. It's even simpler than the RAP decision. What the court is really saying, there is no provision in EU law allowing reciprocity. Therefore, everyone is protected under EU copyright law. And I should add, because this is an interpretation of the Information Society Directive, of neighboring rights as well. So we have now introduced in Europe, which is quite spectacular, after all these centuries of discussions on international application, after all these treaties and interpretations and thick books by Ricketson and Ginsburg, a system of universal protection. Everyone is protected. The American designers are protected, but there is no limit to this if you read quantum. Unless special rules of application apply, and we have them for terms of protection in the term directive, we have them for resale rights in the resale right directive, we have them in the database directive, but for the rest we have nothing. And absent any such European rules, everyone is protected. So that means the chair, the design of the chair, the Eames chair, is now fully protected in Europe, and it was not in most countries. Imitating the chair was perfectly legal, at least under copyright. But the consequence goes further than that. All the authors, all the creators, not protected under the Berne Convention. Well, nowadays, that's not so many, but there are still about 20 countries in the world that are not Berne Union countries. To name a few: Eritrea, Ethiopia, Iran, Iraq, Palestine, Somalia, all our favorite countries, basically. They are now welcome to protection in Europe. On top of that, I think the consequences in the neighboring rights field could even be more dramatic, since quantum does not in any way relate protection under copyright and related rights to an international framework. I think you could make the case that under the quantum ruling, all non-Rome, all non-WPPT performers are also protected, since the Information Society Directive doesn't say that they're not. So, simple as that. We protect everyone. Welcome to Europe. Now, there are, of course, good cases, good arguments to be made for a universalist approach. And in fact, they have been made in the past. Copyright is grounded in fundamental rights. Why would we distinguish between protecting the fundamental rights of European citizens and those of US citizens? And I understand that argument. But I don't understand all this in light of the current looming trade wars. I do not understand this in this world where every international bargaining chip is worth something, in this transactional sphere where, thank you, Mr. President, the United States have now brought us. This end of reciprocity by the European Court, in fact, rewards asymmetric legal protection. It rewards Europe protecting American artists and not doing the opposite. It rewards a very unfair trade relationship where we give remuneration rights, copyright protection to all sorts of stakeholders from the US, and they're not giving anything in return. This is naive. And a situation that needs to be cured rather immediately. I know the European Union has bigger problems these days, like setting up in a European defense force, which I agree is more important than copyright. But this is something to take seriously. And there are a number of member states that have actually called for urgent action already. 6 countries, Belgium, Denmark, Finland, France, the Netherlands, Sweden, have written a rather urgent letter to the European Commission after Quantum, asking for intervention. Remember what the European Court said. The EU is competent to reintroduce reciprocity. Do that, say these countries. And I completely agree. We should do something fairly urgently. And the Court invites us to do so, invites us, the European Union, to act. The only question here is, of course, what should that be? Should that be an amendment to directives like the InfoSoc directive, the rental and lending right, or shouldn't we look at a regulation instead, a more holistic approach, a regulation on international application of copyright and related rights? I would personally prefer the latter. So I think that's the way forward. I hope the European Commission takes this seriously, because it is a serious problem. It's a small bargaining chip, perhaps, but it is one, and a valuable one. And as long as we don't do that, Europe is shooting itself in the foot, and the creative industry is suffering for that. Thank you very much.
In spite of what Professor Hugenholtz modestly has told us, this was a highly interesting and challenging presentation in many levels. I had listened to his explicit or implied criticism, and I might find at least 3 levels. The level of the doctrinal level. What is the notion, the concept of work? Which brings us to the next level, the level of judicial activism of the ECG. Yes. The next level, perhaps, is a problem of sovereignty. May the member states exercise their own reciprocity rights? And I might here suggest an intermediate solution. We all know the well-known Europakonforme Auslegung, the harmonization by the interpretation, vis-à-vis the primary and the secondary European law. Perhaps we might here implement the secondary European law, e.g. the Information Society, Directive, in the light of Berne Convention. And perhaps there might be a reductive interpretation. Under these thoughts, I might suggest that your arguments, dear Professor Hugenholtz, are highly de lege lata ones, not de lege ferenta. And perhaps we might ask for a judicial solution here and now, not in the future. This is my position. Excuse me for the whole intervention. I don't know whether you...
But you're saying that, that judicial intervention should then come from the European Court. And they just spoke. So I don't see that happening very soon.
Okay, they have used us that they, in the fact that they change sometimes their minds.
Yeah, I hope they do. Yeah.
Okay.
Yeah, thank you.
So the BGH might influence this, but perhaps this is also a solution, possible one. Now, After all, last but not least, I may introduce you Mr. Mattioti, a professor in law and innovation in Cattolica School of Law and the Center of Future of Law at Universidade Católica Portuguesa in Lisbon. Of course, he's a doctor juris. Of course, his activity is also multifaceted, because I have somewhere read that you are also a clarinetist.
Yeah.
Anyway, his presentation correlates to the one of Professor Hungenholz, because since he's about to tell us about the international models of collective management, where, of course, the reciprocity perhaps plays a particular role. Thank you very much.
Thank you very much, Chair. Thank you very much to the organizers of this magnificent conference, Daphne and Papadopoulou in particular. I'm very happy to be here, and I'm very happy to celebrate the achievement of this organization that hosts us in this magnificent venue. Thanks to the panelists for the wonderful presentations. I think this hopefully brief presentation of the results of this project that I am leading together with other partners of the consortium Fair Muse, sponsored by the European Commission through Horizon Europe, which is the largest research funding program that we have in Europe, sponsors all sorts of research and allows researchers to be fully independent, which is a privilege these days, considering also, on one hand, the non-supportive environment that we have in academia very often when it comes to research, and the fact that, there are other sources of funding that do not grant the same kind of degree of freedom to researchers. So I'm particularly privileged to represent here also a consortium of completely free researchers. Where does this presentation come from? It comes from the project is promoting fairness in the music ecosystem in a platform-dominated and post-pandemic Europe. This is the acronym Fair Muse stands for. It's a wordplay that I thought of during the pandemic when we were all stuck in our homes and there was no performing art at all, and these platforms grew up in size and scale, became the only ways we had to access the performing arts. And for a second we thought, oh, this is fantastic, because even though theaters and music venues are closed and we are confined in our places, maybe fighting with our family or partners, we still have the possibility of enjoying movies, music, and even live performances, because we shouldn't forget that Instagram and other platforms were used those days also by bands, symphony orchestras, to delight us with things that we normally listen to and attend in theaters or places like this. So the problem was, in light of this 2019 directive that we all know, copyright in the digital single market, whether or not this expectation of fair meaning appropriate proportionate remuneration for creators, for individual creators, primarily physical persons, using Alan Strowell's reference earlier this morning. Physical persons means composers, lyricists, performers, primarily. Although in the project that I'm leading, we try in trying to compare the situation of creators vis-a-vis the situation of online platforms. For instance, I know that the performers and the composers, advocates do not entirely agree with that. When it comes to record producers, we place them on the creator side, even though they are in this regard. It's a little bit the creative industries vis-a-vis as a David versus Goliath. Goliath here is also the big tech that is not present here. Fair Muse tried its best to talk to big tech, all of them. It's notoriously difficult because it's an industry based on secrecy. It's also an industry that deeply tries to influence policymakers and academia. Once again, Horizon Europe helps academics to be free from the influence of big tech. Nonetheless, several big tech companies do not treat their lawyers and policy people very well, in a way that's extremely I would say easy no, but it's possible to talk to them, especially when they stop working for these companies, obviously under confidentiality agreements with all the precautions and all the compliance work, they talk. So whenever Meta, Google make people redundant, these people, even though they are bound by non-competition clause, and they talk. And we were very lucky to talk to some of them and to uncover some of the practices that make many of their businesses completely unfair and completely intransparent. So the project, in 1 minute, just for you also to appreciate the multidisciplinary dimension of the project. It's not only lawyers, because otherwise it would be the usual blah, blah, blah. And we understood, and particularly when we were stuck in our homes, that lawyers have many virtues, many skills, but very often do not know exactly what they are writing about, because they make efforts that are primarily based on statutes, on even super complex judgments, but very often what is missing is the knowledge that regards the technical aspects. And today I appreciated also Silke von Lewinsky's strong remarks on the differences that exist between text and data mining, the classical one, and generative AI. This is fundamentally important. It's very important that lawyers stop looking at the law, considering the law as a sort of religious text. Even though I represent a Catholic university, I shouldn't say that. But the law is fundamentally applied science. We shouldn't fight for the sake of the law itself. We should fight as lawyers for the sake of society, and I appreciate also the political dimension of Professor Hoenegraal's remarks, both in the copyright sphere, but also in a more political and more existential way. So we look at fairness from the point of view of law, of course, but also from the point of view of data science, looking at the fairness of algorithms. It's something that the Digital Services Act now forces us to look at, even though with difficulties, and from the perspective of the business models of these platforms. We know that when it comes to music, and here I will not mention AI because AI is not at the core of fair news, we are primarily looking at streaming services, so Spotify, Apple Music, and the like, and social media services. And we argue to a certain extent, we concluded a few days ago, the second year of the project, that the kind of challenges that we are facing today with AI are not new. New is probably the scale, but when it comes to the complete lack of control of creators and music creators in particular, and the exercise of their rights, we already faced these challenges 15 years ago. Social media already put the creative industries upside down with the logic of a platform so-called neutrality. The e-commerce directive may be an unintended application of the e-commerce directive, supported by this praise for innovation. 10 years ago, it would have been difficult to put social media in the spotlight, because if a legal advocate had said that they could have threatened our society in many ways, you would have been labeled immediately as an anti-innovation person. We understood that there is also quite a lot of crypto-fascism in this kind of platforms. Now, we do have this ridiculous, although dangerous example with Elon Musk, but I don't think, frankly, that other companies are doing a better job when we look at how they are aligned opportunistically with Donald Trump. It's absolutely abhorrent, in my view. So fair news is also in a much smaller domain about this claim of a more just, more fair, more ultimately transparent, because the European Union is still a liberal economy. We should be very proud of being liberal at this time in which authoritarian regimes and gangster-like behavior seem to be like more lucrative politically. It's coordinated by us, by me as a principal investigator. It's a project that promises certain results. As you will see, the main result concern whether or not online music is fairly remunerated, and fairness comes through the transparency of the conditions. There are provisions in the scheme Imagine. This entailed quite a lot of planning and years before the concretization of the project. We have 3 hubs: the law hub, the economics hub, and the data science hub, that are ultimately merged in a final package of work where we are supposed to design a music copyright infrastructure based on better access to music data. White paper, which is the usual thing that lawyers do, and we will try our best to propose reforms, one of which is actually the reform that you just mentioned. Reform is the intervention by necessity. And other 2 are data-related results, one of which is this fairness score. We, with the data science, try to make musicians, music creators, composers, and performers understand which platform treats them best on the grounds of several indicators that they are developing. And we are also trying to show through our economists, through statistical data that is already available, what the value of music is here. We are talking mostly about recorded music. Why is it that? Because we hear very often this kind of reference to remuneration rights. Remuneration. Nobody knows exactly what he or she is talking about, because the value of music is completely unknown digitally, and because the value of the markets that these companies build is completely unknown even to tax authorities. So when we talk about remuneration rights, are we talking about tips? Are we talking about peanuts? Are we talking about fig leaves? That's where lawyers desperately need to study a little bit of economics and to stop invoking remuneration rights where they don't know what the value of music is, because they don't know the basics of the creative industries. Dramatically. So the purple studies are the studies where we are based as a consortium. 2 big economies were added because we had the researchers being able to study the non-easy German laws and the Spanish laws. These are the countries where we did this. I would like to go straight to the point of collective rights management, which is the reason why I am here. Collective rights management is a fundamentally important point in this debate, because we say in Italian, my home country, l'unione fa la forza. Without a proper union of creators, there is no strength. The strength comes from a collective dimension. And we know that the collective dimension of collective rights management was primarily concentrated in the field of so-called publishing rights. The called publishing right in the market is mostly the composers and publishers' rights that are administered by collecting society, also the collecting society operating here in Greece. But we should never forget that when we talk about digital music, we talk mostly about the recording rights. The recording rights are the record labels' rights, which include the performance rights which are acquired at the time of a record production. Then we know, also from Professor Huguenot's presentation, that remuneration rights benefit performers. Obviously, these would be even better with proper data provided also by the users. But let's simplify and consider the music industry as an industry where we have 2 types of rights which coexist: the publishing rights and the recording rights. Well, when we think of the revenue that the music industry as a whole derives from streaming services and social media services, we should consider that the recording rights are tiny compared market-wise, compared to the recording rights. The ratio is 1 to 4, 1 to 5. If you consider that a company like Spotify keeps 30%, 35% out of all the revenues, and 70%, Spotify is the most loyal. It's not perfect, but it's the most, there's a Swedish component here in the panel. Spotify, despite a huge criticism, it's still better than TikTok. TikTok pays, despite a huge use of music, 6% of the revenues to the music industry. So the fairness is also one indicator. How much money are you paying to the music right holders? So obviously, the tech companies say, hey, but we make a very different use of music, but it depends very much on the intensity, the relevance of the music for your core business. But keep in mind, it's 70% versus 6%. Now, the problem is, for a number of reasons related to the conflict between the international or pan-European on one hand and territorial dimension of collective rights management, 20 years ago, the European Commission tried to reform this sector. It tried to make the European CMOs compete with each other in order to provide multi-territorial, possibly pan-European licenses. This created a little bit of turmoil because for a decade or so, until the adoption of the directive that Francesca was mentioning a few minutes ago, there was a little bit of uncertainty about how collecting societies could have worked on a multi-territorial basis coming from a tradition of reciprocal representation agreement. So what is the takeaway of my presentation today? That the collective rights management system, for a number of reasons, is becoming more fragmented when it comes to the representation of repertoires, which is problematic, because obviously there are repertoires which are commercially more important and more relevant than others. On the other hand, the fact that we do have I want to go straight to this point because I think the most important one. In this graph,
you made progress.
No, there is a lot. I think this is the most important point, and then I go back in the final 2 minutes. Why some of them are colored and others are gray? Well, because the gray ones are sort of ghosts. You have to imagine these are all legitimate and very important initiatives that were taken in the past 15 years when the European Commission started prompting the CMOs to create more agile and more technology-wise and strong data and rights hubs. And for a number of reasons, the situation ended up looking like an extremely concentrated market where a few joint ventures representing the most appealing, the commercially most relevant repertoires are condensed in the hands of a few hubs. These hubs at the moment are ICE, the most important one that includes also STEAM as one of the founding organizations. MINT is an alliance of Suiza, the Swiss Collecting Society, CESAC, which is an American IME. Not to forget DEAL, that is the strategic exclusive relationship and partnership between SACEM, that you all know, and Universal Music for the administration of the publishing rights. All other organizations or alliances which came out after the attempt of the Commission to reform this system, to a certain extent ended up being represented, absorbed, or to a certain extent served in terms of services, back-off data processing services by these three hubs. What is one of the conclusions of our study that was submitted to the European Commission a few days ago is that in an environment in which the CRM directive from 2014 created quite a lot of scrutiny and checks and compliance work for the CMOs at national level, and also, let me go back for a second, lots of fuss on independent management entities, which are for-profit licensors of copyrights. It's somehow paradoxical that the largest digital licensors of publishing rights in Europe end up being located outside of the EU. I'll give you just an example in a few seconds. ICE is located, even though there is a German component, is ultimately operating from London. MINT is operating between, if I'm not mistaken, Switzerland and Liechtenstein. So to a certain extent, DEAL is still deeply French, and SACEM is extremely proud, legitimately about it. But we have at least two of the three big hubs being headquartered outside of the EU, which is quite, I find it quite paradoxical and unintended. So in the last 2 minutes, if you allow me, Chair.
2, yes, of course.
Yeah. I'll start acting as Donald Trump of the world.
Like George Commandos.
No, you know, I also have the, yeah, exactly. It's a good place. So this repertoire fragmentation that obliged the CMOs, word that I'm very sympathetic to for a number of reasons, ended up fragmenting the data. So on one hand, there is a problem that these hubs are fundamentally a new powerhouse in terms of representation and data collection, data processing. On the other hand, without these hubs, the CMO's world would be much weaker because the counterparts of the CMOs these days are Google, TikTok, Meta, Apple, and the like. Spotify, but again, Spotify is certainly more loyal than other companies on the rights revenues. So the problem is, and this is something that I would like to talk to the stakeholders too, is that we do have a problem of misalignment and fragmentation of data despite the exceptional efforts of CISAC. CISAC, as you probably know, is the umbrella organizations of CMOs, a global organization, and they have a database called CISNet, which is not a database. It's a portal of local databases, which has a significant element of interaction and accessibility. Nonetheless, CISNet, and Adriana can correct me if I'm mistaken, CISNet is accessible only by the CMOs and the affiliated entities, including the IMEs. And obviously, CISAC and CMOs cannot grant access to their data in their entirety to the online users for the simple reason that data for them is the core business. So, and why should the CMOs transparent vis-a-vis the online users where the online users do not provide proper, accurate reports about the use of music recordings? So here, Fair Muse is a little bit in the middle. We are not partisan. We understand the element of weakness of the creative industries, of the music industry in particular. We urge, we have no authority, it's just moral suasion, the recording branch and the publishing sector of the music industry to better understand each other and to create a system in which these famous international recording codes and international musical compositions called the ISWCs are coordinated. Because you can't imagine how easy it is to lose the data of the musical compositions. We spoke to data brokers in the music industry. Very often, the sound recording data comes without the data of the musical compositions, which are very fragmented because we know that there are multiple right holders and there is a problem of content identification. That's exactly what this graph shows, and I'm happy to talk about this after. Thank you.
Thank you very much, dear colleague. Excuse me for my unfavorable role as chair. Of course, I don't know whether I have the time memory of Trump or Biden, but nevertheless, I'll try to keep my role. Nevertheless, this was a very, very juicy and interesting presentation. I think it was a presentation of a totally new landscape. And of course, it was a very demanding one. There was a challenge for you to try to restrict this issue, broad issue, in a very short time limit. Excuses. Nevertheless, I believe that you have succeeded to tackle your goals. Now, I may pass the floor to the audience, to whoever would like, by mentioning his name, please, for about 10 minutes. Maybe we'll better do it afterwards. Okay. So let me declare the end of this.
Unless to tell you just now, probably they won't be here on the panel. Maybe let's do it now if somebody has a question, because then won't be here.
Yes. Okay, okay. You have listened to the procedural rules.
They are very flexible.
Yes. They put flexibly the strictness of nevertheless, if someone feels that there's no time for him, as I feel, and luckily I have not the luck to follow the rest of your conference, it has to do with my role as the Dean of the Faculty. It's a role for which somebody congratulates me and someone expresses his compassion for missing the rest of the conference. Nevertheless, please. I believe no one dares. Do you want, please? Yes.
Am I allowed? Am I allowed to ask a question? Oh, wonderful. Bernd, I have a question for... Yes. Well, it's a question relating to your presentation, Bernd. We are in Sweden now currently revising our legislation because of the RAP judgment and the quantum judgment. And I find that surprising because we're doing that kind of revision with such urgency, even though we are also writing a letter to the Commission saying that we wish them to take action. In my opinion, we haven't implemented the InfoSoc directive correctly, and we haven't revised our legislation for that. So I'm kind of baffled. What are the politics behind that, or the policy discussions behind that? Do you have an idea? Why is there such a sense of urgency to change something that we, at the same time, ask the Commission to change? I don't understand it.
I have an idea.
Do you? Please share.
Yeah, I'm not into Swedish politics at all, but my guess is that the Swedish ministry is in a hurry to change, to adapt the law to RAP and possibly also to quantum, to minimize Frankovic liability upon the state. Because if a state, as you know, if a state does not comply with EU law and there's harm connected to that, private parties may sue the state. And this has happened in the past. This is the reason why the Dutch lawmaker immediately intervened after the RAP decision, because they want to minimize these liabilities they've had.
It is, you want to minimize liability.
And we're talking about large amounts of money here. And they want to, so that would be my guess. So they're not saying, so by intervening, they're not saying the European Union shouldn't be doing something. These are two parallel tracks.
Yeah. Thank you.
Yes, Professor Stamatoudi.
I have a question to Bernd as well. Do you think the Court of Justice came to this decision because this was a black letter interpretation of the law according to their, to their view, or there was a policy decision there, or they hadn't thought of the consequences as you described them? What do you think lies behind that judgment?
Very essential.
I think our chair already indicated and suggested the answer to that one, and I agree with that. What we see from this court, and it's not just in this case, but also, for example, yesterday there was another decision on the ONB decision concerning the question of allocating rights of performance to their employers. In all these cases, you see the same trend, which is, and I wrote about that in a rather angry blog on the European copyright blog. There is a clear activism, or idealism perhaps, maybe that's the way to put it more politely, with the European Court to harmonize as much as possible. Almost every issue that is thrown at the court for in a preliminary reference now is answered roughly in the same way.
They could also harmonize the other way.
Yes, I agree, but here the powers are, it's mostly towards the European Union. I very rarely hear the court say nowadays on whatever issue that is put to them, no, we didn't harmonize that. That's still for the European member states to deal with. They haven't said that for the last 25 years. But maybe I'm overstating this. But yeah, I think there's some ideology behind it. There's some naiveness there, perhaps. Of course, they didn't consider when they were doing quantum that there is an international trade war about to erupt. Maybe that shouldn't influence the way they interpret things, but you could have, scholars have offered many alternative ways of dealing with quantum, and also with RAP. The European Copyright Society has presented a whole set of arguments that would also comply with EU law and that would have gone in another direction. So there is some idealism involved, I think.
This was a highly political question, and a highly political answer, but also a highly methodological one. It has to do with the phenomenon of extra legem auslegung, extra legem implementation of the law. And of course, it has to do with the distinction between powers, between the legislative and the judicial one. If we have decisions with effects erga omnes, then we have, of course, de facto, de jure, legislative, quasi-legislative decisions. Okay. Yes, yes, please.
It's not a question. It's a response to what has been said. Johan Kaas from APO Artists. For us, Rob is still more a member because it's a society. They're a member of APO Artists. So they're still more a member than a case to us. And actually, to respond to the question, is there a strategy of the court behind it? Is this a policy decisions that they make? No. Because what you have to look at, and Giuseppe said it in his speech, you have to look at where does this come from. Bernd, you said this case could have come from any country. No, it could have only come from Ireland because this concerns equitable remuneration, which is something that music producers and music performers have to share. In every single European country, that money collected, that's not me, that money collected is split 50-50 at source. That means the Collective Management Society collects 100 euros from a bar, from a restaurant, 50 goes to the producers, and 50 euros go to the performers. And you are both grown-ups, and you are both completely responsible for the distribution of that money. If the record labels want to pay US record labels, go ahead. If the performers want to read in some international treaty that they have to pay it to the extent that, go ahead. You're grown-ups, you make that decision. Everywhere in Europe except in Ireland. In Ireland, it's PPI, the producers, they collect 100% and they decide how much performers are getting. And in practice, this results not in a 50-50 split, but in 80% of that money going to producers and 20% ending up with the performers represented by Rob. And this international thing was just an excuse put on the table by the record labels saying, but we cannot pay you out everything, because if we would pay you out everything that you're entitled to, we would have to pay you money for US performers, and they're not entitled to this remuneration. So this was actually an argument put on the table by the record labels, who then, by the way, paid that money out to US record labels. So just the court, what they really did was they were trying to find a way to get some more money going to Rob. And they did it in a very weird way that ended up destroying more than that they built. But that's another problem to solve. But the message to everyone that now has to solve the Rob case, whether you introduce national treatment or reciprocity, in the end, that's a policy decision. And then you can put it in the category of trade agreements, and then you make a policy decision and an economic decision on that. Who cares? I mean, we'll work with it, whatever you decide. But if you do that, put it in EU law that there's a 50-50 split everywhere at source and solve the real problem.
So good. Thank you all, and I pass the chair to Professor Hugenholtz for the next session.
Yeah, I have to get my
Yes, of course. And I pass also my cards to him. Yes.
Shall we continue? Okay, hello again. Now I'm the boss. To conclude this part of the conference, we will have a nice chat between human beings, that is, about collective rights management and AI. And you must have been living under a stone, as we say in the Netherlands, if you didn't notice that generative AI has taken off at rocket speed recently. Creators and right holders have been loudly protesting against its use, against the use of protected content for training purposes. We heard a special panel about that and its legal issues. They've been asking for legislative intervention, urging for legislative intervention, including a right to remuneration. We heard all that earlier today. At the same time, large right holders, mainly in the media sector, have entered into a variety of content agreements with major AI providers. Also that was mentioned earlier. Alain Stroel actually mentioned or expressed his doubts whether creators are actually benefiting from those. So far, and this brings me to this panel, the collective rights management organizations have remained relatively silent in this debate, in this discussion, apart from displaying opt-outs on their websites and GEMA announcing copyright litigation against two model providers. And as we heard from Silke, offering some model licensing schemes. But we're not seeing much collective licensing happening yet. This round table will discuss what role, if any, and I presume you all will be saying there's a major role, CMOs are playing or are expected to play in collectively managing and licensing rights in respect of scraping and training generative AI models. And we have a great panel representing CMOs in different sectors. We don't really have an AI provider here, but we can do without, right? Let me quickly introduce our panelists. To your left, Adriana Moscosa del Prado, who's General Manager of CESAC, which is the European grouping of societies of authors and composers. We have Cécile Despringere, Secretary General of the SAA, the Society of Audiovisual Authors. We have, to your far right, my far left, Anthi Akritidou. I'm not sure I'm pronouncing that correctly. I am. Head of Legal and EU Affairs at the International Federation of Reproduction Rights Organizations, which we usually call IFRO. And then you already heard him just before the stage switch, Johan Kaas, General Secretary of AEPO Artists, the Federation of European Performing Artists, Performance Organizations, and a fellow Dutch language speaker, I would guess. Or not really. Toch een beetje, okay. But we're not speaking Dutch here. No. Don't worry. This roundtable discussion will proceed as follows. First, every panelist has maximum 5 minutes to make a few introductory observations, and then we will start our discussions with me acting as a moderator. So I'll be asking a few questions. But of course, ideally, a discussion will evolve. So let's do that in the order of presentation. Okay. Adriana.
Okay, thank you very much, dear Bernd. Kalispera. Dear members of the Hellenic Copyright Organization, dear Daphne, Papadopoulou in particular, congratulations to all of you And a big thank really for having invited GESAC to be on this panel this afternoon. GESAC is the grouping of Societies of Authors and Composers, of European Societies of Authors and Composers, 32 societies that celebrate the 35th anniversary of GESAC this year. Our main goal is to defend the rights and the interests of CMOs, of its members, authors and publishers, within the European institutions mainly. I think that, well, the name of this panel is Copyright and Collective Management in the Age of AI, and I would like to start maybe by reminding some basic principles about why does collective management exist. And I think that we heard before that, it is a solution to join, to become together, to act collectively when things get complicated, when we are facing times of change. And I think that collective management is just that. I mean, it started precisely in those moments in which intensive dissemination of cultural works started to become really a reality now through theatrical representation and book publishing almost 200 years ago. And we have been seeing this for decades now. So I have the full conviction that AI, it's going to be a moment also for collective management, a very important moment for collective management. I think that collective management is really capable to bringing key solutions for the challenging moments that we are facing in these moments. And I will try to really go maybe to focus on the current situation that we are now in the European Union with this implementation of the AI Act, and what is the position. Bernd was saying that we've been quite silent for the moment. We've been working very much. I can say that. And I will maybe start by saying that CMOs are not being able at all to issue licenses to AI companies, and this is a fact. This is a reality. We have, I think, been very collaborative in all the process of the implementation of the drafting of the AI Act, and we are also very collaborative in this code of practice process. But so far, we are very concerned about the outcome that seems to be, that is going to be, if we don't manage to maybe explain a little bit better why do we feel so concerned about the work that is being developing. I maybe I will go more in detail in the next minutes, because I don't want to take all of the time. But I listen very respectfully and with a lot of interest to Professor Pecker's intervention this morning, and we think that to do not infringe copyright, it's also to be able to get a license, because as Professor Strawell said this morning as well, copyright is an incentive, and there is no way to be able to put in place to enforce copyright if their owners are not able to issue licenses. So if we want the code of practice to be a meaningful exercise, I think we need to have something more than a very, let's say, orthodox exercise of legislation, of interpretation of the legislation. We need a tool that will be that will enable a development of an AI market for everyone, for AI companies, but of course for the cultural and creative industries that make this development of the AI market possible. So we see that there is a lack of encouragement for this promoting of licenses. We see also that we should be asking more commitment to AI companies, and not only asking for instance, reasonable efforts when we are talking about copyright law. Copyright law provisions require an obligation of result, and we think that we need to ask more than for best efforts to comply with copyright. Okay, then I will just say that for us, the solutions come to keep working together, finding this balance between the interests of all those who are going to be part of this, who are being part of this AI market, and that we need to have more political input. We need to understand better that we are in a very crucial moment for Europe, for our sector, and that we need to be also willing to understand better the consequences of the decisions that we'll be taking in the next months. And just one more thing, we are talking about copyright all this day, but I think there is an element very important also that we need to introduce in this picture is competition law. We are right holders, CMOs. In front we have 4, 5 companies, global companies who compound an oligopoly and are becoming even more strong by adding these AI capacities into their already monopoly they were exercising in the access to the internet. So we need competition law to be also looking at this situation. And I will stop here.
Thank you, Adriana. I immediately give the floor to Cécile for your 5 minutes of fame. You're already famous.
Thank you very much, Bernd, and thank you very much, Daphne, for such a very interesting and timely conference, and for the invitation, of course. As far as the Society of Audiovisual Authors is concerned, we have 33 members in 25 countries. Together, they manage rights for 174,000 screenwriters and directors in Europe. Maybe from this perspective of the audiovisual authors, it's important for you to know that our members have generally expressed interest in licensing the use of the works of their authors for the purpose of training of AI models, but they face many challenges along the way. So that really are rooted in their specific situation. So in a number of countries in Europe, audiovisual authors CMOs activities are based on a license prescribed by law and delivered by the national authorities to manage specific rights and fields of exploitation. So these laws and licenses would need to be adapted to include the training of AI models, the use of works for training AI models. There are, of course, countries where such an authorization is not necessary for a CMO to develop a new licensing activity. And in this case, CMOs may, on a voluntary basis, adapt the mandate of their authors members to develop this new field. And so they need to adapt their bylaws and representation agreement. And where CMOs have such authorization or mandate, they have usually expressed a reservation of rights according to Article 4 of the DSM directive, and contacted AI companies to initiate a negotiation of a license. However, all this has so far been in vain because AI companies are not interested in entering into licensing negotiations. And this situation is the result of regulation and market development that are not conducive to any licensing negotiation. So, and in this context, I think it's very important that we all realize that the AI Act is not sufficient to develop a licensing market in which CMOs would play a role. So I can develop a few arguments in this. Let's start with the reservation of rights. We consider that it is completely insufficient to trigger a licensing incentive for AI companies. So bear in mind that rights reservation is very difficult to handle for individual authors. We are not aware of any technology or any tool that would be convenient for authors who are not the distributors of their works. Their works are usually licensed by many different operators who make the works available on different types of media and platforms in many different formats. And when the CMOs have expressed this reservation of rights on behalf of their authors, as I already said, they didn't have any interest on the side of AI companies. And For me, the problem lies very much in the misinterpretation of the impact of the opt-out and the reservation of rights. That also comes from the EU authorities, who consider that reservation of rights is the way for rights holders to regain control on their works. I think Sabina repeated that this morning, regain control on their works. But AI companies do not see it like that. They consider that the reservation of rights is a prohibition to use the works. So if you reserve the rights, they say, okay, we will not use it. No incentive for any licensing in this context. And this was very clearly put it by AI companies in a workshop that the Commission organized a year ago. So in this context, our feeling is that improving the opt-out system will not help authors if in the end there is no more incentive. So we firmly believe that new measures and initiatives are needed to develop collective licensing that will trigger authors' remuneration, because this is what we want. I mean, if they use the works, there should be remuneration for authors. So we firmly believe that there is a need for measures at EU level, member states level, to foster a collective licensing market that would deliver remuneration to authors. This is backed by some member states. If you remember, the Hungarian presidency did a policy questionnaire on AI and copyright, and the summary stated that a significant number of member states were of the view that the mass scale of AI-related copyright uses and the practical challenges of the rights holders in monitoring them both underline the importance of collective management in this area. So a new approach should consider the limited application of the TDM exception in the case of generative AI and reaffirm the principles of authorization and remuneration for the use of the works that will force AI companies to seek licenses. It's also important to ensure the diversity of the training data used. There were several talks this morning about the need for high-quality data, and for me, high-quality data mean authored works, human-created works. So if we want that these tools and models reflect European culture, European languages and creativity, we need to ensure that AI companies are obliged to enter in licensing agreement with CMO representing the European repertoire in the different creative fields. And I think, I mean, we can discuss that further, that they are well equipped. CMOs are the best organization to handle this. They faced a few years ago the management of platforms like YouTube, which represent millions of works and data to handle. So I think there is no other organization that are the best place to handle such licensing agreements.
Thank you, Cécile. Anthi.
Thank you very much. Kalispera σας. Good afternoon, everyone. It's a real pleasure for me to be here today and to participate to such an interesting conference. Thank you to the Hellenic Copyright Organization and Daphne for the kind invitation. I'm also delighted to be part of this panel alongside colleagues from Brussels and to see some familiar faces in the audience. To begin, I'd like to briefly introduce IFRO. As already mentioned, IFRO is the International Federation of Reproduction Rights Organizations. It is based in Brussels. It serves as an umbrella organization. We have as members collective management organizations, author and publisher organizations focusing on text and image-based works. We currently have over 160 members from some 90 countries. And our mission is to develop and promote effective collective rights management in order to ensure that copyright of authors and related rights of publishers and other rights holders are valued through the lawful and remunerated use of the content. Now, moving directly to our topic, copyright and collective management in the age of AI. And this is a broad topic, I must say. There are so many things we could talk about.
A lot have been already said, both in the previous panel discussions, but also by my colleagues just before me. I have only a few minutes, so I'll try to keep it brief and highlight some points that could be further discussed later. Let's go back to the basics. Generative AI is undoubtedly one of the biggest challenges CMOs, authors, publishers, artists face today. We have the large language models, the so-called LLMs, which are built on vast collections of copyright-protected works, and the training process remains highly opaque until today. So AI, when trained on these large data sets, which include copyright-protected works, it means that there is an act of copying that takes place. And copyright laws are designed to prevent unauthorized use and unauthorized copying of these works. So we need to ensure that when these processes take place, this copying needs to comply with copyright laws. At IFRO, we believe that it's entirely possible to be pro-AI and pro-copyright. Actually, these are two goals that complement each other, and they are not contradictory. And this is where licensing comes into play, because it provides the most effective way to marry AI innovation and copyright protection. Rather than relying solely on exceptions and limitations, which are all know that are often complex and open to interpretation, licensing is the most secure way to ensure that these processes are taking place in a lawful way. And I'd like now to move to the practical side of things, because someone would ask me, okay, but what's at stake? Are there any AI licenses? Because we heard a lot just before. Spoiler alert, there are. And I'm very pleased to share with you some of them that have been launched by IFRO members alongside the license that was already mentioned before from VG Wort in Germany. We have 4 more IFRO members that have announced/launched, because we are still expecting some of them to be launched during this year. We have CCC, the Copyright Clearance Center in the US. We have the CLA in the UK. We have the Copyright Agency in Australia. VG Wort was already mentioned, and JAC in Japan. The common element in all of these licensing models is that they offer AI licenses for internal business purposes, to facilitate the work within the organization, to make a summary, to make an analysis, to use it later in a staff meeting, and etc., etc. But just a couple of days ago, CCC in the US announced a new AI systems licensing, which will be put on the market later in 2025. It is a new, voluntary, non-exclusive license to enable organizations to use lawfully acquired works. And it is for inputs, for the AI training, but it will also be used for external purposes. So these are some of the points I would like to raise in my initial presentation, and looking forward to our discussions. Thank you.
Thank you for keeping time. Johan?
Thank you. Yeah, first of all, also thank you, Daphne, for the invitation, and thank you, everyone working at the Hellenic Copyright Office. Happy birthday to all of you. Also, Eva, happy birthday. So I represent APO Artists. We are the European Federation of Collective Management Organizations for Performers, European being the continent, not the market. And I've already had the pleasure to introduce our Irish member, Rob. But in Greece, we have 3 members, being Erato, Dionysos, and Apollon. So we actually work with them to make sure that the Greek performers are heard in Europe, in Brussels. But because, Bernd, you said we're silent. Well, we're not silent. We're just not being heard right now. That's the difference. So we do speak, we do say things, it's just that people are not really listening, because the debate right now is really focused on this reproduction right. You know, and that's actually giving AI developers what they want, because it's the AI developers that found this Article 4 as a ground for them. Like, they were doing stuff they knew, oh, we're not allowed to do this. Can some lawyer please find a way that we can get out from under this? And then someone said, like, yeah, there is this TDM exception, you can use that. And then we all bought it. And we're all caught up in this discussion on reproduction right, as if the only thing that the AI developers do is reproduction. And if you then clear the reproduction, you get paid for reproduction, then you can go be AI. And then there's even AI developers, because they've gone one step further. There's a lot of AI developers that say, like, well, our training, we don't actually make copies. You know, our machines don't make copies. So they don't even make copies. So they don't even fall under Article 4. So they can just go ahead, because they don't do a reproduction. So they do nothing connected with copyright. And we all buy it. And we all buy it also because on the other sides, there is some representatives, well, they're not at the table today, which is sad, but I'm talking about bigger producer companies, music and audiovisual. They have this reproduction right on their catalog. So they also see a way out, like, okay, if you've got the reproduction right, we've got the reproduction right, we can get a thing going on. We believe that we can get some licensing going on. And how do they do their licensing? Because another thing you said, where I disagree, I'm not here to disagree with you, but there's another thing that you said in your introduction is we don't see collective licensing. Well, I only see collective licensing, because the opposite of collective licensing is individual licensing. And if you look at what music producers are doing, if you look at what audiovisual producers are doing, when they offer a license, and this is what makes the news, they get paid 6 million euros because they have a deal with AI developer X, and they get 10 million there. Why? Because they sell their whole catalog. They're not selling records. They're not selling movies. They're just say, here's our catalog, everything. You have access to it. That's collective management. When you sell catalogs, when you give access to a catalog and you license with one single contract the rights on the whole catalog, that's collective licensing. Now, they learned from us how to do the collecting, but on the other side, how to do the distribution, well, they still have a lot to learn, because they have other mechanisms. We have principles, we have some administration fees, okay, and then we have principles of non-discriminatory treatment, we have diversity and stuff like that, and so we're there to distribute in the most fair way. They're there to distribute based on contract, if ever there is a contract, because definitely in the music industry, there's a lot of performers that still do not have a contract. So there's no basis to pay you because there's no contract. And in the audiovisual industry, it's the same thing. There is this presumption of transfer, but does it go that far to say that? So, but just to say that we agree when people like Professor Stroel come up and say, like, we need something now, because for what concerns the remuneration, we need a fix. And I love the ideas of introducing remuneration rights. We're also confronted with what I call policy tiredness. Like in Europe, they're really tired of making new rules. It's like another thing, because they just published their work program. It's literally saying, we're not going to do anything anymore for the next year. We're just going to look at what we've done in the past. But I think here, there is still a ground to ask for something more. When people were able to do copying on tapes and blank CDs, they reacted. We got private copy. When downloading was introduced, we got the making available right. When social media became really big, we got Article 17. And this AI thing is supposed to be bigger than all of that together. And still it's like, oh, yeah, but you've got your legal framework. So I think there is room to still have 1 minute. I think there's still room to introduce new stuff, whether that is a remuneration right or whether that is a new exclusive right on AI training. I'm just launching ideas here. It's just that there is still room to do something new. And I think I'm going to stop it right there. The rest we can do it.
You should.
Part of the discussion.
Yeah.
There we go.
Okay, thank you. Okay, now I'm going to ask a few specific questions. Some of them already came up to a certain degree in your opening statements. I'll follow the same order again, but others are allowed to chime in. So this is an open discussion. Adriana, AI models, generative AI models, are trained, and you mentioned that actually, on enormous quantities of data, including billions of copyright-protected works or other protected subject matter. If you look at it that way, it's almost a no-brainer that collective rights management should play a major role in solving the copyright problems here. And in practice, okay, you've not remained, you weren't silent perhaps, but there's no collective licensing happening. Why is that? What is the reason? It looks like I'm a football fan, a chance for an empty goal. Why is it not happening?
Maybe you should ask the AI companies why this is not happening. Yeah. Because
if they were there, I would ask them first. But
because what I can say is that
I haven't seen them.
What I can say is that our members, they exercise the opt-out as soon as the act was finished, and they.
How did? By the way, sorry for interrupting. How did they do the opt-out?
Well, they made it public in their websites, and they addressed also directly letters to the companies to propose to sit and to start negotiating. And the answer was no one. Silence was the answer. Silence was the answer. So this was the end of the last summer, more or less, no? The end of last summer, and since then nothing has moved. We have been, as I tried to explain at the beginning, very proactive in this framework that we have right now, well, we all know that this process for the Code of Practice has to finish at the beginning of May, and we've been participating in all in the copyright particular working group, but also in the others, making proposals and trying to explain that there are some situations in which, they're not adapted for copyright or for right holders. For instance, this robotic C reference, if you know how licensing of copyright works, you know that authors, they're not the ones who are dealing with the final, with the reproduction, with the material that it's made, for the reproduction. The licenses are given for the content, like not for the. I can find a name. The support for the.
CMOs are not delivering actual content. And so that could be a reason why.
So that's one. For instance, that's one very practical problem. Yeah. And so, I mean, the question is that I think, and I'm going back again to this reasons that I was trying to give at the beginning. One is that we think that there must be like more consciousness at a political level, at the European Commission, at the member states and the European Parliament, about how relevant it is to really balance these two markets, these two sectors that are creating this market, this AI market, the creative sector, without which we couldn't have any kind of AI, of generative AI, and then the technology, the technology or innovation market, if you want, that for us is, I mean, they're very much combined, they need each other, and there is also a lot of innovation from a technology perspective on the creative and cultural industries. They are also an innovative sector. Okay. So, and finally, if we don't see that it will be a proper achievement at the end of this process, we may ask for an amendment on the legislation, because we need to be able to enforce our rights. And as Cecile was saying, and all the rest of the colleagues, enforcing the rights, it's also being able to license them and to live from them.
That brings me actually to the question that I have for Cecile. You already anticipated this in your introductory remarks. You were saying AI companies are not interested in collective licensing, particularly because the current legal frameworks not seems to be very conducive to that. And you mentioned the opt-out problem, which is not working for authors. And you mentioned the need for, and you, Adriana, you just said the same thing, and I'm sure you're all going to say the same thing, that there should be some kind of legislative intervention to foster that collective licensing. What kind of instruments are you thinking about? What could foster collective licensing? You have big AI companies. They have done big deals with big content providers. What could foster them to do more, to pay you, or to conclude licenses with you?
I think they need to be forced to, so that they are inclusive in the way, I mean, today they are cherry picking some content that they are interested in. So if you look, I think it's Martin Kretschmer who did a first review of the agreements in place according to public information. And the great majority of the agreements between AI companies and rights, I mean, content providers is with media or news or newspapers in the different regions of the world because of the language. So it shows that they are interested in what they call high quality content to feed their model with specific language, accurate news related language. But there is no, it's not an inclusive solution because it leaves all the other rights holders or authors and performers whose works has been scrapped on the internet, they are completely left behind. So I think the solution, I mean, collective rights management is the solution to be inclusive of the diversity
what kind of
the
instrument
content.
are you concretely suggesting here? Or maybe Adriana wants to...
I mean, first I want to say also, like Adriana, that we have been very constructive and collaborative in the process of the drafting of the Code of Practice. We want this process to deliver some result, and we put a lot of effort into being constructive and explaining our perspective. But if in the end this process does not deliver any incentive, I think legislation will be needed. We can talk about
like what?
Mandatory collective licensing. We can talk about extended collective licensing. We can talk about presumption of use of works by AI companies. At this stage, we are very open for a discussion, but the problem today is that this discussion is not happening. We are the only one talking about it, and we have nobody to talk about it, because for now, the Commission is very focused on improving the opt-out system, and it's a process we don't believe in to deliver remuneration. So we have no interlocutor to discuss possible legislative initiative, but we would be very much interested in it.
But let's be more concrete. Adriana, you have a concrete
Yeah,
proposal. Are you going to refer to the Spanish proposal?
Yes, I was going to.
Okay.
Do you think it's a good idea?
I'm not saying the proposal is a good idea, but to perhaps mention it
Yes,
could be a
I
good
wanted
idea.
to mention, by the way, I am Spanish, if you didn't realize with my accent and my difficulties of finding some words in English. So I know a little bit the experiment of the Spanish tentative to put over the table a proposal that will at least start, I will say that will at least open the debate or open or show that we have to see what options can be over the table, and we can discuss about them. So the Spanish government, one side of the Spanish government developed this model for Spanish language. And of course, they had to train with the Spanish content, and part of the content was, of course, protected. So the other part of the government, the one at the Ministry of Culture, developed this royal decree that was based on extended collective licensing, which is not in the practice of Spanish copyright tradition. We don't have a Nordic models, but it is an option, of course, for any European country. And I think that the goodwill of this essay was that it gave all the options, and I think that it is also very much something that is it is really on the basics of collective management today as well, because it was a model that made coexist individual licensing with collective management licensing, and with collective management licensing for those creators. I think that was one of your questions also, Bernd, who are not members of any CMO. So this proposal was shared with the society in Spain and through a public publication, and it was completely attacked. Aggressively attacked by AI companies. And the government so far decided to take it away. Also, and I think this is also, in order to be fair and transparent, I also have to say that right holders were not completely aligned neither. So I think this is also a problem that we have as a sector, and that it's, well, maybe we will never be completely aligned because interests are not always the same ones, but I think that we have to we agree on the basics, and so far the basics are so basic because we don't get licenses that we all agree on that.
Okay, fairness dictates that I now move towards this part of the table. Antti, I have a question to you. We've heard this a number of times, I've said it a number of times too. We have seen large media companies, press publishers mainly, including major press publishers in Europe, agreeing with large tech companies concerning AI training. You've seen that. Now, many of these media companies are actually members of IFRO companies, IFRO CMOs. I heard you argue, but maybe I didn't hear that properly, for the opportunity for your members to actually offer collective licenses. How does that work? Are you actually saying that these press publishers unlawfully entered into these contracts and that they don't have the rights? Or are you saying that IFRO members don't have the rights? Or does everyone have the rights to give the same licenses? This is a familiar problem in collective rights management, I realize that, but how do you look at that?
Thank you for this question. As I mentioned, these are all non-exclusive voluntary licensing models. So the organizations, the IFRO members that have already announced or launched, as I mentioned, there is a difference still because we don't have all these models put on the market, do not prevent the direct licensing of publishers with the media companies. If I may, I just want to mention something to build on what Adriana said, because she responded to a question, how have your members reserved the rights? And Adriana said they have published this on their website, if I'm not mistaken. And there might be people here wondering, okay, but this is machine readable, maybe it's not correct, it does not fulfill this criterion. And I'm asking to all of you, if you have ever used any AI model to ask something, have you made your prompt understandable, let's say, in metadata for the model that you have used, or you just asked in natural human language, please give me an image, a photo of this, or please draft me something. You have used your human language. So as long as this is published in human language, it should be understandable by AI model providers, and it is very well machine readable in order to be understood.
Yeah, this is an issue, of course, that hovers over this larger problem everywhere. But you do realize that there are different opinions on that. We have seen the Leon opinion in Hamburg, where the Hamburg court basically said what you just said. an AI can read anything written in natural language, but there are also other opinions. The court in Amsterdam said the exact opposite, actually. And as long as we don't have a decision by the European Court on what is machine-readable means, this remains an open question. It could actually be one of the many reasons why AI providers are not so impressed by opt-outs that are simply published on a website. I could imagine them thinking, oh, well, whatever. That's not a 4-3 reservation. So that could actually be one of the many problems that you're facing. Okay, sorry for lecturing you. This brings me to Johan and the issue of the remuneration right, which has already been mentioned in an earlier panel, which also already came up in your introductory talks. There is, of course, an argument to be made here, apart from whatever kind of instrument can be devised to foster collective licensing, at least to introduce a mechanism to guarantee fair remuneration to authors. Alain Stroel earlier argued for a residual remuneration right. We've seen Martin Zemfleben, another colleague of mine, arguing for an output-related reservation right. There have been, Christoph Geiger has been arguing for a levy-style remuneration right. There's all kinds of remuneration rights that are currently on the table, at least in the academic sphere, and possibly also in the political sphere. Now I have a question concerning it. Assuming you agree that a remuneration right of some kind is a good idea, and I assume, well, with you, I'm not so sure you agree when I say something, but someone else says that. Now my question is, how do you imagine such a remuneration right, if you agree, to operate in practice? And this question I think you've heard before. When we're looking at a ginormous potential right holder base of anyone who has ever expressed him or herself on the internet, because that's what these generative AI models eat. They don't just rely on professional content, which is already a big number of right holders, but they eat everything. Every post on Reddit is interesting for an AI professional, and there's some copyright attached to it. All the photos on the photo sites, everything that any amateur ever produces, and most of that is copyright protected, is devoured by these models. How would a remuneration right work in practice if you have almost every citizen in the world as a potential right holder? That could either be an extremely expensive system, or everyone would get 1 or 2 peanuts maximum. I have difficulties understanding how that would work in practice.
I agree. And well, to first respond to your first question, yes, if you would look at it really philosophical, then everyone making the smallest creation that, I mean, if I make a joke, send it to my friends in the WhatsApp group, and Meta has access to that conversation to feed their AI with conversations between human beings that result in laughing icons, and then, okay, the first message must have been a joke, so I'm gonna learn what comes before the laughing icon. So
that's probably valuable content.
Yeah, am I then the author of the joke? Maybe I'm not even, maybe I heard it from someone else, but that's for me, it's another discussion. Like and I think that goes for everyone here, we do represent a specific category of right holders that do have a right in their creations. So if there's millions of other peoples out there that think that they should be remunerated for the joke they told their friends, then let them start their own CMO. That's not what we're here for. So But
they will.
Yeah, but let them do that.
Or a lawyer will.
Let's have the discussion first with those groups of right holders that have already taken the decision. We like to group up in a collective management organization because we feel stronger as a collective than as an individual.
So that's to answer the first question. And then, because the initial question was, how do you see the actual remuneration, right? I mean, if you want us to discuss that in detail, we would need a whole day for that, because there's different concepts. But the concept of remuneration, right, always starts with one starting position. You admit that you've lost control. It's not because you lose control over your rights that you're no longer entitled to a remuneration when your work is being used. So step one, and that is something that performers can do, accept that we've lost control. And then in return, the focus gets put not on the exclusive right of controlling stuff. If producers think that they, when they get the exclusive right, are able to control, well, let them try. We even support that. I mean, we still have it with piracy. We support that. Like, the exclusive rights are there actually to be supported, to be looked after. But we as performers represent a category that has lost control, but we still think we are entitled to remuneration, something that in the clear model presented by Professor Stoel is unwaivable and parallel to the exclusive right continuing to exist. And whether you then connect that to, whether you give that to a performer that has made an opt-out choice, or specifically to the performer that has not made the choice to opt out. You can also say, well, if you opt out, then you're in the relationship with the producers and you should get your remuneration from them. So there is many different ways of introducing a remuneration right, but the concept is always the same, that you are entitled to continue to be remunerated even though you no longer control your actual right.
I see Daphne frantically waving.
We're out of time.
We're out of time. But I had such a great question. Left. Just one, a quick one. It's an existentialist question. And just a good one for the afternoon. Existentialist. And I want very quick answers to this question, which is really about what authors feel about all this. Collective... Oh, you're already leaving. Yeah, okay. Everyone here at this table, including me, assume that creators just want money from the AI providers, or at least a fair license. But is that really true? If you look at the ethical responses to generative AI from the creators and from many other fields, what I also see a lot is, I just don't want this to happen. Yeah. I don't want and that's for the performers, I don't want my voice being used by an AI. I don't want my likeness to be appearing in the film when I'm dead. I don't want my novel to be AI-ified. And that's something. How you all assume here at this table that collective licensing is the way forward. But is that really what the creators want? That was my quick question. Now, a quick answer. You can probably not, but maybe Adriana?
Well, I'll try to be quick, but I think they feel robbed. And I think there is this moral rights dimension also that you addressed, and it has to be also taken into consideration. This is why, when I was explaining the Spanish situation, I said that on the right holder side, there were not all the positions were the same ones. But I think that as CMOs, our responsibility is to find solutions and to balance situations and to try to get the best outcome for the situation. So what I can say from my members is that what they are trying to do is try to license the input, so all this mass that was not licensed before, and then try to find solutions also for the output, which is another issue that we don't have the time to talk about. I think it's legitimate to feel robbed because, well, for me it's a fact, but I think that our position is to try to find solutions for the future and for our market on AI.
Anyone else? A quick remark?
Authorization is not negotiable. We are not negotiating this. Just two very brief statistics that might help. They come from the UK, ALCS and DAX. So they both represent authors. 81% support collective licensing to ensure fair remuneration. That is from a study carried out by ALCS. And we have DAX, Design and Artists Copyright Society. 84 of respondents would sign up for a licensing mechanism to be paid when their works are used by AI.
That's interesting. Okay, time's really up, I guess. Thank you very much for this conversation. We could have gone on for a while, and for your patience.
Thank you very much. I am sure that everybody needs a break. I would like to be back in 10 minutes, 5:45. So it's always the last panel is the less favorable position, but 10 minutes just to have a little bit of fresh air, a little bit to have the mind a little bit clear. And we will start 5:45. So if you would like to listen, please be back 10 minutes. Οκ, έλα. Thank you. Okay, I was expecting that we will have a delay. This was for sure. I have asked already the kind support of interpreters that we very much thank you that they had to go through all our speeches, very technical speeches, all the speakers, sometimes a little bit fast-speaking speakers. Thank you very much for all your patience and your support. And yes, we will, okay. So we are starting the last, but not least, panel about combating online piracy. I had some things to tell, but I won't say anything. We don't have any time. You already know that we have, let's say, a quite effective system combating online piracy. And we had also lately some amendments that the most interesting feature is that we have also adopted some administrative fine for the users when they are combating online piracy. We have administrative fines ranging from 750 euros till 5,000 euros, depending whether they have a commercial benefit or not. So I won't say anything else. We will start with Audrey Timar. And she is a copyright counsel in Google. I won't say anything more, just to save time. So Audrey, she will talk about 30 years of fight against online piracy. But the most important, she will tell what the lessons for the present are from these old 30 years. And probably the 30 years was not a coincidence, I would imagine.
And happy to be here. I will talk about 30 years of fight against piracy, which is actually 20 plus years if you think about the history of Google, to be honest. But since it's an anniversary conference and happy birthday for the Hellenic Copyright Organization, it became 30 years to sum it up, basically, the 20 plus. So what we do at Google in terms of piracy, we are engaging with various right holders and lawmakers, and we address their problems and needs and try to tackle various technical constraints to prevent privacy in the online sphere. And we do this in the past more than 20 years. So I can say that we have a sort of extensive practical experience in this field, and we try to come up with newer technologies in order to prevent efficiently piracy in the online sphere. So I won't go deeply into Google's history. I think all of you might be aware that we are a pretty long-standing company and we had various technical advancements. And part of these technical advancements since the 90s, we had various technical solutions which help nowadays right holders to protect their rights in the online environment. So our piracy work is construed around 5 anti-piracy principles which are available publicly for everyone. And I will go with some examples from our technical solutions around these 5 principles, which we find the most important in terms of fighting piracy. So the first one, which you are most likely aware, is that we need to create more and better legitimate alternatives, because having legitimate alternatives is the best way to prevent piracy in the online sphere or in anywhere else, actually. So what we do in this sphere when we think about search and the evolution of Google search, for example, if you type in now in search that you want to watch something, let's say the recently 4 times Oscar winner Anora movie, then search will first show some so-called watch actions, which are legitimate options how you can watch this movie in your own country. Of course, the appearance can be different depending on the exact country. And for example, if you write in some other type of movie or drama, the solutions can be different. So for example, I brought also a Korean example, and in Europe, of course, there is a limited option, but still there is available legal option to watch this kind of material. Then if you don't really know what you want to watch, then you can write in to search what to watch now. And the first option what you will see is various options for movies with all the legitimate offers from various online players or even broadcasting stations where you can watch these alternatives legitimately. And the last one is the so-called TV and movie listings, which is mainly to have people watch linear broadcasting stations materials when they are interested in certain programs which are airing at the broadcasting stations program at the time in the country where they are looking for the titles. So these are some options which we use to direct users to legitimate sources where they can actually reach these contents. I brought examples from the movie industry, but there are some other examples for other type of contents too. When we think about how else we can actually direct people to legitimate content, we can also think about YouTube, which is one of our biggest products, where creators can reach globally a really huge audience, and they can engage with this online community and provide legal alternatives and legal sources for users where they can watch the content online. And as we go further, the second principle is follow the money, and the third one is be efficient, effective, and scalable. I combine these two because they have a lot of interrelated actions and they are really close to each other. So basically, following the money, what we mean by it is that we apply effective removals of illicit sites on our products. And with this, we cut off monetary supply to all these commercial ventures which are engaging in piracy. Follow the money because all these ventures are basically businesses, just like any other business. So if they are cut from their monetary supplies, it helps to prevent further infringing activities of these ventures. How we do these removals, it's based on massive AI technology. We streamline the removals and use various tools from one side to detect and from other side to remove on scale efficiently illegal materials online. If we think about why we talk about efficient, effective, and scalable solutions, when we talk about global platforms like, for example, Google and search, then in search we receive a little under 2 million copyright takedown requests one day. So we can imagine that we really need a scalable solution where people can remove efficiently a huge amount of illegal content when it's displayed. And another side of these removals is, of course, that we have there is also an advertising on the online platforms. And if we remove content, it's important that this content will not be able to be used by others for advertising purposes. So when we remove sites, for example, from search, then we will also remove advertisements which are linked to this search queries. And with this, we also go back, of course, to the follow the money, and we will cut advertising revenues effectively for those who try to use advertisement linked to these illegal content. Another interesting or useful sector where we have some technological solutions is the demotion signal. It's not a new thing. Actually, it's existing since 2012. It's a signal which we consider when we rank search results. And basically, this signal is based on the valid copyright removal notices to a certain site. So how it works that when there is a site which receives a large amount of copyright takedown notices, which are valid, because of course there are fraudulent notices also which we need to consider in the system, then this site will get a sort of demotion signal, which means that it will be deranked. So basically it will fall down in the ranking of search. And how does it actually help in fighting piracy? It helps because the traffic will also go down for this site. So when a site is demoted by this signal, then based on research, that site which is demoted on average will have less traffic by 89%, which is a pretty high amount. So even if we don't remove a content, the demotion signal may be a really effective tool to actually prevent income for infringers over the platform. And when we fight against piracy, one thing we also consider is where the user is, where we fight against piracy. Because of course it really matters what kind of, for example, search queries we consider when we think about piracy and prevention of piracy. So for example, I tried to bring a Greek example. I have to say it was quite difficult. I tried actors, I tried musicians, but the result wasn't really different. It seems that Greek people look for musicians and artists a lot in English instead of Greek in Google search. However, when I looked at the famous soccer team, Panathinaikos soccer team, then the result showed in trends that basically the search results really differ whether I use English or Greek terms. So when we fight against sites which have pirated content, let's say the live games of this kind of soccer games, then we need to consider that they won't really just look for, let's say, English terms. People will look for Greek terms. On the other hand, it's really unlikely that someone will look, let's say, in Chinese for the same term, because it's not that much likely that someone from China in Chinese language want to look for, let's say, a ribbed live stream of the game for this soccer game. And if we move out from the search sphere, we have also other programs which prevent piracy. So next to search for other products like Drive and Cloud and also Google Images, we have the Trusted Copyright Removal Program, which also helps with submitting bulk notices and fast, scalable removal processes for everyone. We also have the YouTube Copyright Management Suite, which most of you might be aware of. This consists of 3 different tools, but the most important or the most used tool is the Content ID tool, which basically matching certain content submitted by right holders in the system with the content which the users upload, and it prevents uploads of already existing protected content in this area to make it simple. And this system was really difficult to make because, as you can imagine, on platforms like YouTube, it's not just that people try to upload things as they are, but they try to amend it, modify it. They try to upload it in a way that actually the system will accept it. So they will use mirroring, they will change it into black and white, they will also change the ratio, or they use color shifting technologies. Everything what you can expect creative people to do to actually change the videos. And when we talk about preventing abuse, we mean basically in the piracy sphere that we need to detect and reject false claims for infringement, because of course if we have false claims, that can have a lot of side effects on free speech and access to information. For example, in this Spanish case, there was an effect where basically they tried to use false infringement claims to manipulate the right to be forgotten in the EU, and it made pretty huge because it was about investigative news writers who they try to silence with this technology. And when we talk about provide transparency, we have various tools which you can find, like you can check in the Ads Transparency Center what kind of advertisements are available now in Google, in which territory, and for what kind of political advertisements, for example, and a lot of other information, including our transparency report, which discloses various numbers which you may be interested in terms of what kind of removal notices we receive and how we handle them in practice. And so what are the lessons for the present for all of these, and looking all of these tools which we developed in the past like 20 plus years? We found that follow the money basically works, because if we cut off these ventures from receiving more monetary benefits from their activities, then they can't really continue these kind of infringing activities. New ventures might come up, but essentially, if we can find the way where they get money and we can prevent them from getting money, then it will be a really useful tool to prevent them from further infringements in the future. And also building upon these experiences, we try to combat piracy in various ways with building various features into our tools to prevent infringement. For example, an interesting data that you might be aware that in all of our products, of course, the takedown procedures are available, that you can report infringing content and the notice and takedown procedure takes effect. It's also available in Gemini for the same purposes. However, in the last year, we only had 146 reports in the whole year for Gemini for takedown, and we consider it as a good result of building our experience in fighting piracy into our products. And also in terms of AI overviews, we have the same experience that they can actually increase traffic for various sites if it's well maintained and well made. And since we are a bit short, this will be my presentation. I hope that I gave you some useful pointers about how we fight piracy.
Thank you very much, Audrey, also for keeping the time. So the next speaker is Melissa Morgia. She is a director for Global Content Protection and Enforcement at IFPI. In the beginning, during my greetings, I forgot to say a special thanks to all the speakers that came from abroad, and also a special thanks to Raul that he came from India. So also a special thanks to you. Melissa, you have the floor.
Thank you. Good afternoon, good evening, everyone. Huge thanks to HCO for having me today. Daphne, thank you for the kind invitation. It's a real pleasure to be here in this incredible location. So today I'm going to be speaking about how AI is changing piracy. I will begin by giving a brief introduction of technology in the music industry, and then I'll focus in on AI models, AI outputs, and then I'll talk about some of the principles that we believe should be applied in order to safeguard copyright in the enforcement sphere. So for those of you who aren't familiar with IFPI, we are the voice of the recorded music industry globally. We have around 8,000 member record companies, including the major companies as well as independent record labels. We operate through a network of national groups in around 70 countries, including here in Greece. As Daphne said, I'm the Director of Global Content Protection and Enforcement. My department's mission is to safeguard our members' content against unlawful uses and to facilitate the conditions where music can thrive. So my team is very much at the forefront of fighting piracy on the ground, and as such my presentation will be very practical, so I think it will be a sort of different lens through which to look at these issues. The other thing to mention is that this is really giving a snapshot into the current state of affairs. I'm aware that there's legislation that is coming into force in the future, but this is really what we're seeing on the ground now. The first point I wanted to make is that the music industry has always embraced technology, and AI is no different. In fact, AI has actually been used for the music industry for some time now, particularly on the production side. And our members are actively exploring opportunities to use AI to provide innovative and new ways in which fans can engage with their favourite artists and their favourite music. There have been some really great examples of such cases recently. You may have heard that the Beatles were able to release a new song with John Lennon's voice. And also AI was used in the case of Randy Travis, where this artist lost his voice after having a stroke, and he was able to release new music thanks to AI. Obviously, all these examples were situations where the artist gave their permission for that use. And then just finally to note that our members are used to licensing under new conditions, and it was one of the points that was raised earlier that we faced a similar issue with the emergence of social media and UUC services some time ago, and our members were able to find ways to license their rights in that new environment. So, the music industry has been through transformative change over time, and of course, piracy has evolved in parallel with that. So, the music industry is very adept at evolving and adapting to new threats, facilitated by new technologies. And AI is really kind of the new frontier in that evolution. And I think in this context, you really do need to take an expansive conception of piracy. And here I wanted to address two main aspects of AI, the AI models and the AI outputs. And just wanted to also note that one of the interesting trends that we see is that AI has actually introduced new uses for existing forms of piracy. So you can see here stream ripping, which is a long-standing issue for the music industry, which is the ability to rip content from licensed platforms and create a permanent download without any payment or permission. That is now finding new uses in AI processes, and I'll come on to that. So I think this has been covered pretty well in the previous sessions, but as you know, it's relevant to understand the sort of key phases of the AI model life cycle, the data collection, pre-processing of that data, the final creation of a data set, the training of the model, the creation of a model itself, and then that model generates outputs. But I won't dwell on that. But obviously there are many opportunities for restricted acts to be engaged in that context. So beginning with models, the two categories that are most relevant to the music industry are generative AI. So as you can see there, it's content outputted by machine learning models that were trained on existing material. Of that category, generative audio is obviously at the top of the list, but also generative video, generative images, and large language models that can obviously output things like lyrics. And we're increasingly seeing sort of multimodal generative AI where it's not just text that users put in, it's all formats of inputs, including audio files and video files, for example. The second category is vocal cloning. This is a process that creates a digital replica of a person's voice using a vocal model. And in this category, the subcategories, and I'll show you some examples in a little bit, are vocal covers and deepfakes. So beginning with the training data, we've discussed at length earlier about the fact that data is mined and ripped to create data sets at scale. And in this context, we know that it's happening and it's happened without permission or payment for that use. Although we know this is generally happening, as I'll come on to talk about, we don't actually know in many circumstances what that data then looks like for specific models. It may well have been ripped from pirate sites and also legal sources of music which have technical protection measures applied to them. So just to flag here, this is a great example of where we're seeing stream ripping of content at scale. There is content available online, music content available online, and we are seeing these tools starting to emerge where you can actually rip content at scale and create a data set with a single script. So that technology exists, and it's really quite terrifying, and obviously lowering the barriers to entry. And just for completeness, we also see some of the data sets made available for others to use online as well. So turning to the models, there has been an absolute explosion of consumer-facing services that utilize generative AI as well as vocal cloning technology. My team specifically monitors hundreds of them. This is an example of a generative audio service. As you can see, you can include a text prompt to generate a song. You can also upload an audio file. You can include lyrics. And then it's difficult to read, but on the right there, there is actually the option to rip a reference file as an input on a particular service there. This is an example of a vocal cloning consumer-facing service. What we see here is websites offering a whole range of artist and celebrity voices. You can choose which voice you want, and then you simply add an instrumental track in the background, and you will have a cover version of your chosen voice singing that particular track. As mentioned, we have mobile apps doing the same thing. So easy to use. Literally, you can create these covers in minutes. And then we see bots. So on platforms such as Discord, you can create vocal clones within the Discord channels. And then also to mention that standalone models are also available online on AI platforms as well as in social communities. This is another example of an old form of piracy being used where the models and sometimes the outputs are shared via cyberlockers, which are our old friend used for sharing infringing content. So unauthorized use of copyright-protected content, as you all know, has been the subject of, or is the subject of a lot of litigation around the world, including by some of our members. I wanted to dig in a little deeper about the enforcement challenges we're seeing in practice. The first, and I guess most important, is the lack of transparency. And this really describes what we're facing right now. We have zero visibility in terms of any phase up until the model produces an output. And in some cases, even if a model is trained on a particular input, it doesn't necessarily mean it will be very obvious in the output. So we really have to use various methods, very time-consuming, very complex, to try and establish whether our members' rights have been used. So I've covered transparency. I would say the vast majority of models we've seen to date are closed and haven't disclosed their data sets. It was mentioned earlier, the issue of DeepSeek, which is an open model, but actually only part of it is open. So, as discussed earlier, there are different definitions of what an open model is. There are also evidential challenges. So, as I've also mentioned, there is sometimes very limited evidence in the outputs, and these platforms are also now introducing filters that prevent either prompts that are going to produce infringing outputs, or on the output side, which prevent delivery of an output that might include third-party content. So that, again, presents another barrier to detecting infringement. Another issue we have is actually knowing where the restricted acts take place. So we do see, often if we can find the company, we don't know whether they've actually done the training where they're located. It may well be somewhere else. We've talked about the issues around the availability of the exceptions. So, the legislative framework, wherever we're looking to bring a case, may pose challenges. We also see forum shopping. So we've seen several companies carrying out activities in places with very broad TDM exceptions. And so I think that is obviously no coincidence. And then finally, I mentioned the scale earlier. I think the barriers to entry are becoming lower and lower. And so we are seeing a proliferation of these services. And then I just wanted to show you some outputs so you can get a sense of what these models are producing. These are video, generative video services. As you can see, clear resemblance to famous artists being produced, very clear resemblance to famous album artwork. So that just gives you a hint of what they might be using as training data. And then here are some examples of a vocal cover. I'll see if this will play. This is the end. I actually wanted to play this one because I think it's a little bit... Sorry, I don't think that will work. But in each case, you can see here, the one I wanted to play was actually Taylor Swift singing The Weeknd. I think that's very recognisable, but you can see a lot of other artists singing other artists' songs being created by vocal cloning services. So this is really where we come to why do we care? So, not only is there an ethical issue about using an artist's personal assets, there is also exploitation of the artist's brand, and this sort of activity diverts revenues and attention from artist content. So many of these videos will end up on social media, UGC platforms, ad-supported services where, eyeballs matter, clicks matter. And you can see here, these are actually the same track, but once Drake's name is in it, the number of views goes up to 1.6 million from 8,000. So you can see that it really is exploiting the artist's reputation. And then I'm limited for time here, but I very quickly wanted to cover some of the downstream uses of these infringing AI outputs. So one example is in the pre-release space. So one of our major priorities is combating the distribution of content before its prior release date. There was this one example concerning Frank Ocean. Someone created a deep fake track, publicised it online as a real unreleased track, and was able to sell it for $10,000. And then the final example I wanted to give you is actually not strictly a copyright case, but one of the major issues in the music industry is streaming fraud, and that is the delivery of streams on platforms that do not represent genuine consumption. And we're seeing AI used to supercharge this type of activity. So essentially, in order to stay under the radar of the DSPs or the platforms' fraud detection systems, you need to have lots of content and not play it so often that it sends a signal that something fishy is going on. And so one of the ways that the perpetrators do this is actually to use generative AI to create thousands of songs and then thereby receive the royalties from those streams, diverting those from legitimate artists. And there is a pending case in America now with an individual that earned $10 million from this activity. I think I'm out of time now, So I think I know it's the end of the day, so I'll wrap up, but very happy to take questions later or at dinner. Thank you very much.
I'm the bad guy now. Okay, thank you very much. Yeah, thank you very much, Melissa. Very interesting. And now the Ziga Drobnik, we have introduced him in the morning. We gave him this hard work to have 2 speeches. We took advantage of him. So he will speak about the case of live event piracy, and he presents latest developments and good practices. I know you have prepared for 15 minutes. If you could, a little bit, it will be, yeah.
I'll do a bit less, as fast as I can, but as slow as I have to for the interpreters. So thanks a lot for having me here again. I'll speak now about a subcategory, and also thank you for still being here. I know it's a bit late. I'll speak about a subcategory of online piracy. It's live event piracy, which includes sports and other types of live events, such as concerts. We often only refer to sports, but it's actually it includes other cultural events too. So I'll introduce quickly the topic of live event piracy and the EU IPO's work on it. Then I'll mention the EU Commission's recommendation in this field, and I'll explain a bit 3 relevant developments that we've noticed. So compared to other types of piracy, the issue of live event piracy is that it's timely critical. So the main value is during the exploitation of their live performance, and that's why live event piracy is particularly damaging, because it's for the organizer, for the advertiser that uses highly expensive advertising slots. For example, athletes that are training, when you don't see them and then they have a performance, those few minutes and seconds. It's also reducing the value of the broadcast and increases the need then for very costly anti-piracy measures. So how we have, as the EU IPO, been involved in combating live event piracy. If you remember from the first panel that we are supporting policymaking, facts to support policymaking, we create tools and also raise awareness. And among our expert group on cooperation with intermediaries, we have published a discussion paper on live event piracy, and we looked at the different roles of online intermediaries that are involved in live streaming. We identified the trends, the challenges, and also the good practices when it comes to addressing these. So, for example, it showed that live event piracy is developing through several models, open web stream services or subscription-based IPTV services, and particularly these ones, the IPTV ones, was identified as an important trend in the recent years. We have also published a study in November last year on online copyright infringement, which covers the years 2017 to 23. And it shows that sports piracy events remain important, but it also showed that as a trend, IPTV became a major channel for piracy. Coming back quickly to our discussion paper, piracy services also put in place resilience strategies to withstand or immediately recover from enforcement measures which are targeting their service, for example, by the use of mirror websites, fallback IT infrastructure, or they also use virtual private networks to remain undetected for a longer period of time. And what are the challenges? Well, the challenges are reconciling different objectives. On the one hand, the need for prompt measure to limit economic loss, and because they have to be also sometimes quickly adapted during the live event itself. But on the other hand, they also have to prevent wrongful or overblocking to preserve the rights of third parties. A different challenge is also the nature of live streaming processes, because it involves different intermediaries at different stages, and some offer hosting services while others are more technical, and this can also change the legal context when considering necessary measures. Now, at political level, this issue has not been ignored, and my colleague Sabina from the Commission mentioned before the recommendation, which focuses on 4, let's say, pillars: on prompt treatment of notices, on dynamic encouraging the use of dynamic injunctions, which are tailored to live events, raising awareness on availability of legal offers, and also fostering cooperation. Now, in this recommendation, the EU IPO was specifically asked to monitor the implementation of this recommendation, and we're currently analyzing the received data. And we also set up a dedicated network of national authorities that have a role in combating live event piracy, and it acts as a forum to exchange information on good practices at national level. And here again, thank you very much to the Hellenic Copyright Organization for being such an active and valuable member to it. So I would like to speak now about the 3 elements, the recent developments that we came across our work, and that had specifically targeted at live event piracy. And these are injunctions, new administrative approaches, and cooperation and voluntary initiatives. So when it comes to injunctions, they have evolved over time and have become more and more effective in tackling online piracy, in particularly regarding live event piracy. There we have dynamic injunctions, which enable to extend the blocking order beyond the initially targeted injunctions. So it addresses when the blocked website reappears again through another location. But with these type of injunctions, there is no need for a new legislative procedure. So it aims to capture mirror websites and any other future internet location where this content might reappear. Then there is a second type of injunction that has also been developed, and it's the live injunction, which is specifically meant to address the live event piracy because it applies to the live content. So it's a temporary blocking of a website, of a server, and the duration is only for the duration of the live event. These measures can be then adapted throughout the lifetime of the order, but it doesn't mean, for example, only one match. It can also be a longer period of time, for example, a whole football season. The new administrative approaches, you can see on this slide, developing at member state level that are aimed at tackling online piracy more efficiently. They are, in a nutshell, evolving around increasing role of specialized administrative bodies and the development of voluntary collaboration. So we've been trying here in this table to classify a bit and summarize the different approaches that have been identified. Starting with those member states where dynamic injunctions are available. Here you can see France, Ireland, Malta, Spain, and others. They were directed also against. There are also some court injunctions that were directed against other types of intermediaries than the commonly targeted internet access providers. For example, alternative DNS resolvers, CDNs, or hosting providers. The latest development, which is not mentioned here, but also comes from Poland, where a few weeks ago there was the anti-piracy, interdepartmental anti-piracy team was re-established, and they're looking into details how to work out live dynamic web blocking procedures. So we're really curious about the outcomes of this. Then we also have regulatory approaches whereby an administrative authority is acting to support the effectiveness of a court order. So there is a court order at the beginning, but then this is its effectiveness is then being further implemented by this authority. This is the case in France with Arcom or Belgium, which was a new authority established in June last year. Then we also have some countries where regulatory approaches allow that an administrative decision is used as a basis to request a court order. This is the case in Spain and Lithuania. Then we have regulatory approaches where administrative bodies, such as here in Greece and in Italy, are competent to issue such blocking orders and make them also dynamic, which we heard also this morning, a very interesting introduction. Finally, to mention the voluntary approaches and cooperation agreements. So we have in Denmark, Netherlands, voluntary procedures whereby a court blocking injunctions is directed against one internet access provider, but all other internet access providers will voluntarily block access to this domain. And it can happen because it's a voluntary if it combines the largest internet access providers. It's very effective on a territorial level of the country. There are also voluntary procedures within with the intervention of an administrative authority that acts as a trusted partner between rights holders and internet service providers, which is the case in Portugal and Germany. And we've also come across different cooperation agreements between rights holders and national authorities. For example, memorandums of understandings ahead of important sports events, which was the case for the Olympic Games in Paris, or the use of tools which are developed by rights holders, but are given for the use to national authorities. This is the case in the Spanish La Liga, with the Ministry of Culture, where they offered the tools to identify sources of illegal streaming of live sports events. Now, there are more voluntary and cooperation approaches existing. Here I focused really on national authorities, but there are different ones between rights holders, payment services, dedicated service providers, so intermediaries are also part of different cooperation agreements. So, to make a bit of a longer conclusion, the live event landscape is permanently changing, which we also saw from the music industry. There's increasing occurrence of IPTV, use of obfuscation, circumvention techniques to avoid detection. We have noticed that also that there are changes happening on the sides of different actors that are also adapting. But instead of acting alone, here the strength is in numbers. So what do I mean? On the one hand, combining different type of actors in voluntary procedures that are involved in live event piracy chain. We've seen that with cooperation and voluntary agreements between intermediaries, rights holders, and national authorities. So the more, the better, the more we cover. On the other hand, also between national authorities themselves. The EU IPO is trying to make a difference here with a dedicated network to improve cross-border cooperation, starting with exchanges of information on the different approaches between member states, because this is important to tackle this phenomenon, which by nature takes place across borders. So we could continue with many possibilities that are not yet used, where the exchange of information could lead to great results. For example, the exchange on blocked domain names or IP addresses. So the playground here is very, very big, and much could be said, but the time here is limited, and I'll stop here. Maybe something for next time as well.
Thank you.
You're welcome.
Thank you, Siga. 13 minutes, okay. Last but not least, Saniva, thank you also for you that still you're here. Saniva, you have the floor. Saniva Hansson is the Vice President, Head of Policy of the region encompassing Europe, Middle East, Africa for the Motion Picture Association. Saniva, the floor is yours, and we are going to, she's going to talk about the site blocking, best practices and principles. Waiting for the PowerPoint?
There we are.
Okay.
Great. Good evening and kalispera. First, let me say thank you, Daphne,
for organizing this fantastic conference and for getting together such an amazing group of speakers. I was, of course, particularly delighted to be invited to speak on this panel, given recent developments in Greece, which we heard about this morning, of course, with the extension of the dynamic site blocking regime to audiovisual content also. Daphne, quick check. Being the final speaker on the final panel, does that mean I get unlimited time? I take that
yes,
as a...
but you won't have an unlimited public.
There we go. With that in mind, I'll dive right in, and I will actually try to abbreviate my presentation, maybe allowing for some questions at the end. So, what I'd like to talk about is a bit about why do we need site blocking, and really also focus on best practices for site blocking legal frameworks, especially in the context of dynamic site blocking. As you'll probably be familiar, for the Motion Picture Association, enforcement of copyright is a key priority. We do that through three means. We advocate for effective enforcement frameworks. We target operators of pirate sites directly, and we also work together with intermediaries whose services are used by users to access content, and it's within this third category that site blocking falls. I was going to give you a brief history of site blocking, but I think given the time of the evening, I am just going to skip through that and instead just tell you a little bit about piracy and honestly why we need site blocking. And I would say I probably don't need to convince anybody in this room who are copyright enthusiasts why copyright infringement is a bad thing. But it damages the industry, it damages right holders across the sectors, audiovisual, creative content more broadly. As Adrienne touched on, it also provides a source of income for those who place adverts, in particular, next to pirated content. And that can, for example, be organized crime. From my perspective also, another key point is that users of pirate websites are at an increased risk, and that's a significantly increased risk of exposure to malware, identity theft, and credit card fraud. And so with that, let me just skip through the following slides. Here we go. So, why do we need site blocking injunctions? And what I'm going to tell you now is probably going to come as a great surprise, and that's that operators of pirate websites don't tend to give their full name, address, or phone number. So when we do direct enforcement against them, actually finding out their identity is quite a difficult job. Difficult or in fact impossible sometimes to locate the pirate operators. And in any case, it will be costly and it will take a long time. And even if you can find who the operator behind a website is, they might hide, we say, in a location or jurisdiction with much lower IPR rights framework. So that's why we need site blocking injunctions. They are really designed to provide an effective and timely remedy and a means to stop large-scale online infringement, particularly when we're looking at anonymous and offshore operators. The previous speaker touched on this a little bit about, we have different types of site blocking injunctions. Static, which are the ones that block, where the orders block a specific list of locations. Dynamic, which is really what we're talking about today, and also here in Greece, which allows for flexibility to notify intermediaries of, say, mirror websites or aliases or copycats, which of course means that the pirate operator's circumvention is thwarted. And the effect of site blocking, here I would draw out two things. It reduces traffic to pirate websites, but it also is effective in actually increasing legal consumption and driving traffic to legal offer. So this is really a very good tool. So then when we are talking about rolling out dynamic site blocking injunctions more broadly, we advocate for best practices in doing that. And we set them out under sort of 4 pillars. We talk about precise targeting, having a legal framework for dynamic blocking, particularly when we use automated tools to notify intermediaries of new locations, a framework for balancing fundamental rights, due process and transparency, and safeguards. And let me talk to you a little bit about each of these. When we talk about precise targeting, this is really, I think, a cornerstone of site blocking. The orders should be available for structurally infringing services. So those that have as their primary purpose or primary effect large-scale infringement or facilitation of copyright infringement. We think that the measures should be tailored to the infringement. And by and large, sunset periods are a sort of good means of making sure that nothing is blocked for a longer period than it should be blocked. And we then come to dynamic blocking, of course, specifically. And as I sort of mentioned, pirate operators tend to be technologically savvy, I would say. So they evade or circumvent site blocking orders by switching domain names and IP addresses. They can do that very quickly, particularly also in the context of live. So that's why many countries have adopted dynamic blocking frameworks, operating with the streamlined procedures so that these blocks can be updated without the need to go to either the court or administrative authority again, and can just feed mirror websites back to the intermediaries. And here we have a sort of map of the countries that have site blocking globally. And in light green, we have the jurisdictions which provide for dynamic site blocking, most recently updated to include Greece, of course. Now, site blocking, of course, has the potential to implicate fundamental rights. That includes both of users and of intermediaries, the businesses. Obviously, the Court of Justice has issued a number of judgments talking about how to balance that. We think that a number of principles are important in ensuring respect and balancing of fundamental rights. The first one starting with the very first principle. This needs to be very strictly targeted to structurally infringing websites. We think that it's really important that that best efforts are made to notify the operators of the sites. And we think it's really important that intermediaries have a reasonable level of flexibility in choosing the measures that they use to block. We also talk a lot about transparency and due process. When a site is blocked and a user arrives at that site, we think it's very important that there's an explanation for the user. And I will actually show you the next slide here. An explanation, that's a few examples from around the world. An explanation for the users for that the site has been blocked, that it's done pursuant to a court order, perhaps linking to the court order, and also in the absolute best case scenario, providing alternatives to the legal offer. And then, so just go back one slide, just also flagging that, of course, the order should be publicly available, and that there should be routes to appealing these orders. Here we talk about automated tools. So dynamic injunctions are often work on the basis of automated tools, so finding a way for right holders to communicate directly to intermediaries. Greece is one of the countries in which this is possible. That, of course, implies a pretty significant level of speed. And here, of course, additional safeguards are needed. Obviously, due process from the beginning and fundamental rights balancing. We think that when these automated types of tools are used, there should be a sort of trusted flagger status for the rights holders that are guaranteed access to these tools. So obviously, as a sort of baseline, making sure that these are genuine rights holders, but also making sure that they are have a good track record in terms of rights enforcement. And if these tools aren't functioning well, or if it is the case that a rights holder isn't providing proper notifications pursuant to these automated tools, we would also always advocate for some form of temporary ability to revoke credentials or access to the tools, so what we would call a cool-down period, if a rights holder is unable to meet the quality standards after having been granted access to these types of automated systems. So with that, I'm going to wrap up, hopefully on time, to just sort of draw out the key messages from me today, which is site blocking is an effective tool. It's important to combat piracy on a global scale. We think that there's a way of balancing rights of third parties, including intermediaries and users, and the effectiveness of the tool. And we think these types of best practices that I mentioned today are the key to that. And overall, we also think that cooperation between intermediaries and rights holders is key to making this a success. Thank you very much.
Thank you very much, Saniva. Now the conclusions. You can draw your own conclusions from this conference. I hope it was interesting, and I hope that it was thought-provoking. Thank you very much for all the people that you still stayed here, and thank you that you have actually devoted your time your valuable time to celebrate with us to this scientific, let's say, scientific γιορτή, celebration. Thank you. So thank you. A big applause again for everybody of you that you are still. Thank you. Two last notes. I want all the people from the Hellenic Copyright Organization here to take a photo. And afterwards, the speakers will follow Maria with the white dress, the speakers and the chairs of the panels to do our program. Thank you again, everybody, for being here.